Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's stream, we turn our attention to Alex Murdaugh hearing for a new trial. Alex Murdaugh was convicted of double murders related to his wife and child at their home in Moselle at South Carolina. There's been suggestion from at least one juror that the clerk of court interfered with the jury, and this might be a problem. So a former Chief Justice of the state Supreme Court has been appointed by the Supreme Court to conduct this hearing on the question. So we're going to hear some testimony from the jurors, who are now witnesses, as to what the clerk of court did or did not do, and the degree to which it did or did not interfere with their decision. So we're obviously quite a bit behind because we've been covering other stories today, but we're going to watch this from the beginning in live. So we're 6.5 hours behind, but that's okay. We're going to do what we can, and we'll see what we got. So let's go ahead and get started.
Rise.
Good morning. Please be seated.
Thank you, Susan, for becoming a member. We do appreciate it.
Ladies and gentlemen, and I now address these remarks to the members of the press. You have not been completely in accord with what I asked you to do last Friday, but you've all done me the great favor of obeying what I asked you to do with respect to the identity of the jurors, and I thank you very much for that. The first order of business after I give some preliminary remarks will be the examination one by one of the jurors. And what will happen is I will bring all of the jurors in to begin with, and they will be seated. I will make remarks to the entire panel. I will then ask that the jury be taken to their jury room, and I will one by one call the jurors and address them, and I will address them by a letter that I have developed rather than their number. Now, I realize full well that many of you who attended this trial for many, many weeks probably know these jurors, and I'm not making any further statement about what you do or don't do in terms of identifying the jurors, but I don't want any photographs taken of the jurors by the media. With respect to the rest of the audience, if you have devices, cell phones, iPads, or anything of that nature, please silence them. Please do not use them. The press is allowed to use their devices in order to make notes, but the press is not making any photographs either. I have a pool photographer as well as a pool court TV arrangement, and that's what will be used to photograph, and those materials will of course be fed and available to the press. I think if there's anything else. All right. All right, the jurors are in place in the jury room, Mr. Bailiff?
Yes, Your Honor.
Very good. Bring me the jurors.
If you please report, Your Honor, prior to bringing that juror in, that have something on the record.
Sure. Hold for a minute. Yes, sir.
Your Honor, you have a list of questions you've distributed to us, and
yes, sir.
Of course you went through those with juror
Z. Or X.
X. I knew it was one of those
Yeah.
last letters. Juror X. The third question you say, did you hear Ms. Becky Hill make any comments about the merits of this case before your verdict?
Yes, sir.
And clearly the juror didn't understand what the word merits meant.
I disagree with that, but you may make your record about that. I think the juror understood what was being asked, and frankly, in some of the materials that we exchanged back and forth about questions, you yourself have used the word merit. So I don't think she was confused.
Well, Your Honor, occasionally I make a mistake. I think in this case, perhaps you've made a mistake, and if you would just respectfully use the words, did make any comment about the case before your verdict. Just leaves out their judgment about merits. They don't know, merits is a legal word.
I will take what you say into account, but I have already examined one juror using that term, and you now say that that term confused the juror. You have that on the record, and certainly would be able to argue that to any of the appellate courts that review what I do here, but my intention is to use the language that I used with the juror I've already interviewed.
But, Your Honor, you went and did a follow-up question, our request, which elaborated on what that meant. And certainly, after you asked that question, we think that clarified it, and you could use merits or anything else about the case and deal with both issues. I just think it's going to require us, based on statements that these jurors have given to SWED, to ask very specific questions.
Okay, I understand what you're asking. Let me ask you this, Mr. Harpootlian. Do you happen to have the transcript of Friday's proceedings?
Uh-oh.
I don't think so.
State, do you all happen to have a transcript of Friday's proceedings?
Your Honor, we're looking right now.
All right, belay that. I've got a copy. Let me look at it for a minute to see what I did in clarification, and so just pause for a minute. Let me look at that.
Do you have a copy? No. Do you have a copy? No. That's okay. I have a copy. Lol. So we'd like to object to the question, and we want to use their clarifications to modify the question. Okay, let's see where that goes. The Low Country is a beautiful place, man. I lived in the Low Country of South Carolina for a while, man. It is beautiful. I lived in Beaufort for a while. Really beautiful. I grew up in Columbia. Went to school at Clemson, lived in Beaufort for a while, lived in different parts of the state. South Carolina's a cool state. Recommended. I don't know if it's still true, but at least at one point Charleston had the lowest gas prices in the country. So that's nice.
I look at this transcript, and the only thing I note.
Wait, there's
Hang on.
Okay.
The lowest country sure is Holland. Ha 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 ha.
Okay, all right. I said this. I asked the attorneys for any further commentary about the questions I asked, and I have been asked to ask one more question, and I'm going to do that. I'm going to read you a memorandum by the state to counsel for the defense, and then ask you about it. All right? And then here's what I read. Per Chief Attorney Waters, please be advised that the attorney for Juror X has told us that his client says that prior to the defendant's testimony, his client did hear Clerk Hill say words to the effect of, quote, looks like the defendant is going to testify, this is an important day, close quote. Or, quote, this is an epic day, close quote. And that there was some statement that it was rare for a defendant to testify. And then I said,
I do like the South Carolina barbecue. I'm a mustard fan.
Something you heard.
I definitely am team mustard when it comes to my barbecue. It's what I grew up with.
And she says, yes, ma'am. Very good. Do these statements have any impact on your verdict? No, ma'am. Very good. I will ask that question. I didn't change well, I've read you what I asked. I will be glad to do that again.
Your Honor, different jurors say different things based on the memorandums we've received.
I won't say you told your attorney or anything like that, but I will ask about that statement having been made.
Your Honor, just for the record, we believe the term merits is a term of art, just as if you asked them was there probable cause. Again, or anything else, we're not asking you to open Pandora's box.
I hear what you say, and I will take it into account.
Okay, thank you, Your Honor.
Mr. Waters, anything on your behalf?
I do not have anything further, Your Honor. We believe the term is self-explanatory.
Thank you, sir.
Yep, Waters knew to sit the fuck down because he knew he won. Good on Waters, right? He knew to sit the fuck down because he knew he won. Like, yeah, we got nothing. We're good. Yeah, good on you. Good on you. Stop talking when you've won. That's a good clue. Not a lot of... Some attorneys can't do that. They can't stop talking even when they win.
Just so you know, Mr. Harpootlian, I'll have to go to my screen to do this other, but I will, the third question will read, did you hear Ms. Becky Hill make any comment about this case before the verdict?
Yes, Your Honor.
Okay, that's what I'll ask. All right.
So now
Right,
Dick
Mr. Bailey,
won.
bring me the jury.
Harpootlian won. Okay. So yeah, Walters thought he won, and apparently Dick Harpootlian won. Okay.
Yes.
Murdaugh looks surprisingly good for a man who's spent some quality time in prison. He looks scared? I don't know about that.
Essentially the way
It's the same thing except without,
yeah.
basically.
I want Kurt to be a judge. I kind of want Kurt to be a judge too. I think I'd make a good one. Even if I have fights with the Court of Appeals. Could be hilarious.
Good morning, ladies and gentlemen of the State versus Murdaugh jury. I wanted to make a few opening remarks to you before I question each of you about the matter. You have done absolutely nothing wrong. None of you, not any of you. You didn't ask to serve, but you served and did your duty. This was an unusually difficult trial because of its length. 6 weeks is almost unheard of in South Carolina as the length of a case. It was difficult because of the intense publicity and public interest in the case. It was difficult because of the complexity of testimony and exhibits in the case. And you acquitted yourself honorably. So this question today is not about anything you did wrong. Please be assured of that. I respect you and I respect your service. Today, I'm going to ask you to do something that's difficult. This case is unique. Most of the time, if there's some issue about improper conduct or contact with a juror, it comes up immediately. The judge puts questions to the juror and perhaps to the person who may have made a improper comment, and then you go on with, to verdict. Or sometimes it's very shortly after the verdict is rendered. And again, the judge questions the affected jurors and the supposed interference and makes a ruling right then and there on either a new trial or a mistrial. Now here, we are almost a year after your beginning of service on this case. And that makes it mighty difficult for you to do something I'm going to ask you to do, and it's this. Today, I ask you to focus your attention What is that? Mr. Bailiff, what is that noise?
I'm not sure.
Is that the sound system doing
I
that?
believe it's the court sound system.
This is the funkiest sound system in the world, so you just have to keep up with it. I've had trouble in every case I've ever tried with the sound system. So, jurors, if something happens and the sound system goes haywire, we'll stop for a minute until it stops. Now, as I was saying, I want you to focus your attention as you answer the questions I'm going to ask you on your 6 weeks of experience as a juror in this case, and on the point in the trial where the judge charged you, and on your verdict as you rendered it on March the 2nd, 2023. That's what I want the focus to be. And again, I know I'm asking a lot to have you cast yourself back into that time, but that's what the questions I'm asking are about that time and not about this time. There has been so much drama about this matter since the verdict was rendered, and my heart goes out to everyone, the lawyers and you who are in this trial. That I can't help. But I've been asked by the Supreme Court to take a look at this issue. The appeal is on pause until I do, and I've got to do my duty as I see it. And you do yours as I know you see it. So I thank you very much in advance for, again, the terrible inconvenience of calling you all back together now. But it's very essential to completing the record about this case and placing it before the appellate authorities as it needs to be. So in advance, I thank you. What I'm going to do now is dismiss you to the jury room, and one by one, I will call you, and I will refer to you by a letter that I have just assigned you that isn't your jury number and certainly isn't your name. You know, these people in the media saw y'all all through the trial. They probably know who you are. But I'm trying to do my duty as I see it when I make your appearance here anonymous to the record. And only the court reporter will have a sealed document by me indicating what the key means in terms of your juror number and your name. So I'm doing everything I can do about this matter. But it goes without saying that your business is your own business. You don't have to interview with a soul, not lawyers, not media, not anyone after this matter. That choice is purely yours. And I will respect that and protect that to the best I can if anything comes up afterwards. All right, you may go to the jury room.
Hopefully other jurors don't watch proceedings on their phone while they're in there. Surely that wouldn't happen, Tony. Surely that's not a thing that would be allowed to occur, right? Because we're ringing them one at a time so they didn't influence each other. Surely the other jurors wouldn't watch the testimony on their phone, would they? Would they? Yeah.
All right, Mr. Bailiff, bring me Juror Z.
One other matter.
Yes, sir.
One of the individuals sitting in the jury box has called this, the next jury, liar publicly. I'd ask that that'd be Mr. Bland and his partner, cohort, not sit behind her or near her while she's testifying.
I object.
Well, just a minute.
Your Honor, I object to him speaking.
One moment. We're not going to have a big colloquy about this. You keep your seat for a moment, Mr. Harpoot.
Yes, Your Honor.
Mr. Bland, you do the same. Mr. Bender, is there a seat over next to you?
There is.
Mr. Bland, will you go over and sit next to Mr. Bender, please? Thank you.
Thank you, Your Honor.
Problem solved. Right? We're not going to have a discussion about this.
For the record, I have some people in the jury box. Two of them are SLED agents. One of them is the media consultant, and one of them is attorney for several of the jurors, Mr. Bland. And that's being done at my direction.
Hey, Justice, told you have Scott Mongillo, Blaine Richter, also in the jury box.
Very good. Yes, sir. That's fine. All right.
Yeah, the judge is like, yeah, I'm just going to do this. We're not having a discussion. I like that. Control of your courtroom. I was just like, fuck it, fine. It's like, we're not having a discussion about this. Like, everyone's objecting. Like, judges, like, we're not having a discussion. This is what's happening now. I appreciate that. It's like, I'm just going to avoid the issue and grant it because it's easy for me. And like, I appreciate that. I mean, you know, we don't want anyone who called one of the jurors in there. That might improperly influence the juror. That might be bad, right? Just as surely as if we allowed the jurors to see video of this testimony while it's happening. That would also be bad. The judge is a woman. First woman Chief Justice of the South Carolina Supreme Court.
Juror Z, you may take the witness box after you are sworn. Step over here to the clerk and she will administer the oath.
You can address her as Chief Justice if you would be so kind.
Do you swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Please have a seat.
Juror Z, I will ask you some questions, and there are no right or wrong answers. The truth is what I seek, and that is the truth of what you experienced in relation to these questions at the State versus Murdaugh trial. You rendered a verdict on March the 2nd, 2023. That verdict was read in open court by the foreperson of the jury. And then the court said this: Madam Forelady and members of the jury, if that is your verdict of each and every juror, let it be known by raising your hand. The transcript then indicates that the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate statement about your verdict at that time?
Yes, ma'am.
All right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
If yes, what did Ms. Hill say?
To watch his actions.
To watch his actions. What else?
To watch him closely.
To watch him closely. Anything else you remember?
There it is, but I can't remember.
Okay, that's fine. Was your verdict on March the 2nd, 2023 in any way with any influenced in any way with any communications by the clerk of court, Becky Hill, in this case? Want me to
Yes,
read it
ma'am.
again?
Yes, please.
All right. Was your verdict influenced in any way by the communications of the clerk of court in this case?
Yes, ma'am.
And how was it influenced?
To me, it felt like she made it seem like he was already guilty.
All right. And I understand that. That's the tenor of the remarks she made. Did that affect your finding of guilty in this case?
Yes, ma'am.
All right. Be at ease. Those are my questions are submitted to the juror. Are there any reactions, further questions, and so forth? If there are, and you would like to voice them, I can ask the juror to retire to the jury room. Just tell me whether I need to do that. All right, sir.
We need to put some things on the record.
All right. Take the juror to the jury room, please. Yeah, that's fine. Mr. Ward.
Your Honor, in the
There we go.
affidavit that was given by this particular juror, paragraph 10 said,
What I was saying while I was muted is that Dick Harpootlian should not be asking to be putting things on the record. That's what I was saying when I was muted. And the fact I was muted was due to a hardware error that I was not aware of. But anyways, I was like, yeah, you don't want to put things on the record. You won. You got all the things you want. The juror said, yes, I was influenced. That's game over, man. That's game over. You won. And Dick Harpootlian's like, I want to put things on the record. No, you don't. You absolutely don't. You won. You want to, it's like game over. Game over. You win. And Dick Harpootlian's like, I want to put things on the record. No, you really don't. You won. Please stop talking. Yeah, why not? Because you won. Why talk when you've won? It's game over. You won. You just won. Did they talk to you? Yes. Did it influence your verdict? Yes. You've won. Stop talking. Game over. You've won. Why would you want to put anything on the record? You've won. Game over. Please stop talking. Verdict in 10 minutes. Our judge is ruling in 15. All right. Well, we might skip to the end of the day. I don't know. Should we skip to the end of the day and see how it all panned out? I mean,
questions about Mr. Murdaugh's guilt, but I vote guilty because I felt pressured by the other jurors.
What could he do to lose it now? I don't even know, and I don't want to find out. That's the thing. When you've won, stop talking. I don't want to know what he could do to lose it now. I don't want to have to ask that question. What could he do? I don't know. I'm sure he could do something. Stop talking. It's just a classic rule of sales. When you've made the sale, stop talking. Just stop talking. When you've made the sale, stop talking. You've won. Stop talking. Yeah.
Request an inquiry as to that, which is how, when this motion was filed, she expressed the basis for her verdict, which obviously this answer is a little different now. So we would request a brief inquiry from the court as to that specific issue.
All right.
Thank you, Your Honor.
Mr. Harpootlian?
Your Honor, as to two things. The first thing is, he is correct. She gave an affidavit. We would ask Your Honor to let her read her affidavit.
No.
Refresh her memory.
No.
She said other things. They're very detailed in here.
Absolutely not. You've won.
And let me hand up to the court.
Absolutely not. Why are you doing this? No.
Affidavit. And ask you to.
Why are you doing this? You've already won. You've won everything. She said, yes, they talked to me. Yes, it influenced me. Yes, it impacted my verdict. Why are you doing this? Why are you asking them to comment about things in their affidavit? You've won.
Mr. Waters?
You've won.
What I've been handed for the record is something now referred to as Z.
Oh my God.
Taken August the 14th, 2023. It was sworn before Holly Miller, paralegal for Mr. Harpootlian. and he would like for me to give that to.
No, why are you trying to refresh her recollection? Why are you trying to refresh her recollection? You've won.
But I want to hear from you first.
Why would you do that?
Again, if they want to refresh the recollection, that's fine with the state.
I bet it is. I bet it is fine with the state. I bet it is fine with the state. Because all the state can do is recover. So every additional word she says can only help the state at this point. It is game over. The defense has won. Everyone pack it up. Let's go home. So of course the state wants it read into the record because it literally can't get any worse. You've already lost. So of course you want her to keep talking because it can only get better. Maybe if she keeps talking, maybe I can get a different answer. The fact that Dick Harpootlian wants to do, of course the state wants it read into the record. Of course he does. Why wouldn't he? He's already done. He's already lost. If she keeps talking, maybe he can somehow win. Oh my God, Dick Harpootlian is an idiot.
So we have no objection to that.
Very good. It will be done.
Your Honor, also we would ask that you not ask the question that that Mr. Waters asked you to ask because it violates Rule 606B, which provides upon an inquiry into the validity of a verdict or indictment, a juror may not testify to the effect of anything upon that.
Why are you doing this? You've won.
The question he asked.
You've won.
If you look at that affidavit,
It's paragraph 10, Your Honor.
Paragraph 10.
It's in the very affidavit.
she said she was influenced by other jurors.
Yeah,
Okay.
I'm gonna ask her about that.
You've won.
Affidavit, and then I'm gonna
What are you doing?
And we would, for the record, indicate that we object to that under 606B.
Your Honor, from our perspective, she's put an
And
issue.
you're the one that asked me to have her look at this affidavit, but you telling me I can't question about it? I deny that objection.
Your Honor, if it's something that's inadmissible, you should not ask her about it. And that's
Well, you want me
inadmissible.
to admit it and have her examined
No, I
on it.
want you to have her read it to refresh her memory.
We're quibbling, Mr. Harpootlian, we're quibbling about things that I'm not going to take time to quibble about. My ruling is pursuant to your request, I am going to allow the juror to examine her affidavit, and then I'm going to question her about it. That's my ruling. Your objection is overruled.
Oh my God. The judge is right. The judge is right. Oh my holy God. Dick Harpootlian, why? Oh my God, why? The judge is right. You asked me to do this. You asked me to have this admitted. You asked me to have them read it. But then you don't want me to ask questions about it. No. Oh my God. Why, Dick Harpootlian? Why did you do this? Why did you do this? Oh no. No.
For the record, I just want to note, Your Honor, just for the record.
You noted 606. I hear you noted.
And in no way waiving anything or opening any door by asking you to let her examine.
That's your perception, that you didn't waive anything or open any door. Oh my God. Oh my God.
But a higher court than me to decide.
Well, I understand that, and that's why I want to make sure when they read this transcript, there's no confusion. I'm not asking you to put that into evidence.
The Court of Appeals is not. Yes, you are. You literally asked for her to read it. It of course is in evidence. How can it not be in evidence? She can't read from it if it's not in evidence. What are you doing? Oh my God.
I'm asking you to
Well,
let
I don't
the
see
jury
how in the world I can question the juror about something and not put it into evidence. You can't have your cake and eat it too, Mr. Harpootlian. You could have been very satisfied with the answers that were already given, but you have chosen to ask about this.
Withdraw the request.
Denied.
I moved to withdraw my request. Denied. Oh fuck. Oh fuck. Oh my God. I moved to withdraw my request. Denied. Oh fuck. Oh my God. Oh my God. Dude. No. Yeah, I'd like to have this happen. Okay. Here's what's going to happen now. Okay, I withdraw my request. No. Kill me. Kill me. Kill me. Kill me. Yeah, this would be roughly equivalent to like having the ref review the play. And like upon further reconsideration, we actually see another penalty against you. I'd like to withdraw my request to review the play. No. I'm sorry it didn't work out for you, that we found another penalty to give you. Yeah, well, this is the penalty we ruled on the field, but actually, upon further consideration, there's a new penalty and a new exciting penalty. Oh, we'd like to withdraw our request to review the play. No. Oh, what a colossal fuck up. What an absolute total colossal fuck up. He had it won. He had it in the bag. It was in the bag. He won. He won. And then he's like, I'd like to make a record by having her review this thing. Oh my God. Oh my God. Oh my holy Lord. Oh my God. Oh my God. I don't even know what to do. I don't even know what to say. What are we, 5 minutes into this hearing and my mind is already blown completely apart? Holy shit. I don't even know what it is. It would be like, yeah, it would literally be like, you get into the end zone and they call it a touchdown for you. And you decide to ask the refs to review the play. You decide to ask the refs to review the play. That's basically what just happened. So you score a touchdown. The refs call it a touchdown. And you ask the refs to review the play. And they're like, upon further reconsideration, it's not a touchdown at all. Okay, then I'd like to request my review be withdrawn. How about no? How about, oh my God. It's hard to even give analogies for what this is. Like, you had won. You had won. The jury gave every answer that you wanted. You won. You won. Game over. Game over. You won. You won. Yeah, it's a challenge flag on your own touchdown. That's exactly what it is. It's a challenge flag on your own touchdown. You won. No time left on the clock. Game-winning touchdown. The refs call it in your favor. Game over. And you're throwing a challenge flag. You're throwing the challenge flag. And basically, at this point, not only is it not a touchdown, but upon further review of the play, we found a 15-yard penalty against you. Oh my God. Oh my God. Is Murdaugh gonna strangle Poot? He should. He should strangle Poot because... Move the video forward, we get it? Oh my God. Okay, fine. We're moving the video forward because we get it, apparently. All right.
Your Honor, all the time we ask witnesses to examine a prior statement.
Mr. Harpoon, I made my ruling. Please take your seat. All right. Bring me Juror Z.
Oh, what a fucking clown.
Get me another copy.
It's in here.
Yeah.
It's in here.
Yeah, sit down, you fucking idiot. Sit down. Oh my God. You're out of here, what a rant? Okay. Bye. Thanks for dropping by. Apparently I'm not allowed to rant on my own channel. Apparently that's not allowed. Okay, noted. You won the case. Game over. You should have been objecting to any new questions by the state. That's what you should have been doing. Yeah, I'd like to ask these questions. No, I don't think so, Your Honor. We've got everything we need. The jury admitted they're interfered with, and they only want to challenge it because they didn't get the right answer. And, you know, you were very clear in your questions. There's no need for further questions, Your Honor. I object to any new questions by the state.
Now,
Kill me.
You gave an affidavit to a representative of Mr. Harpootlian on August the 14th, 2023. And I have this in my hand at the present time. And I'm going to hand it to you. And I'm going to ask that you read it. Tell me when you completed reading it. And then I'm going to ask you some questions. You're going to see 4 little boxes on this affidavit. They are your name and the names of 2 of the jurors. I will strike that out before it appears in the record, just so you understand.
What are the odds they intentionally messed up? 0. Yeah. When you take a drug test and your test comes back clean and you say, are you sure there's no cocaine in it? Yeah.
Take a moment to read this and tell me when you...
Basically.
Yes, ma'am.
This is a pile of stupid. I feel like we have to skip ahead to the verdict, though. So where are we at this thing? We're like, we can pause this, and maybe we can open a new tab with like the decision, because I gotta know where this shit. I can't. I mean, you guys are obviously going to tell me. You guys are going to spoil it, so you know, I might as well skip to the end. Why did the judge strike out the names? Because it wasn't the journalist names; it was the jurors' names that she struck out because she wants to keep it anonymous. So fair enough. As much as she can, within her power, she wants it to be anonymous. I mean, we know their names and everything, but she still wants to do it for the record. So, you know, fair enough. Yeah, would you test for Q2? Yeah, it's like, are you sure I tested clean? Really? No, that's a surprise. Are you sure you didn't test for this? Oh my God. Yeah, one juror being affected is enough. That's what I said. It is an absolute game over. He won. He won. It is an absolute game over victory. That's everything you needed. Yes, she talked to me. Yes, it influenced my verdict. One juror says it, you're done. You win. You win. You should be doing everything in your power to prevent the state from asking new questions. And then you should be asking, okay, Your Honor, well, one of the jurors said we're interfered with, so we're done here. So we don't need to ask any of the jurors any more questions. So we can all go home now. That's what you should have done. Oh my God.
All rise.
This'll better be fucking good.
Please be seated.
We're live now, by the way. For those of you who are catching up, we're live with apparently a decision on this thing. I bet she's pissed. Given the things I've heard in this trial, I bet she's pissed. Or this hearing, I should say. It's not a trial. Are we going to go back?
In the matter of the state of South Carolina against Richard Alexander Murdaugh. 2022 GS 1500592, 593, 594, and 595. The following constitutes my ruling on this matter from the bench. This order will be supplemented, as I will explain, after proposed formal orders are received from each side in this matter. This case is unique in my 20 years of experience as a lawyer and my 35 years of experience as an active justice of the Supreme Court and a senior active trial and appellate judge. Usually matters involving possible improper contact with or conduct of a juror arise during or shortly after the trial. The judge then puts the affected juror or jurors under oath, conducts an examination, and rules on the request for a new trial or a mistrial. In this case, I was appointed almost 9 months after the trial to replace the trial judge who was recused. It is now almost 10 months after the verdict was rendered and sentence imposed in this matter. It is now on appeal to the Court of Appeals. Several months after the appeal was filed, the defendant moved that his appeal be suspended and this matter be remanded to the trial court to consider his motion for a new trial on a charge that the clerk of court for Colleton County tampered with the jury by expressing her opinion to the jurors about what their verdict should be and about the credibility of the defendant who had elected to take the stand and testify on his own behalf. Since this matter has been remanded to me, I have set the matter for a pretrial and a final hearing, conducted a telephonic status conference with the attorneys for the parties on December the 21st, 2023. I have received briefs from the parties. I conducted a pretrial proceeding on January the 16th, 2024, in which I invited briefs and arguments by the parties and by the attorneys for certain of the jurors and for the clerk of court, Rebecca Hill. On Friday, January the 26th, 2024, I conducted a hearing on this matter in which I took testimony from one of the jurors. The conduct of the examination conducted solely by me. I received further argument from the attorneys for the state and for the defendant. Today, January the 29th, 2024, I have taken sworn testimony from the remaining 11 jurors who rendered a verdict in this case. This examination was conducted solely by me. I have found no case that provides otherwise in the many cases I have read on the subject of a motion for a new trial on the basis of after discovered evidence of jury tampering or misconduct. I have also received sworn testimony from the clerk of court, Rebecca Hill. Direct examination was conducted by Deputy Attorney General Creighton Waters. Cross-examination was conducted by Defendant Attorney Richard Harpootlian. I have also propounded questions myself to the clerk of court. I also received testimony from the clerk of court for Barnwell County, Rhonda McElveen, who attended most of the trial and assisted the clerk of court for Colleton County. I've also received testimony from the remaining alternate juror who was, when the matter was deliberated, dismissed from further service. The following is my ruling on the defendant's motion. The standard of proof. The state contends that in order to prevail, the defendant must show, 1, that the clerk of court made an improper comment or propounded an improper question to the member of the jury, to a member of the jury who rendered the verdict. 2, defendant must further show that Ms. Hill's improper comment or question actually influenced the juror's verdict, citing State v. Green, State v. Aldrett, and other opinions of our Supreme Court and other authorities. Defendant contends that he must show only that an improper question or comment was propounded to any juror by Clerk of Court Hill. If so proved, the defendant contends that the motion for the new trial must be granted. Defendant relies on United States v. Rimmer and many other cases. My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the Clerk of Court, Rebecca Hill, to a juror or jurors, and 2, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influenced the juror to vote to convict defendant Murdaugh. The facts. Did Clerk of Court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the Clerk of Court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the Clerk of Court, Ronda Milsap, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did Clerk of Court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations.
Oh my God.
But the juror, who was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath.
Azeroth, there is a legal system. Time out, Azeroth, please.
The court allowed public attention of the moment to overcome.
In fact, just ban Azeroth. I'm tired of him. I can't deal with him anymore.
I have read the entire transcript of this lengthy trial. Not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited on the record before me as a trial judge, and the authorities that have been cited by all parties in this matter. To that end, I will hold the record open. I direct that within 4 business days of receipt by the attorneys in this matter of a transcript of these proceedings, a proposed order by the state denying the defendant's motion for a new trial with citations be sent to me and to opposing counsel. I will allow the defendant 4 business days from receipt of the state's proposed order to lodge objections and or submit an alternative proposed order. Upon receipt by the court of all proposed orders, I will finalize this record, submit a written order, and I will at that time transmit the written order to the Court of Appeals, the court which has remanded this matter to me. This hearing is adjourned.
Thank you, Your Honor.
Thank you. Let me say this, and I should have said it before I began my order. Hey, order. Members of the audience, would you just be patient with me for one more minute? Please keep your seats. I have probably had more experience with trial and appellate work than anyone else in this room for many years, and it has been an absolute pleasure to receive from these learned lawyers some of the best briefs I've ever received. I know they're a product not just of the attorneys who presented to me, but of the attorneys who sit with them.
This is absolutely Dick Harpootlian's fault. He fucked it up so hard.
And the writings that I received.
Oh my God.
I know that I put you on a very tight timeline, but my feeling is these matters are best disposed of by the trial judge in a very timely manner, so that you may then go to the authorities that really count more than I do. That is,
Dick Harpootlian fucked this up. Dick Harpootlian fucked this up. Oh my God, he fucked it up. Oh my God.
Our appellate judges have seen a case such as this before, and they will take a lengthy time to study the record in this matter, the record in the part remanded to me. There are many issues in this case, issues over which I have absolutely no authority whatsoever. But I will say this about the record now that I have read it, and I will say this about the testimony that I heard Friday and today. Judge Newman said it best in his sentencing when he discussed the weight and the measure of the case presented and testimony and evidence submitted in this case when it was tried. It is a very compelling case supporting the verdict that the jurors reached. He said it with a lot more detail than I do, but now that I've read the record, I say as the successor trial judge, I agree that the evidence was overwhelming and the jury verdict not surprising. This matter is now adjourned.
What an absolute colossal fuck up from Dick Harpootlian. Oh my holy God. What an absolute colossal fuck up. Dude. Dick knows it too, probably. He fucked up so hard. Oh, wow. It's like it's hard to even know where to start on that one. All right. So, all right. So, 11 jurors, apparently 11 jurors say, we weren't influenced by this, which the judge says under State v. Green is required. So she says, okay, the South Carolina Supreme Court says I need 2 things, both that the clerk of court did this thing and it also influenced their verdict. Okay. So we broadly agree that the clerk of court interfered with the jury. All right. No one seems to contest that. Right. And she's like, also, Becky Hill's not credible. And she did these things and she won reputation and all the rest of it. He knew it when he tried to retract it. Yeah, he knew it. And when the moment he tried to retract it. This judge is a woman. Why do people keep asking? It's very rude. This judge is a woman. Anyways. So the first juror they had gave all the right answers. For Dick, he gave all the right answers. The judge even asked her twice, were you interfered with, right? She even asked her twice because she said yes the first time. And then the judge is like, let me make sure I ask this question again, just to make sure. And you gave the answer twice. Yes, it influenced my verdict. You were done. You were absolutely done. You were absolutely completely done because that was the right answer for Dick Harpootlian, right? You have everything. Yes, the jury. Yes, here's what she said. Here's what she said. Here, she said these things. Did it influence your verdict? It sure did. Are you sure it influenced your verdict? Quite sure. Thank you, Your Honor. All right. So Dick Harpootlian has won. He has won. He has got everything he needs. He only needs one juror. He only needs one juror, and he's got it. He's got the one he needs. Game over. Game over. He wins. Then Dick Harpootlian decides, for some reason that defies all possible understanding, he's like, I'd like to make a record. And I even said, no, you don't. You absolutely don't want to make a record. You absolutely do not want to make a record. Sit your face down. And your guys are like, why doesn't he want to make a record? Why doesn't he want to make a record, Kurt? It's like, because I know exactly what's about to happen. It can only get worse. It can only get worse. You've won. Sit down, shut up. You've won. But Dick Harpootlian's all over here like, I'd like to make a record. I'd like the witness to be able to be asked about this affidavit. I'd like to have the recollection of the juror refreshed by this affidavit. And the state, of course, is like, we have absolutely no problem with this because the state has already lost. The state has lost. It is over. It is over. It is over. It is over. So the state, of course, has no objection to the juror reading this affidavit because there's no way it can get any worse. Right? There's no way it can get any worse. Like, the whistle has been called, it's game over. And Dick Harpootlian's like, how about we don't blow the whistle? And so the state's like, sure, we're good with that. It can't possibly get any worse. And I'd like to have this introduced. And so the jury can reflect it. And so then the judge is like, okay, well, if you're going to introduce this thing, I'm going to ask some questions about it. And he's like, but no, I don't want this entered into evidence. I don't want you to answer any questions about it, asking any questions about it. But it's like, but you asked me to. You literally just asked me to just now to have her memory refreshed. Right? Why would you want me to do that unless you're going to ask me, what is the point of having the judge has got to be thinking this in their own head. The judge is like, what is the point of having the witness's recollection refreshed unless I'm then going to ask questions about it? Right? That's the only reason you have their recollection refreshed. Well, otherwise, why would you do it? It doesn't make any sense. You want the witness's memory refreshed by bringing this thing in. Okay. Well, then I'm going to ask questions about it because why would I just ask them to read that and have their memory refreshed and then be like, okay, we're good. That doesn't make any sense. So I'm going to ask questions about it. Well, we object to you asking questions under this rule of evidence, this rule of evidence, and this rule of evidence. But the judge is like, it's your idea. It was your idea. You want to bring this in. You want to bring this in. You can't object under the rules of evidence. You can't invite your own error. That doesn't make sense, right? You can't invite your own error. It's like, yeah, this shouldn't be admissible. This shouldn't be admissible for this reason, this reason, this reason. And the judge is saying to themselves, what the hell are you talking about? You can't admit it for this reason, this reason, this reason. You're the one offering it. You can't offer the exhibit and object to it at the same time. That is not even close to how this works. So all your objections are denied because of course they are, because it doesn't make any sense. And then Dick Harpootlian's like, okay, we move to withdraw our request. And the judge is like, denied. You asked me for this, you got it, and now you're going to get it hard. We move to withdrawal. No. And Dick Harpootlian's like, but Your Honor. And the judge just literally says, I've ruled, sit down. And Dick Harpootlian sits down with the saddest face he ever has. Oh, there's some post-commentary? What is this bullshit?
About the law, and the law's unsettled.
Does he want to say some things afterwards? We've got no audio on this.
Next level. Next, we go from here to the Court of Appeals.
Oh, we can definitely rewatch it. We'll definitely rewatch it.
Our southbound.
No, we'll see this moment where it all went horribly, horribly wrong. We got to rewatch this because it is absolutely a shit show. We got to rewatch it because I can't believe it happened. Why do we have no audio from this?
Explain to us how you found out this information.
Go ahead, Jim.
Well, we're glad you're being honest.
Is it just me? Can you guys hear it? I can't hear shit.
No, I mean, and we found out the information by talking to the jurors. You heard the alternate testify today, and honestly, that was really the first one-on-one interview that we
I can't hear shit. All right, let's listen. I can't hear anything.
Indications from lawyers who represented some other jurors that, you know,
He said we go from here to the Court of Appeals. No, you don't.
Go down this road, and when we finally met with her as she's cooking Sunday
I can't hear
dinner
anything.
in her home down a dirt road. I mean, she told
I
us
got no
things
audio
we
output. That's great. Well, you guys can hear it. I can't hear it. That's
And
nice.
we rode down a lot of dirt roads in Carlton
Oh, there it is.
County on Sunday afternoons, knocking on people's doors.
All right, I'm going to roll back a little because I missed it.
Shoe weather is the way.
So let me just pause this so I can roll back because I didn't hear it. I want to hear this shit show thing from the beginning.
Next level. Next, we go from here to the Court of Appeals, and then to the Supreme Court if necessary, our southbound Supreme Court, and then federal court.
Sure you do.
I have to be honest with you, I didn't really believe the whole story with Becky Hill until today's testimony, and I have to tell you, it did sway me quite a bit, you know, because I didn't believe it.
I'm going to have to figure out how to make a click excerpt out of this because this is absolutely unbelievable.
No, I mean, and we found out the information by talking to the jurors. You heard the alternate testify today, and honestly, that was really the first one-on-one interview that we were able to get.
It's really quiet in my ear.
We had gotten some indications from
I can
lawyers
barely
who
hear it.
represented some other jurors that, you know, we needed to go down this road, and when we finally met with her as she's cooking Sunday dinner in her home down a dirt road. I mean, she told us things that were jaw-dropping, and so that's how we found out.
And we rode down a lot of dirt roads in Carlton County on Sunday afternoons.
Oh, it's the other earphone. That's why.
And that, you know, that's shoe weather is the way you work cases. I know, you
it's
know,
only in my one ear.
to
Thanks.
Social media and electronics, but you got to knock on a door and you got to ask questions, and that's what we did. And that's how we proved to Judge Toll that Becky Hill attempted to influence this jury. She said for the siren call of
publicity and money to sell a book. I mean,
right.
You know, we were, you know, denigrated, made fun of, chastised because in our initial filing, we pointed out that she had a profit motive for doing what she did. And guess what? Justice Toll ruled that was exactly the case today. So we feel vindicated on the facts. The law is unsettled, and early on, she acknowledged, and we all acknowledged, this was not going to be the final say-so on the law. That's going to be determined by the appellate courts, and that's the next step.
Dick, do you know how hard you fucked this up?
I mean, we did lose today. If we'd won today,
Dick, do you know how hard you fucked this up?
So no matter who wins today, it's just one step in the process. We would not have a trial next week or next month. It would all be wrapped up and gone up to the Court of Appeals and the Supreme Court.
Do you know how bad you fucked this up?
We're prepared for that.
But the good news is we agree, the court agrees.
That'd be my question. Question for Dick Harpootlian.
Becky Hill
Do you know how badly you fucked this up for your client?
Jurors, that she made these statements. With the facts resolved, the only issues.
Do you realize that?
And as Judge Toll said, that is unsettled. This is not, you know, it's going to go through the appellate courts, and we feel strongly that we'll win.
Thank you all.
Wait, one more question?
How important is it to get a different standard for the burden of proof?
I have a question for you. Hey, Dick Harpootlian, when you made that motion to have the juror see their statement, did you know at what point did you realize you had fucked up?
That we get a presumption based on our factual findings here. And so if we win that legal standard, I mean, on this record, we get a new trial. If we lose that legal standard in our state courts, then we probably don't get a new trial. But we go to federal court where there is no dispute in the Fourth Circuit where we would end up with what the standard is, and it is a standard of presumption. So it's either going to be decided, in my view, in our favor in our appellate courts, or 4 or 5 years down the road in the federal courts, unless there's a change of federal law.
How they fuck it up, I've explained it a couple times, but I've explained it 4 or 5 times how they fucked it up.
Yes, there would be. But I'm not going to tell you why.
Absolutely, yes.
It doesn't discourage you that Justice Toll at the end said she agreed with Judge Newman about the facts and the verdict and how it was, you know, that it was a compelling case and all of that.
No. She's not going to say, oh, I disagree with Judge Newman, the facts were very thin. No, she's not.
Yeah, there's an innocent man here who's wrongly
Right.
convicted.
And
We didn't expect her to say that. So.
But the appeals court could say it's harmless error, is my point.
No, they can't.
No.
They can't. This issue is not harmless error. Cannot be.
I've asked about this before. You all have said that you're investigating who might have actually committed these murders.
Yes.
Have you all found any?
Oh, I'll explain it again. We're going to go watch it again. We're going to go watch it again. We're going to go watch it again
And we'll be pursuing that.
and see exactly where he fucked it up.
Who really did it?
No, he's not getting a new trial. He fucked it up. Dick Harpootlian fucked it up.
Well, if he did, we couldn't tell you. That's called attorney-client privilege. I can't think.
South Carolina
about
courts
what
are
my
corrupt?
client could have told me. That would be attorney-client
Nope,
privilege.
that's not the problem.
Rules, they're so pesky.
That is not the problem.
You get credit. Okay. Thank you. Pardon me?
How did Alec react to that?
Fine.
Al, how did he respond? Yeah, I don't think so. Okay, we're going to go back and watch. Yeah, I don't think this is an issue of corruption. I don't think the judge did anything wrong. I think Dick Harpootlian fucked this up. That's what I think. You know, I think he fucked it up. All right, so we're going to go watch this again so we can all experience the pain together, where it all went horribly, horribly wrong. All right. Yeah, these two are bad as J Hatch. It's actually worse because J Hatch, I don't think, fucked it up. I mean, J Hatch was making ridiculous arguments, but they didn't self goal. You know, so this is worse than J Hatch. J Hatch's lawyers were making ridiculous, insane arguments, but they didn't self goal.
You know this.
All right, so let's see if we can find out where this thing happened.
Each juror.
All right.
Yeah, that's fine. Mr. Waters.
Yes, ma'am. Your Honor, in the affidavit that was given.
All right, now let's see, because I want to go back to where she started the questioning of this juror. This is how to lose your case in one easy step right here, guys.
Juror Z, you may take the witness box after you are sworn. Step over here to the clerk and she will administer the oath.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Please receive.
Okay. So bear in mind as we're about to start this, okay? For Murdaugh to win, he needs to prove 2 things, at least according to the judge. He needs to prove 2 things. It can be for any juror. Any juror. He needs to prove one of these. He needs to prove these 2 things are true with respect to any juror. He needs to prove 1, that the clerk of court interfered with the jury, and 2, that interference influenced their verdict. Okay? That is what he has to prove. The clerk of court interfered and the interference influenced the verdict. Okay? Those are the two things he has to prove. Now, the judge is going to ask all the questions, which is fine in a hearing. So let's see if the witness gives him all those things. All right?
Juror Z, I will ask you some questions, and there are no right or wrong answers. The truth is what I seek, and that is the truth of what you experienced in relation to these questions at the State versus Murdaugh trial. You rendered a verdict on March the 2nd, 2023. That verdict was read in open court by the foreperson of the jury. And then the court said this: Madam Forelady and members of the jury, if that is your verdict of each and every juror, let it be known by raising your hand. The transcript then indicates that the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate statement about your verdict at that time?
Yes, ma'am.
All right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
If yes, what did Ms. Hill say?
To watch his actions.
To watch his actions. What else?
To watch him closely.
To watch him closely. Anything else you remember?
There is, but I can't remember.
Okay, that's fine.
Okay, so we've proven the first thing we need to prove. The clerk of court interfered with the jury by talking to them about things in the case. Look at him closely, whatever. The clerk of court interfered with the jury, at least with this juror, which is enough. Okay, so did it matter? Did it influence you? Let's see how the juror answers that question.
Was your verdict on March the 2nd, 2023 in any way with any influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
Yes, ma'am. Yes, please.
All right. Was your verdict influenced in any way by the communications of the clerk of court in this case?
Yes, ma'am.
And how was it influenced?
To me, it felt like she made it seem like he was already guilty.
All right. And I understand that. That's the tenor of the remarks she made. Did that affect your finding of guilty in this case?
Yes, ma'am.
All right. Be at ease.
Okay. So we've satisfied both parts of the test, and the judge even clarified, and she still says yes. The witness just gave every answer the defense wants. Did the clerk of court say things to you? Yes. Did it influence your verdict? Yes. How did it influence your verdict? Well, it made it seem like she was convinced it was guilty. Well, I understand that. That was the tenor of the remarks. But did that fact influence your verdict? Yes, it did. So we've got everything, right? We've got everything. The clerk of court interfered, and it influenced the verdict. We've satisfied both parts of the test. Game over. Game over. Defense wins. Game over. Okay? All right, so let's see how it all goes horribly, horribly wrong.
Those are my questions are submitted to the juror. Are there any reactions, further questions, and so forth? If there are, and you would like to voice them, I can ask the juror to retire to the jury room.
So the judge says, yes, I've asked all the questions I have. I have no further questions on this issue. Would any of the attorneys like to ask any further questions? Now, the answer from Dick Harpootlian should be no. It should be no, Your Honor. No, Your Honor. The juror has spoken clearly. The answer should be no, Your Honor. The juror has spoken clearly. As the court said, that there needs to be both the influence and the influence, or there needs to be improper influence by the jury, and that it influenced the verdict. Both parts are met. So we should call an end to these hearings, and you should find in favor of us. That's like what you should do. You should say, no, we're good. We're good. Okay, so, all right. So let's listen what happens next.
Just tell me whether I need to do that.
No, you absolutely don't. We're good.
All right, sir.
Your Honor, can we ask the juror we need to put some things on the record.
All right. Take the...
What do you mean we need to put some things on the record? What are you talking about? We need to put things on the record. You've won. Why are you saying you need to put things on the record? What are you doing?
Juror to the jury room, please.
Laura, that's not what happened. Pay attention.
Yeah, that's fine. Mr. Waters.
Yes, ma'am. Your Honor, in the affidavit that was given by this particular juror, paragraph 10 said, I had questions about Mr. Murdaugh's guilt, but I vote guilty because I felt pressured by the other jurors.
So now he's like, okay, well, according to the affidavit, this is the thing, but it should be like, no, Your Honor, we don't absolutely need to do that. Your Honor was just clear just now. She clarified the issue. There's no need to do anything further. We're good. Right? Dick Harpootlian is like, yeah. So Waters is over here like, well, that's not what she said in her affidavit. And Dick Harpootlian right about now should be like, Your Honor, your questions couldn't have been clearer on the stand. She was absolutely clear that influenced her verdict. We're done here. Everyone should go home.
Request an inquiry as to that, which is how, when this motion was filed, she expressed the basis for her verdict, which obviously this answer is a little different now. So we would request a brief inquiry from the court as to that specific issue.
Now, Dick Harpootlian should be saying, no, absolutely not, Your Honor. We oppose any inquiry on the issue. The court was aware of the affidavit before, and the answers, the court was quite clear in its questions. The court even clarified to make sure the juror was aware of the answer, and the clarification resulted in the same answer. So there is no need to do this, Your Honor. We should all go home. Is that what Dick Harpootlian's going to say? Is he? Is he going to say that?
All right.
Thank you, Your Honor.
Mr. Harpootlian?
Your Honor, as to two things. The first thing is, he is correct. She gave an affidavit. We would ask Your Honor to let her read her affidavit to refresh her memory of, she said other things. They're very detailed in here. We'd ask you to, and let me hand up to the court, a copy of her affidavit.
Why are you doing this? Why do you want, because Waters just said, just now, if you were paying attention, hey, in her affidavit, she said that the pressure was from other jurors, which is not improper. That's legal. Pressure from other jurors is legal. And so, and that's that we'd like to have you question about it. And Dick Harpootlian's like, okay, we want to enter this because it makes really, really clear in the affidavit exactly what she was pressured. It was very, very detailed. We would like to introduce this thing that undermines the answer she just gave just now on the stand. Why would you do that? Why would you do that? Why would you want to answer this thing? We want to refresh, Your Honor, we'd like to refresh her memory because her answers on the stand just now are inconsistent with her deposition. And we'd like to have her memory refreshed so that she can give different, more exciting answers. Even though the answers we already have are the best possible answers. But we'd like to have her memory refreshed so that we can get better possible answers. Kill me. Just absolutely kill me. Absolutely kill me. This is such a horrific misstep. It's hard to fathom how bad a misstep it is. It's like, what are you doing? Yeah, what are you doing?
I'd ask you to have her read it before.
Alex Murdaugh burying his face in his hands because he can't believe how dumb his own lawyer is. Alex Murdaugh face palming this because he can't believe how dumb his own lawyer is. Holy God. Alex Murdaugh is not a happy camper over here.
Before she's asked any other.
What I have here from Mr. Waters, for the record, Mr. Waters, what I've been handed for the record is something now referred to as Z. It was taken August the 14th, 2023. It was sworn before Holly Miller, paralegal for Mr. Harpootlian, and he would like for me to give that to the juror and ask her to read it and then ask her about it. I'm inclined to do that, but I want to hear from you first.
Your Honor, again, if they want to refresh the recollection, that's fine with the state, but
I bet it is fine with the state. I bet it's fine with the state because that's what the state just said. You know, hey, her affidavit's inconsistent with it. And the defense is like, we'd really like to refresh her memory about what she said before. The state has no incentive to say no. The state has no incentive to say no because they've lost. They've lost. It can only get better for them. So of course they want to read it because it extends out the clock. It extends the game. So their defense is like, we'd like to ask some questions about this. And defense is like, we'd like to have their memory refreshed by the very thing that you'd like to ask questions about. The state's like, that sounds great to us. Of course we'd like to have their memory refreshed by the thing so that we can ask them all sorts of exciting questions about it. Holy God.
So we have no objection to that.
Very good. It will be done.
Your Honor, also we would ask that you not ask the question that that Mr. Waters asked you to ask because it violates Rule 606B, which provides upon an inquiry into the validity of a verdict or indictment, a juror may not testify to the effect of anything upon that or any other juror's mind or emotions.
What was the question he asked?
If you look at that affidavit,
it's paragraph 10, Your Honor.
Paragraph 10.
It's in the very affidavit.
She said she was influenced. She was influenced.
Yeah, it's like, so it's like, we'd like you to ask that question. And he's like, it's paragraph 10. And Waters says it's in the very affidavit that they just asked you to consider. Yeah.
By other jurors.
Yeah.
Okay.
I'm going to ask her about that.
Of course you're going to ask her about that. You just literally asked me. You literally just asked me to have her memory refreshed by this thing. Of course I'm going to ask her about it. Because it's in the thing you want me to refresh her memory by. That's the inconsistency, right? So of course I'm going to ask her about the inconsistency because you asked me to do it. You asked me to do it. And it's like, well, I don't want you to ask the question because it's against the rules of evidence, but you asked me to. You asked me to. You can't object. You asked me, you can't object. It's inadmissible because you just asked me to admit it. Shit.
Give her the affidavit and then I'm going to question her about it.
And we would, for the record, indicate that we object to that under 606B.
Your Honor, from our perspective, she's put an
And
issue.
you're the one that asked me to have her look at this affidavit, but you telling me I can't question about it? I deny.
Yeah, it's like, you're the one who asked me to look at this affidavit, but you don't want me to question her about it. I deny that. Yeah, she even cuts off Waters, because Waters is about to be like, that doesn't make sense. And the judge is like, that's okay, Waters, I got this one. And Waters knows to shut the hell up. Waters knows to shut the hell up because he's winning. He knows that he's winning. So Waters knows to shut his fucking face because he's winning. And it's just like, let the defense lawyer frown around. So he's like, Your Honor, that doesn't make sense. And barely can get 4 words out before the judge is like, this doesn't make sense. You asked me to read it, and I'm going to ask questions, so your motion is denied. Of course, yeah.
I deny that objection.
Your Honor, if it's something that's inadmissible, you should not ask her about it. And that's
Well, you want me to admit it and have her examined on it.
I want you to.
Yeah, exactly. If it's something inadmissible, you shouldn't ask the question, but you want it admitted. So, yeah.
To have her read it to refresh her memory.
We're quibbling, Mr. Harper, we're quibbling about things that I'm not going to take time to quibble about. My ruling is, pursuant to your request, I am going to allow the juror to examine her affidavit, and then I'm going to question her about it.
Which is perfectly rational. It's perfectly rational because you've asked me to have her memory refreshed. You asked me to have her memory refreshed by reading this thing. Of course I'm going to question her about it. What else would I do? You asked me to refresh the recollection of the witness. Of course I'm going to ask questions about it, because otherwise, why am I asking them to do it? The judge is completely correct. The judge is completely correct.
That's my ruling. Your objection is overruled.
For the record, I just want to know, Your Honor, just for the record.
You noted 606. I hear you noted.
And in no way waiving anything or opening any door by asking you to let her examine.
That's for a higher court than me to decide.
Yeah, I'm no way waiving anything by doing this. And the judge is thinking to themselves, you absolutely are. That's literally what you just did. You are actually waiving it. You literally asked me to consider it. I'm not waiving anything. Yes, you are. You're absolutely waiving it. What are you talking about? Of course you're waiving it.
Well, I understand that, and that's why I want to make sure when they read this transcript, there's no confusion. I'm not asking you to put that into evidence. I'm asking you to let the jury.
I don't see how in the world I can question the juror about something and not put it into evidence.
Yeah, exactly so, right? How could you possibly question her about it and not put it in evidence? That doesn't make any sense, right? Because you asked me to have her memory refreshed by this thing. So this is now a thing that's in the record because it has to be, right? You asked me to have her memory refreshed by the thing. Of course the thing is in the record. What are you talking about? The judge is like, what the hell are you talking about? The judge is 100% correct. Everything the judge says is 100% correct. She's 100% right.
You can't have your cake and eat it too, Mr. Harpootlian. You could have been very satisfied with the answers that were already given, but you have chosen to ask about this.
Request.
Yeah, it's like you could have been satisfied, but you asked me to. You could have been satisfied, but you asked me to. And Poot's over here like, we withdraw our request.
Denied.
Your Honor.
And everyone laughs. And everyone laughs. Because the clown show is complete. Everyone laughs, the clown show is complete.
All the time we ask witnesses to examine a prior statement.
Mr. Harpootlian, I made my ruling. Please take your seat.
Yeah, he's like, all the time, he's like, I've made my ruling, sit down. I made my ruling, sit down. Woof.
All right, bring me Juror Z.
Oh, Dick. Look at Dick Harpootlian. Look at Dick Harpootlian. He knows he fucked this up. He knows he fucked this up. And it's like, shit, it's all over. It's all over. Fuck. Yeah, legally, why can't he withdraw? He can't. Because it's you can't unring the bell. I mean, it's up to the judge's discretion, right? So the judge is like, it's like, okay, I want this read. Okay. All right, I don't want it read. No. You can't just undo things automatically. You can't just undo it just because you want to. You know, you just can't undo things just because you feel like it. Dick Harpootlian's like, I want the memory refreshed. Okay, here's what's going to happen. That shouldn't be what happened, but it is going to happen. Okay, then I withdraw my request. No. No. Hey, God, awesome. Yeah. She could say yes. She could say yes and show mercy, but she doesn't want to say yes. And I don't blame her. I don't blame her. It's like this lawyer just forced an error on himself. Why would I let him off the hook? Oh my God.
Another copy.
It's in here.
Yeah.
It's in here.
Mm-hmm. Yeah.
He didn't learn from the opening the door on the financial. Yeah, exactly. And Murdaugh's like, what the fuck is this? Because I'm fucked. Yeah, he can ask to withdraw, but that's a request. I'd like to withdraw. How about no? You can't withdraw. You stepped into the chasm, my friend. You can't step back. So now we're going to ask some more exciting questions about this from the juror. And the judge even pointed out the error to him. The judge even pointed out the error. It's like, you could have stood on the witness's answers, but you asked me to reopen this camp. You could have stood, but you decided not to. Yeah.
Madam Juror, you gave an affidavit to a representative of Mr. Harpootlian on August the 14th, 2023.
How's it invalidate what the juror testified to? Well, we're going to go find out together how to invalidate it. Let's pay attention.
And I have this in my hand at the present time, and I'm going to hand it to you, and I'm going to ask that you read it. Tell me when you completed reading it, and then I'm going to ask you some questions. You're going to see 4 little boxes on this affidavit. They are your name and the names of 2 of the jurors. I will strike that out before it appears in the record, just so you understand. Mr. Baird, please pass this to the juror. Take a moment to read this and tell me when you have completed reading. Yes, ma'am.
All right, take a moment to read this. Yep. This is the worst case of open mouth insert foot I've seen in a while. This is a hot absolute fail. You have snatched defeat from the jaws of victory. You had it. You had it in the bag. It was yours. It was yours, and you snatched defeat from the victory. Oof. Or snatched victory from defeat, whichever way it goes on that saying. Dick Harpootlian has got to be feeling like a total clown. Alex Murdaugh is like, I can't believe what the hell just happened. I haven't seen any sham of a hearing so far, my friend. I haven't seen any sham. Looks okay to me. I don't think the judge is doing anything wrong. Yep, no, I don't see a problem. The judge was very badly looking for a way to protect the system, and this idiot gave it to her. Maybe that's what's happened, but the judge isn't wrong. I can't disagree with her rulings.
Very good.
I can't find any fault with her ruling.
The first paragraph, of course, is a statement that you are a juror in the case. Second paragraph says, toward the end of the trial after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury, quote, not to be fooled, unquote, by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testifies. Is that what your recollection is of that statement?
Yes, ma'am.
Is there anything in the statement that, on reflection, you think is not correct?
No, ma'am.
All right. Number 3, she also instructed the jury to, quote, watch him closely, quote, immediately before he testified, including, quote, look at his actions, quote, and, quote, look at his movements, quote, which I understood to mean he was guilty. Is that an accurate recitation of your view of the matter?
Yes, ma'am.
Number 4, paragraph 4. Immediately after he testified, the foreperson said Mr. Murdaugh was crying on cue. Is that an accurate statement of what you saw and heard?
Yes, ma'am.
5, the foreperson criticized the former foreperson for handing Mr. Murdaugh a box of tissues when he was crying on the stand while testifying about his murdered son. She told the jury we cannot interact with Mr. Murdaugh because that's what the defense wants us to do. Do you still stand by that recitation of that conversation?
Yes, ma'am.
All right. Number 6, the jury frequently discussed the case during breaks before deliberation. Is that correct?
Yes, ma'am.
All right. Number 7, toward the end of the trial, Ms. Hill came into the jury room a lot. Is that your recollection?
Yes, ma'am.
Ms. Hill and the foreperson had private conversations on multiple occasions. The foreperson would tell the bailiff that she needed to speak with Ms. Hill. Ms. Hill would arrive, and then she and the foreperson would go to another room for a private conversation. The conversations typically lasted 5 to 10 minutes. The foreperson never said anything about the content of the conversation. For example, she never communicated logistical information after these conversations. This happened 2 or more times, more frequently towards the end of the trial. Is that still your recollection of the interaction?
Yes, ma'am.
9, when we began deliberations, Ms. Hill told us this shouldn't take us long, quote, and if we deliberated past 11 p.m., we would be taken directly to a hotel. We had driven from our homes that morning and were not prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, but they were told they could not smoke until after the deliberations were complete. Did you hear that?
Yes, ma'am.
Including the business about the smokers?
Yes, ma'am.
All right. Number 10, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that an accurate statement about your verdict?
Yes, ma'am.
All right. After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from a television show. Is that an accurate statement of what she said?
Yes, ma'am.
And did some jurors decline to do that?
Yes, ma'am.
Yeah, let me get back. Where are my questions? Juror Z, I asked you previously, was your verdict on March the 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered that question, yes. In light of what you said in the affidavit, which is I had questions about Mr. Murdaugh's guilt but voted guilty because I felt pressured by the other jurors. Is that answer that I just read a more accurate statement of how you felt?
Yes.
Form, Your Honor.
Overruled.
Yes, ma'am.
All right. So you do stand by the affidavit?
Yes, ma'am.
Very good. Thank you. All right. You may go to the jury room.
Yep. Is that a more accurate statement? I felt pressured by the other jurors. Yep. 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 So then the judge says, okay, her testimony is ambiguous, and there's no other confirmation from any other jurors. So, yeah. Great.
And let me just explain to you what the
Murdaugh knows he's screwed because his attorney screwed it up, because Murdaugh, for all his faults, is a good attorney, and he knows that he knows he's screwed because his lawyer screwed it up. Yep.
procedure will be. I'm calling the rest of the jurors, of course, one by one. When I'm finished with that, I will bring you out as a group one more time, and then you're free to leave. You don't have to stay. Okay? Very good. You may go to the jury room. What's that?
Before this juror is excused, but after she steps out, I'd like to address the court.
All right. You may be excused.
It's not perjury necessarily. It's just clarifying the remarks. It's not perjury. It's like, well, that statement was inaccurate. Here's a more accurate statement. It's not necessarily perjury. You know? It's like, no, it's like, here's a more accurate statement. It's not perjury. Give me a break.
Your Honor, just very quickly, I do have a redacted copy I can hand up to the court if you want to make that use of the court's exhibit for this witness.
That's good. What I'm going to try to do is redact as I did in the as you did in the document that you sent me. The identifying thing redacted now.
He has an extra copy of the redacting.
I have it right here.
Oh, good. That's great. That would be wonderful. Show it to Mr. Harpootlian.
I've seen it.
Very good. Thank you. That's the one I will give to the...
Dick Harpootlian's like, I see it. Do you see his face when he just said that just now? It's like, see?
Show it to Mr. Harpootlian.
I've seen it.
Very good. Thank you.
Dick Harpootlian's like, I've seen it. I don't even rubbed in my face. Dick Harpootlian screwed.
Yeah, that's the one I will give to the court reporter, but I think you can see that I asked off of it. This is a court's exhibit.
3.
Court's exhibit 3.
And Your Honor, just to be clear, that does still have the juror numbers in it. It does not have the letters.
Yes, what I'd ask you to do, Elizabeth, is take off the juror numbers, just strike them through, and then where it says affidavit of juror and gives a number, just strike that out and you can put in pen Z. Thank you. Yes, sir. Mr. Harpootlian.
Your Honor, we objected to the questioning because this juror gave 2 statements under oath, one in an affidavit and one here to you today. The one here today was Becky Hill influenced her verdict.
Yes.
The one she gave in an affidavit 6 months ago was based on jurors. It could be both. Your Honor picked out the one in the affidavit from 6 months ago and said, is that a more accurate statement? That presupposes and suggests to her what she should say. And we believe that this juror's testimony, and Your Honor,
good luck on that on appeal.
She said the affidavit was more accurate than what she testified under oath here today, and therefore I'm not going to consider her testimony. And I think that's where we're heading here. I'd ask you to bring her back in, explain to her there's nothing wrong with it both being true.
I decline to do that and overrule the objection.
Nice.
All right.
Dick Harpootlian makes one last stab at it. The judge is like, no, fuck you. No, fuck you. I'm not doing that shit. Fuck you. I loved it. I love it. I have no problem with this. I have no problem with it. Dick Harpootlian, this is all on you. This is all on you. I want more clarification. No, screw you. Yeah, no. The Court of Appeals is not going to slice it that thin, man. There's just no way. The Court of Appeals is going to be like, yeah, which is more? Right? There's no way. You're so fucked. Can the judge ask a leading question? Sure, they're the judge. They can do whatever the fuck they want. Yeah. The Court of Appeals isn't gonna care. There's no fucking way they're gonna care. There's no goddamn way. She's a former Chief Justice of the state. You really think the Court of Appeals or the state Supreme Court is going to overrule based on that thin of a distinction as the former Chief Justice of the state? I don't think so. No fucking way. Not even close. Dude, he is so fucked. He is so absolutely screwed. What a fool. What a total fool. What a total fool Dick Harpootlian is. I don't blame this judge at all. I don't blame this judge one bit. It's one hell of a self-gall. It's one hell of a self-gall. Yeah. Yeah. Now all your hopes rest on basically 403 with the Court of Appeals. Yeah, good luck. No one to blame but himself, yeah. He totally fucked it himself.
Counsel, I have to report this to you, and I'm very, very unhappy about it, but there's nothing to do but put it on the record, and then I will proceed with questioning the rest of the jurors. The jurors' cell phones were not confiscated or taken from them, and they tuned this thing in on court TV and listened to all of what just went on. So you may make whatever statement you like to make, and then I'm going to go on and question the jurors. I will tell you in advance, I am not going to stop the proceedings or do anything to interrupt them. I'm going to get the rest of this on the record. You might imagine that they no longer have their cell phones with them.
Your Honor, we have a 5-minute recess to discuss what we need to put on the record. I mean, this is... I'm
not going to take all day on this thing. I report things as they come to me. I will give you a couple of minutes, and then we're going to... They were late getting here. I didn't get to start on time like I wanted to. So I need to just calm down a little bit. But I tell you, don't take any long period of time. Court will be in recess for 5 minutes.
What a shit show. What a shit show. So that's maybe something there. Maybe they can work with that on the appeal. Like the other jurors were tainted, maybe they can make something out of that. So maybe they can do something with that, like the other jurors were influenced improperly by the thing, and they saw all the things that happened, and they don't want any piece of that. So maybe they can try to work with that on appeal. So yeah, unforced error by the court there. So maybe they can try to make something have that happen in court. Holy fuck. This is just so good. This is so fucking rich. Unbelievable shit. Yeah, the jury was sequestered, but they had their cell phones with them and they were able to watch the whole goddamn thing. Oh, man. Yeah, let's skip ahead to wherever they come back.
Just a minute.
Rise.
Just a minute. Now, you about to do something that I've already said I'm not going to allow to happen, and that is you've got standing next to you a member of the team that represents the juror. And I can tell you, Mr. Harpootlian, I made a ruling early on that when Mr. McCullough was in court and when Mr. Bland was in court, that I was not going to allow the attorneys to participate in formulating the procedure for this hearing. But I have not, I indicated that I would not allow the jury, the lawyers for jurors to participate in this hearing. And so I'm not going to do that. I can just tell you that. And if what you want to do is by indirection tell me what the lawyers for the juror would say, I'm not going to accept that.
Your Honor, my understanding is she'd like to approach to ask if the juror can be excused.
No, not yet.
Your Honor, I actually approached.
Now, Mr. McCullough can be excused. There's still plenty of you lawyers and you can do it. I didn't want him to come to begin with, so I love him dearly, and he can go anytime. And I speak on behalf of Amy McCullough, his wife, when I tell you that.
Your Honor, I actually was here to let both of them know that I was going to ask to approach to talk about a security issue very quickly.
Well, come up here. Lord knows, I tell you what, Murphy's Law. What can go wrong will go wrong at the worst possible time, and Murphy was an optimist.
So one of the lawyers for them is like, we want to talk about a security issue. It's like, holy shit. Oh man, we're having fun over here in South Carolina. Good times. This is yeah. I think the lady is one of the attorneys for the jurors. I think that's who it is.
Let me place upon the record two things. First of all, I have made certain now that a bailiff will be in the jury room with these jurors. Why that? I announced that many times, that is the way it was to run. Why there wasn't a juror in the jury room is something I don't know.
So there was supposed to be a bailiff in the jury room by prior order from the court, but that actually didn't happen. So they brought out their cell phones because there was no bailiff to stop them. Wow, great. That's wonderful.
But I have asked that that be followed rigidly. I've also asked, I don't go into jury rooms, never have and never will, but I asked the bailiff to tell the jurors that they are not to discuss any testimony that any of them are giving. I asked Juror Z whether she was comfortable, because I would be glad to place her in a separate room so that she's not set upon by the rest of the jurors. She gave me a big smile and said she is perfectly comfortable. And I said, at any time you're not comfortable, you simply tell me and I will have you placed in either my office or another jury room. So that's where I left it with Juror Z. I think she's fine, but I just wanted to make sure of that. And again, on the record, the conversation I had with her was outside the jury room. I don't go into the jury room for any reason. Very good. Mr. Bailey? Yes, sir.
For the record, Your Honor, we would ask, as jurors are brought in, we would ask that you ask them if they watched or heard anything this morning from their cell phone or other jurors about what occurred in here this morning with Juror Z, and if so, what was it?
I'm going to say, ask each one of them something about this. Whether it's exactly what you want, I don't know. But I will ask them something about this or make some direction to them about it. I'm not going to get into who shot John about what they said in that jury room today. I'm not going to do that. But I will try to, as best I can, deal with this question of of them hearing parts of the examination of Juror Z.
Your Honor, this morning I think you already instructed them not to discuss these matters among themselves. So if they have violated that, again, I think it's important for you to make that inquiry.
I'm going to make it as I see fit.
Thank you.
Yes, sir. All right. Bring me Juror C.
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 What a total fuck up by Dick Harpootlian. Unbelievable. Yeah. Did you see the exact second that Poot's soul left his body? A little bit, man. Yeah, Paralegal Liz, did you get to see that in person? Did you get to see the moment that Dick Harpootlian's soul left his body? Because it was pretty, yeah. Did you see it? Do you want to call in, Paralegal Liz? Do you want to call in? Let's have Paralegal Liz call in. You want to call in, Paralegal Liz? Are you in Discord? I'll give you my cell phone number and you can call in. Actually, it's easier than that. You can just call me on Discord. We don't even have to give you my cell phone number. It'll be better connection anyway. Can you call me on Discord? You need the Discord link? Tony, help her out.
Do you swear or affirm that the testimony you're about to give today to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
I will address you as Juror C because I've designated from your juror number at Colleton to letters of the alphabet. I am trying to protect the anonymity of the jurors as best I can. I can't promise you with all the time that they spent seeing you all in the trial of the case that they won't figure out who is who. But on my record here, which is all I can control, I will address you as Juror C.
Yes, ma'am.
And before I begin, I understand that there may have been some cell phones activated in the jury room and the watching of the questioning of Juror Z. Did that take place?
I know people were on cell phones, but I'm not sure of what they were watching.
Were you on a telephone?
No, ma'am, I was not.
Very good. I don't think I have to go any further then. Thank you, sir. You rendered a verdict on March the 2nd, 2020.
Send me a friend request and then you can direct call me in Discord is the way to do that. Or I can call you if I see you. Oh, there you are. Oh, okay. I'll just call you. That makes it easier. Should be able to do that. Hi. Yeah. Okay, great. Yeah. Yes, I am in fact human. I am in fact human. Yes. All right. Let's see if Paralegal Liz picks up. Hello.
Hey, let me turn on my Bluetooth.
Okay.
Okay. There we go. That way you don't have to hear yourself.
No problem. Take your time.
I'm sitting in the gas station as long as they'll let me.
Okay, cool. Well, thank you for coming. And how are you doing today?
I'm great. Thank you.
All right, cool. So tell me about your day.
Wow. Well, I was there actually on Friday as well, but was there today as well, and I got there really ungodly early, probably like 7, and a little before 7, and it was so cold. So I sat in my car for a little bit until the line started forming, because there was no line. It was literally just me and the media last Friday whenever I was in court. But today was a circus, as you saw. It was a lot more strict too. Like this time they actually cared about phones and things like that, when on Friday they did not care. Justice Toll has one thing that kind of drives me crazy is she's almost as scary as a jury to me because she's just unpredictable, and I don't like that about judges. And nothing I felt like she did was really consistent with like the courtroom like rules and procedure and dynamic, not the legal stuff, but kind of crazy. Long day, huge courtroom. I was seated behind like Murdaugh on that side. So also right in front of me were the attorneys for the jurors, the one that you actually just had on your stream at that point where she got up and had the security issue. She is an attorney for the juror, but Joe McCullough, the attorney that had a heart attack, if you follow the case, I'm sure you know that. It's actually another attorney at that firm. So you were spot on with that. I got to like hear them be like, oh shit, where's that affidavit? Or oh shit, you know, like I got to hear their little murmurings from the bench, and that was cool. I also got to meet like all the other like lawyers and YouTubers and Fitz News and stuff like that the past 2 days. So that was cool. That was like a benefit of getting there, like being the only civilian there on Friday was I kind of like they were texting me pictures that they had on their phone that they hadn't even posted on their news things yet. So that was kind of cool. Murdaugh didn't really like turn around or do anything this time on Friday. I felt like he did more, probably because the cameras weren't there. It's always so surprising how smiley he is with everybody.
Yeah. So was there any discussion of how Dick Harpootlian basically totally fucked this up?
You mean whenever he you mean like in general or in this hearing today?
In this hearing today is like, I'd really like to have the juror read from the affidavit, which completely sinks my win that I have in the bag, and I've absolutely won this case, but let me undermine myself.
When he handed out the affidavit?
Yeah. It's like, it's like, okay, we need to prove two things, right? We need to prove one, that the clerk interfered with the jury, and two, it influenced their verdict, right? So the judge asks the questions of the juror, and she says yes to both. She's like, yes, the clerk of the court said this thing, and yes, it influenced, and then it impacted me. And she's like, in what way? Well, it was clear that she thought it was guilty. It's like, I understand that, but did that influence your verdict? Yes. I'm like, game over. Game over. Right? We have proved everything we need to prove. All we need to prove it is for one juror. We have won. And Dick Harpootlian's like, okay, I'd like to make a record. I'm like, no, you don't. You absolutely don't want to make a record.
He's known for his brevity, right?
No, you don't want to make a record. You've won. It's over. It's like, I want to have the memory of the witness refreshed by this thing. And I'm like, why? And then the judge is like, well, I'm going to ask questions about it because, well, if you want me to have their memory refreshed by them reading it, of course, the only purpose in doing that is to ask them questions about it. So I'm going to ask them questions about it. And he's like, well, I don't want you to because of these rules of evidence. And the judge is like, well, you're the one introducing it, so you can't have it both ways. It's like you can't object to the very evidence you're asking me to introduce. He's like,
I do have a question for you.
Yeah.
So on the same issue, whenever at the end, like the main thing, when she was like, so is your affidavit more true or what you're testifying more true? Meaning like, was it the jury that pressured you or was it Becky Hill's words that influenced you? I don't know why you can't have both. Can you help me understand why you can't have both?
I don't know why you can't have both, and that was Dick Harpootlian's point. But it's sort of, the judge is the finder of fact is like, well, now her testimony is ambiguous. And that's sort of enough because, you know, it's like the Court of Appeals nor the Supreme Court is going to slice it that thin. This is a former Chief Justice of the state. They're not going to overrule her just for the hell of it.
And she said, I have no authority. I don't have authority to rule on these matters. I'm like, bitch, yes, you do.
Yeah. Well, I appreciate that, but it's like, you know, there's just no way. Because is the judge like abusing discretion or making a clear error by asking that question? Not a chance. And is the Court of Appeals going to care? Not a chance in this world. So I was just wondering if there was anyone else who, in that moment, was like, I can't believe what the fuck is happening, or maybe afterwards is like, did you see how Dick Harpootlian completely and absolutely sabotaged his case like a complete fucking moron?
Yeah, so I was sitting right next to this attorney. Her name is Lauren Taylor. She's in South Carolina. And she actually, goes on different news networks and stuff sometimes. But I'm sitting next to her, and literally when that happened, she put her hand down on the pew for me to grab her hand, like the oh shit moment. Literally, we were just holding hands. Like, is this really happening? Take your foot out your mouth. Oh, it was so bad. So tense. Yeah. And I didn't even expect her to make a ruling from the bench today. I thought she was going to take time. I'm so shocked, and I hate being shocked.
Well, I mean, apparently the other 11 jurors didn't testify that any of them were influenced by the comments, right? Did any other jurors say they were influenced? Right?
No, they didn't. Only one said they were influenced, and then I guess three total.
Huh?
3 total. I have my notes right here. If you want me to dig them out.
Yeah, please go ahead.
I am in my car, so.
Take your time.
Don't judge the ratchet car.
You look fine.
Okay. Okay, here's my little breakdown. X, Z, and P all heard. You don't need to see that. I'll just say it. So, juror X was on Friday. Correct me if I'm saying this wrong, because I'm delirious. Juror X,
that was juror X. You're right. That was Friday. You're correct.
And she said, I can say what she said now, because I have my notes. And I actually went back and circled this during the hearing. So out of the 5 questions that juror X was asked, that's relevant to this, the 5th one, where they asked her about her private meeting with Becky Hill, was the 4-person, by the way. She said that they were discussing another matter, ... nothing to do with this case. So she said that she had been talking with her and stuff like that. So, and then the memorandum, that's right, that's where I'm getting at. The memorandum that was introduced, that y'all heard them read that email today, from Eric Bland to Creighton Waters saying what his client was going to testify to about hearing the epic day. It's rare for the defendant to testify, all that. The lady said that she admitted to that she heard that. So back to that point, juror X heard something, didn't affect her. And then going back in the page, I'm sorry, this was so empty.
Yeah. So juror X, the forewoman, I suppose, said, no, this didn't influence me. Okay, yeah. Okay.
Z says it influenced her. It made Becky's comments made it.
And then not. That was the one we heard from. So we got juror Z's comment. What else we got?
And then P. Juror P was. I don't know.
If you're friends with P,
he was a male, and his thing he said he heard was that she said to watch his body language. That was all he could recall. So that's at least 3 people who were deliberating that heard it, but only 1 was affected. Not even counting.
And juror P said it didn't affect him, right?
Right. He didn't say it affected. He just said he heard the watch his body language.
Okay. Yeah. So yeah, that there's really not much for the judge to consider here, because she thinks you need both components, and whether or not that's true or not is a pure question of law, because 3 witnesses say, yeah, the clerk of court said that. So if that's sufficient, then that fact is on the record, and so a court of appeals, either South Carolina or the 4th Circuit, could overrule them on that issue if that's all that's required. But let's assume the judge is correct and that you need both. Okay. So you need both components. So 11 jurors say, no, this didn't influence me. And 1 juror said, yes, it did. And then asked the clarification, well, which influenced you more? It's like, well, my fellow jurors did. That was where the pressure came from. And so it's like, okay, this is ambiguous. So the judge is like, well, therefore, I have 1 ambiguous witness and 11 who say no. So I don't find that there was influence on the jury as a finder of fact. It's like, I can't contest that conclusion.
No, I don't,
at least in a legal sense, I can't.
I guess, to me, I don't know. I don't think that green should have been the standard.
I'm not saying that you're wrong. Maybe it shouldn't be. But that can be cleared up on an appellate issue, right? If the issue is simply the clerk of, and I tend to agree with you personally as a matter of policy, I tend to agree with you. Mm-hmm. But if it's merely enough that the clerk of court said these things, then those things are on the record. 3 jurors say that happened, and so that can be cleared up on appeal. So that's fine.
Yeah, I was really surprised Justice told, I don't really know how this works with like lawyers getting sanctioned, but I'm really surprised she didn't sanction Becky Hill, if that's a thing. You can tell me if that's a thing. But I'm waiting for Sled. I wish they would have arrested her or something outside the courthouse. That would have been cool.
Sanction her for what?
For like tampering, or I guess she says that it didn't affect, but like for her being so inappropriate, for finding her discreditable, her potentially driving with a juror. I don't know if a judge can sanction her. I don't know, but I wish, I mean, her being called not credible on international news is pretty cool.
Yeah. Well, she can definitely be tried criminally for her own actions, so I don't really think this judge can do anything about it within the respect, because like I don't really feel that falls within the contempt power, which is really the only power the judge has within this context is contempt, and she's not committed contempt within the context of this hearing, so there's nothing the judge can do. But obviously the statements can be used to prosecute her for juror tampering or other crimes, so she might have legal liability, but that's not for this judge to do.
Right, that's true.
But I still want to know if there were other people, because I got to imagine that there when there was a break or something, there's got to be more water cooler gossip about the fuck up of Dick Harpootlian. I want to know more.
I mean, really just a bunch of attorneys, like I'm not an attorney. Anybody who's worked in the courtroom was like, stop Creighton, stop, not Creighton, stop Harpootlian, stop. We all kind of saw where it was going.
It can't go anywhere good. You've already won. There's nowhere. Why would you keep talking after you've won?
I don't know, but Harpootlian, just like me, we both talk too much, and it really got him this time. Really got him. It was crazy to watch, like, the energy shift. Like, you could feel it. Like, we were like, oh, he's getting a new trial. Oh my gosh. Like, oh, like, started sweating and it was freezing in there.
Yeah.
And then you're like, oh man, he could have potentially just screwed this, and then found out he screwed it.
He did screwed it. Yeah.
Not a good day, but I got a selfie with him. That was cool. Yeah. He was like, who are you?
I'm Paralegal Liz, baby.
That's what I said, and he laughed at me. I was like, what? We all need cute nicknames, right?
Yeah.
He didn't know I call him Poot, but then this other lawyer was like, Elizabeth, stop doing that. That's disrespectful.
Southern lawyer was down there?
Yeah.
That's cool.
Another lawyer was like, don't do that. That's rude. And I'm like, everybody does it on the interwebs, right?
What's that?
Call him Poot.
Oh, yeah, no doubt. 100%.
Yeah, that's what she said was rude. She said I was being rude because I referred to him as Poot.
We call him Dick Poot.
What did I say? I was like, he had low Poot energy. And she was like, that is rude. Okay. I'm not, like, friends with him or anything, so I don't think it'll get back to him. But one thing that is crazy is I was in court today, and this one lawyer, I bumped into her, and I was like, oh, I'm sorry. I knew who she was. And I was like, Miss, whatever her name was. And she was like, oh, I know who you are. And I was like, oh. She was like, I saw your interview on YouTube. I was like, oh, God, this is so embarrassing.
You have no reason to be embarrassed. You're a wonderful woman. Why not?
Oh, thank you. I don't know. Because I'm not a lawyer, and I was, like, babbling and tired. And
hey, I mean, you're well-informed, intelligent. What's not to like? You underestimate yourself.
I really do. I really do. Thank you so much.
And at least in this moment, you're smarter than a trained lawyer because you know not to ask the stupid ass question.
Yeah, I guess you're right. Thank you, Kurt. I love you. Come back to South Carolina. Come back to South Carolina.
Yeah, I can. I can come back to South Carolina.
You should be a lawyer here.
Apparently the bar's pretty low.
Justice is first in SC. I'm here to let you know.
Yeah.
So.
Do you live in North Carolina or South Carolina?
I live in South Carolina. I actually, I'm from Columbia, Lexington area. I went to school here at USC. I went to law school and dropped out. So I'm a paralegal. And
You can always go back. You can always go back.
I'm a 3 and a 5-year-old, so I probably will in the next 2 to 5 years. But I just moved out into the middle of nowhere on Lake Marion, in a little town called Utahville. So I'm about an hour, 15 minutes away from Columbia, so I got to hit the road in a second. But I'm all over the state anyways for court, up here in Columbia, Richland County, down in Charleston, Berkeley, Dorchester, all that. So
you get around. That's a lot of mileage. Do you make it to the upstate?
No, not really. I would normally farm a case out for something like that,
Okay. Well, thank you for telling. And do you have contact information with Southern Law by any chance?
With who?
With Southern Law, because you said Southern Law was there?
Oh, I don't have any contact with them. I could get it if you want it.
That'd just be cool because, I'd love to talk to him and if he's available. So
okay, I'll reach out to my new friends in the medias and work on that for you.
All right, cool. Well, thank you very much for your time. I hope you have a great drive back.
I'll be listening in the chat while I'm driving. So.
All right, have a good one. Thank you.
Bye, y'all. Thank you.
Bye-bye. Okay, that was fun. Let's see. All right. So thank you, Liz, for that wonderful discussion of things. And a paralegal is just an assistant to a lawyer. And depending on the paralegal and depending on the lawyer, the paralegal can do quite a lot. The paralegal can theoretically do anything a lawyer can do except sign the document at the end. So they don't have the power to practice law. But many paralegals are quite competent and they can do basically everything a lawyer can do. Now, of course, your mileage is going to vary between paralegals. So some are better than others. But basically they can do as much as the lawyer will let them do. And some paralegals are really, really good and can basically effectively practice law on their own. And so if you have a really good paralegal, you can basically have them write, your motions for you and stuff like that. And, just basically put your signature on at the end of the day and do it. Paralegals typically do case law research. They look up things, otherwise provide assistance. It's like a physician assistant to a doctor. There you go. It's like a physician's assistant to a doctor. Yeah, depending on the physician assistant, depending on the doctor, the physician assistant can basically borrow the lawyer's license or borrow the doctor's license, all but for the, end of the page, right? So yeah, depending on the relationship. So yeah, effectively the paralegal can borrow the lawyer's license for everything but the signature at the end of the page. Do the work of a lawyer, get paid half the salary. Yeah, there you go. That's about it. Yeah, there you go. Nurse practitioner, something like that. Yeah. So yeah, there you go. You do all the same work and you get paid half as much. Yeah.
2. The verdict was read in open court, signed by the foreperson of the jury, and the court then said, "Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand." The transcript then indicated that the jurors complied. The jury was individually polled, and each was asked, "Was that your verdict?" Each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
No. Was your verdict based entirely on the testimony, evidence, and law presented to you in the case?
Yes, ma'am.
Did you hear Becky Hill, clerk of court for Colleton County, make any comment about this case before your verdict?
No, ma'am. I wasn't privy to any of that.
All right, sir. Was your verdict on March the 2nd, 2023, influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No, ma'am, it was not.
Very good. That completes my questions. You may retire to the jury room.
Do I think the judge got it right? 100%. 100%. Yeah. I think the judge got it right. If she's wrong on the law, then fine, but based on the law that she understands, she's correct.
Good morning.
Good morning.
I have designated the jurors by a letter, and that's how I will be addressing you this morning, and I will be addressing you as Juror F. Now, I realize that you folks were on the jury for a long time, over 6 weeks, and people may know who you are, despite my efforts to protect this record. But to the extent I can, I will protect this record and your anonymity as a juror in this record. So just wanted you to understand why I'm addressing you as Juror F. This morning it was brought to my attention that some jurors were perhaps on their phones listening or looking at a broadcast of the questions to the first juror I examined, Juror Z. Is that something that you know anything about or experienced?
Yes, ma'am.
Did you activate your own phone?
Another juror did.
All right. And will what you saw and what you looked at in any way affect your testimony as you're about to give it?
No, ma'am.
Very good. You rendered a verdict on March the 2nd, 2023, in open court and signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript that indicates that the juror complied. The jury was individually polled and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was your answer an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Absolutely.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March the 2nd, 2023 influenced in any way by any communications by the clerk of court, Becky Hill, in this case?
Absolutely not.
Very good. That's all the questions I have.
I'd like to discuss the matter with you before we finish with this jury.
You may go to your jury room and keep yourself ready. I don't know if I'm going to have any further questions, but as far as I'm concerned, the questions that I'm asking are at an end, but I need to consult with the attorneys before I can dismiss you. You may go to your jury room. Yes, sir.
Your Honor, in interviewing the clerk of court for Barnwell County, who worked as an assistant to Ms. Hill during this trial, and interviewing the alternate juror who was not, wasn't needed, wasn't dismissed for any particular reason other than it wasn't needed, both of them indicate they believe that Ms. Hill transported this juror by her personal vehicle or a bailiff's vehicle at least once during the trial. So I would ask you ask her, during the trial, did Becky Hill either drive or ride with you in a vehicle before or after court? If so, what, if anything, did Becky Hill and you discuss?
All right, what's your position on that, Mr. Waters?
Your Honor, I have no objection to that, Your Honor.
The clerk of court is giving rides to the jurors.
All right, bring the juror.
That's a hell of a thing.
This is Juror C, returning to the stand.
Let's carpool with a juror.
The same juror. Yes.
Well, Becky Hill's at best at fucking idiots.
Thank you, ma'am. Of course, you're still under oath. And I have this question for you. During the trial, did Becky Hill either drive or ride with you in a vehicle before or after court? If so, what, if anything, did Becky Hill and you discuss? Do you recall that at all?
Could you please ask that again?
Ma'am?
Could you please ask the question again?
Sure.
Sorry.
During the trial, did Becky Hill either drive or ride with you in a vehicle before or after court?
No, ma'am.
All right. Then I don't need to ask the second question. This will conclude your testimony. You are dismissed. I'm going to ask the jurors to stay with me until I've completed this process, and then you are free to go. Thank you so much.
Apparently not, I guess.
Next one's
Thank you so much. I have redesignated each of the jurors in the record for this case, and so I will be referring to you as Juror L, as in Lima. And, you know, y'all are all on this jury. If these people saw you for 6 weeks, they may know or be able to identify you, but I'm trying to, as best I can, protect your anonymity. You don't have to talk to anybody about this at all. That's purely your prerogative.
Justice.
Oh, yeah. Juror L, before you came to testify and were sworn, you were in the jury room with the other jurors.
Yes,
I understand that some may have looked at their cell phones and looked at pictures of the proceedings as they involved the first juror who was examined. Did you see any of that?
People had their phones out, yes, ma'am.
Did you look at any of it?
No, ma'am.
All right. And I don't need to ask you anything further about that. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury, and the court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was then individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, Madam Justice, yes.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, Justice. Yes, ma'am.
Did you hear Becky Hill, the clerk of court for Colleton County, make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No, ma'am.
Very good. Juror L, thank you, and you are dismissed. I will send word back by the bailiff if there are any further questions. Or E.
E is in Edward.
Yes. Sir, I will be addressing you as Juror E this morning. I've designated the jurors by letter. I realize that you sat on this jury in Colleton County for a lengthy period of time, 6 weeks or better, and people may know who you are, but to the extent I can make this record a record that protects your anonymity, I am doing that. You don't have to speak to a soul about this matter after you're finished, and your service will be complete, as I'm sure you thought it would be when you rendered your verdict. I have these questions. You rendered a verdict. Oh, yes. It was brought to my attention that cell phones of the jurors were accessed in the jury room for a time, and that some were able to examine the broadcast of the testimony of the first juror called Juror Z. Was your cell phone one of those activated to look at the proceedings?
No, ma'am.
Did you look at the proceedings on any other cell phone?
No, ma'am.
Thank you. Now, you rendered your verdict on March the 2nd, 2023. The verdict was read and...
Is anyone going to admit to seeing this thing? Is anyone going to admit to seeing this? Okay.
Open court, signed by the foreperson of the jury. The jury then said, the court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
It was.
Was your verdict based entirely upon the testimony, evidence, and law presented to you in this case?
Yes.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No.
Okay.
Was your verdict?
We have an interruption. What would be? Breaking news alert. Breaking news alert. Breaking news alert. Okay. Breaking news alert. Okay. You remember how we had the conversation with Ty, Treehouse Murder lawyer, Treehouse Murder pro se, and I said you really should get an attorney because the jury was 11-1 against you. Remember how I said that? Anyone remember that? How I said we had the whole interview, and then I was like, okay, the jury's 11-1 and they're guilty, and you really should get a lawyer, and please, for the love of God, get a lawyer. Okay, so I sent him a text message saying that, and he has responded to my text messages. Would you like to hear what Treehouse Murder Pro Se has said in response to my "you really should get a lawyer because okay, here's what I said. I'll just read it to you verbatim. I said to him via text message, I said to him, seems the jury was 11-1 to convict. Please use a lawyer next time. This should be a clear win for you. You really need someone who can present your case in a more organized fashion. Don't roll those dice again, my friend. To which he responds the following. That's according to them. And besides, no time really. The judge isn't going to allow time for an attorney to get up to speed. Besides, last time I got 2 of my witnesses. This time I'll have all of them. However, Think I'm going to get a paralegal to help with the legwork this time. Also still doesn't solve the dirty judge problem. I'm stuck in an airport right now on the way home, but I'm going to send you a couple of things to check out so you have a better understanding, to which he sends me a link to some newspaper articles. I know Pitcher's Depot is long, but read what's in it. I don't like to say I told you so, but the dirty judge is gone. He recused himself, so now new judge refiled motion to dismiss based on violations of due process, and if they rule by law, it's over. The pro se wins. Ty doesn't appear to be taking my advice.
Verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No.
Thank you, sir. That completes my questions. You may go to the jury room. I always consult with the lawyers to see if there are any further questions. If there are none, stay with the jury until I dismiss all of you. I'm hoping that won't be too much longer. Thank you, sir.
Thank you.
All right. Anything from the state? And from the defendant? Very good. Bring me Juror P, as in Paul. Yeah, that did happen.
He is so fucked.
Swear affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Good morning, ma'am.
I will be addressing you as Juror P, as in Paul. I've tried to redesignate the jurors without their number and, of course, without their name. Now, I realize you spent 6 long weeks hearing this case in open court in Colleton, and many people may know who you are anyway. But to the extent that I can make this record such that it protects your anonymity, I'm going to do that.
Yes, ma'am.
And you certainly are not obligated to talk with one soul about this matter after your testimony is complete.
Okay.
Juror E, I understand that before I began to receive your testimony, that at the beginning when Juror Z was being examined, that some jurors may have had cell phones and accessed the proceedings. Did you have your cell phone?
No, ma'am.
Did you examine any cell phone broadcasts?
There was a couple people, but I have no clue what they were viewing.
Yes, sir. Okay. Did any of this activity by other people in viewing this material have any impact on you in terms of your testimony today?
No, ma'am.
All right. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
It was.
Did you hear Becky Hill, clerk of court for Clarendon County, make any comment about this case before your verdict?
I did. Yes, ma'am.
What did she say?
It was
the day that Mr. Murdaugh was taking the stand.
Yes, sir.
And she made a comment about watch his body language.
About watch his
body language.
His body language, I see.
Yes, ma'am.
And what else?
That's all I can recall.
All right, sir. Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No.
All right. That completes my questions, Juror E. Or
P.
P. Juror P. You may go to your jury room. You are...
Ma'am.
Oh. I'm trying to preserve juror.
Yeah.
You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am, it was.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No, ma'am, I did not.
Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this matter?
No, ma'am, it was not.
Very good. That concludes my questions. You may return to your jury room. I ask that you stay until I've completed the questioning of the jurors. You don't have to talk to a soul about this matter. It's purely your prerogative. And if you have any difficulties in that matter, let me know.
Yes, ma'am.
You are excused.
Mr.
Very quickly, I think question 2. I don't know that we did question 2.
Resume your seat. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am, it was.
Very good. You're excused. Thank you, Mr. Waters. All right, bring me juror Y. Oh, excuse me, sorry. All right, nothing further, Ms. Waters. Thank you.
I can believe it got denied. I can believe it got denied because Dick Harpootlian's an idiot. I very much believe it was denied because Dick Harpootlian is a moron. As to whether or not the judge is applying the wrong legal standard, I'm not sure. I haven't really dived into the issue. But if it is the wrong standard, that can be fixed on appeal because it's a pure issue of law. So, we'll find out, I guess, but...
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Good morning, sir. I will be addressing you as Juror Y. The one who activated your cell phone?
No, ma'am.
Were you aware that some cell phones might have been activated?
I was aware after that.
All right, sir. Did you hear anything about the examination of the first juror?
No, ma'am.
Thank you, sir. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, Please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Not to me, ma'am.
Did you hear her make a comment to anybody else?
Not that I'm aware, ma'am.
All right, sir. So you don't remember any details of any conversation?
No, ma'am.
All right, sir. Was your verdict on March the 2nd, 2023, influenced in any way by any communications by the clerk of court, Becky Hill, in this case?
No, ma'am.
Thank you, sir. That completes my questions. I am going to excuse you. Stay together with the other jurors until I've completed my examination.
Who's swearing in the juror? A clerk of court, I suppose.
So help you God? Yes. Thank you.
Where is this hearing being held? Is it being held in Richmond?
Good morning. Good morning. I'll address you as Juror W. I have redesignated by letter the identities of the jurors as I question
get
them
food.
today.
Yes, ma'am.
And you know, you sat on this jury for 6 long weeks, and I'm sure that those who were there in the trial for a long period of time may know who you are. I'm just doing the very best I can to make your participation in this matter anonymous, and I will preserve that anonymity. You are free to not talk to one single soul about this if you don't want to. That's purely your prerogative.
Yes, ma'am.
I understand that when the first juror was being questioned, some members of the jury, as you were back in the jury room, may have activated their cell phones. Were you one who activated your cell phone?
No, ma'am. I left my phone in the car.
And did you hear any information coming from anybody else's cell phones about that examination?
I did.
All right. Does that have any impact on the testimony you are going to give today?
No, ma'am.
Very good. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict?
Yeah, Richmond is where the Fourth Circuit is, but that's the city of Richmond.
Was that an accurate
Richland
answer
is
about your
the
verdict
county in
at that
South
time?
Carolina.
Yes, ma'am.
All right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this matter?
Yes, ma'am.
Did you hear Ms. Becky Hill, the clerk of court for Clarendon County, make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March the 2nd, 2023, influenced in any way with any communications by the clerk of court, Becky Hill, in this matter?
No, ma'am.
Very good. That is the end of my questions, Madam Juror. You may go to the jury room, stay with the jury until I've completed the questioning, and then you're free to go, and you're free not to say anything you don't want to say. And if anybody upsets you or bothers you in any way about that, you just let the court know.
Yes, ma'am.
Thank you. Bring me Juror Q.
I want to be Juror Q. That sounds badass.
Juror Q. I County, your accusers, Madam Forelady, and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. Assist as best I can. You don't have to speak to a soul about these proceedings. And if anybody, the verdict was read and was individually polled.
Mean some chicken.
Each was asked, was that your verdict? Each juror answered yes. Each juror was then asked,
had some jalapeno poppers. They're
is
pretty
that
good.
still your verdict? Each juror answered yes. Was that an accurate answer
Yes, ma'am, it was.
about your verdict at the time?
Yes.
All right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, it was.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March the 2nd, 2023 influenced in any way with any communication by the clerk of court, Becky Hill, in this case?
No, ma'am, it was not.
Very good. You may be excused, and if you'll just stay in the jury room till we've completed the examination of all the jurors. Thank you, sir.
Thank you.
Your Honor, very briefly, I know we were doing the cell phone inquiry
Yes.
with the various jurors.
Yes.
I didn't know if you wanted to have that with this particular juror as well.
Sure. I understand.
Prosecutor Waters apparently has to remind the judge, it's like, you were supposed to ask this question? She keeps forgetting. So Prosecutor Waters coming to the rescue. Yeah. Is ma'am a pronoun? It is in the South, I'll tell you what.
Understand that before I began questioning you or the other jurors, on the questioning of the first jurors, some jurors...
I suppose you could also argue it's a title, but sir is a pronoun too. You know, sir is a pronoun, ma'am is a pronoun. Yeah, works for me.
Jurors in the assembly room may have activated their cell phones. Were you one of the jurors that activated your cell phone?
Yes, ma'am.
All right. And was anything that you heard at that time something that has any influence or effect on the testimony you now give under oath?
No, ma'am.
All right. Thank you. Anything further? You may go to the jury room.
Yeah, damn straight. Damn straight. You know, in a lot of places in the South, you use sir or ma'am, or you get it, ma'am. Yeah, sir or ma'am, or you get it, big time. Yeah, yeah, very much so.
For the state.
Nothing, Your Honor.
Nothing, Your Honor.
All right. Is done that you feel is harassing, or understand that during the testimony of the first juror, some opened their cell phones in the jury room, in our jury assembly room here. Were you one who opened her cell phone?
Yes, ma'am.
Did you listen to the watch the broadcast of that first juror's examination?
We were on Facebook.
Ma'am?
I was on Facebook.
It was on Facebook, and you watched it?
When we closed it.
All right. Did anything that you heard in that Facebook cell phone access impact or influence your testimony in this matter in any way?
No.
All right. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes.
Did you hear Ms. Becky Hill, the clerk of court for Colleton County, make any comment about this case before your verdict?
No.
Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No.
Thank you, ma'am. That completes my questions. I'll let you go to the jury room now. I'll then ask the attorneys whether there are any further questions. If there are not, please just stay in the jury assembly room until I give you the word that you are all to come out one more time and I dismiss you. Thank you, ma'am.
Murdaugh doesn't look like he's having a great day here.
For the state.
Nothing from state, Your Honor.
Nothing for the defense, Your Honor.
Very good. This then completes the questioning of the jurors. I will ask the jurors to come into the open courtroom again, thank them and dismiss them. Anything further before I do that?
None from state, Your Honor.
You only use ma'am for the queen and high-ranking female officers in the police. In the South, they use it for any woman.
Move for the record that I be able to question Juror Z to follow up on what I believe the court is confused about.
Very good. I deny the request. Anything further? All right, bring me the jury.
I bet you want to fix this nightmare. Your Honor, I'd like to undo my own goal, please. Can I have a do-over? No? Oh, well. Yeah, in South Carolina, you don't say yes or no without ma'am or sir. Pretty much, yeah. Pretty much. You are not wrong.
Thank you. Ladies and gentlemen of the jury, that completes the court's examination of the jurors in this matter. I can only deeply apologize to you for having to inconvenience you so long after the trial of this case to come here, and I very much appreciate your candor. There are no right or wrong answers to the questions I asked you, but I think each of you, to the best of your ability, answered the questions, and I am deeply grateful for that, as is the state of South Carolina, as is the defendant. You don't have to speak to a soul about this matter if you don't want to. That's purely your prerogative. If there's any difficulty you encounter about this hearing that I can help with, please contact the court, and I'll be happy to do so. You're dismissed this time. You may go. Thank you for your service. Excuse the jurors.
All right, so now we'll fast forward ahead to Becky Hill.
Stay
Seated, I have a matter I need to put on the record.
All right, sure.
Standard by which you would proceed during this proceeding and evaluate the evidence. We argued that you should use a case called Bremer. You rejected that. But under any standard, as I understand it, the burden of proof is on the defendant to show certain statements were made or certain conduct happened. So far, Your Honor has called as court witnesses 12 witnesses. We were not offered the opportunity to cross-examine them. And so we've not had the opportunity to present any evidence whatsoever.
Shut your
and before
face.
the state presents evidence, I believe that we should be able to call witnesses. And
No. What the fuck are you talking about? No, this is stupid. What witnesses could you even theoretically call? What the hell are you talking about?
I would ask the court to allow us to present some evidence before the state comes up with rebuttal. And by the way, under the cases you cited, they have no affirmative obligation to present anything at this point. There's no requirement they present anything.
Okay.
So I would ask you to allow us to call a witness or two before you make a decision as to whether or not they need to call a witness.
Who? Who would you call?
Your Honor, we obviously have argued very extensively some of the cases, and I think the South Carolina jurisprudence is very clear that while an evidentiary hearing is appropriate, and that's what we're doing here, that manner of inquiry is purely within the discretion as the trial judge sees fit. This is not a criminal trial where we're here with the jury to present the normal criminal trial process. This is a inquiry that is very much directed by the trial court and what the trial court thinks is appropriate. And so the state certainly is comfortable with the inquiry the court is conducting. In my understanding,
He wants to call an alternate juror? Fuck no. Absolutely not. Fuck you.
is as far as putting up Ms. Hill, this is the manner in which the court wanted that evidence presented, and so we're happy to comply in that regard. But we think that this inquiry is within your discretion, and we have no issue with
The Barnwell Clerk of Court? How would that be helpful to the question? No. The Barnwell Clerk of Court, how would that be helpful? No. That has nothing to do with anything. That has nothing to do with the price of tea in China. We want to call the alternate juror? Also, no. These are fucking stupid ideas. I don't like any of this.
manner in which Your Honor's proposed to conduct it.
Please, the court, Your Honor. Certainly the conduct of this hearing is within your discretion. What is not is who has the burden of proof. We do. And we can't meet that burden if we can't call witnesses. And so I'd ask the court to allow us to call witnesses. And if at the conclusion of us presenting those, you believe the state is required to present evidence to contradict that evidence, or in some way, I'm not quite, since Remmer is not the standard, I'm not quite sure.
It's his burden. He can call who he wants to. No, he has to call relevant witnesses to the question. He can't just call anybody. No, that's some bullshit. It's his burden, but he can't just call anyone. They have to have something to offer. This isn't The Simpsons, where Lionel Hutz is like, Your Honor, I'd like to bring in my list of surprise witnesses, and just brings in like 12 random people from the town who are going to testify. No, bullshit. You have to bring someone who knows something to the question. The question is, was the jury interfered with by the clerk of court? So who else could testifies to that other than the jurors and the clerk of court? Like, who else would have the answers to these questions? He can't just call. How would an alternate juror know if they were influenced or not? The influence on the alternate juror is irrelevant. She didn't cast a vote. So who cares if she was interfered with, because it doesn't matter. The Barnard clerk of court has nothing to offer on this subject. You know? Yeah, this doesn't make any sense. They're irrelevant. They're absolutely not relevant in any way, Michael. I'm just going to sharp disagree with you. They're not even remotely relevant to the question. I disagree.
What they have to prove, but that's an argument down the line. I believe we ought to be.
You can absolutely hold the defendant to a burden and say, I get to decide. Absolutely can, in the same way you can for the prosecution. That's dumb. Yeah, the prosecution has the burden of proof, in a criminal trial. That doesn't mean they can just call anyone for the hell of it. That doesn't make sense. The prosecution's like, yeah, we have the burden of proof, therefore we have the right to call any witness we want. I'm like, no, you can only call someone who might have something to offer with respect to the question at hand. You can't just call random people. This is some bullshit. No, the judge absolutely has the right to be like, no, you can't call that witness. That's dumb. That's a thing the judge can do. No, you can't call that witness. That's stupid.
I would call witnesses now, and we have witnesses which would substantiate the burden we have to show you that statements were made by the clerk of court and that those statements had impact on a juror or jurors.
All right. I've got a couple of reactions to that. Number one, the pretrial was the time to figure out exactly what we were going to do here. And I think it comes at the last minute for you to now come and say we want to present witnesses. You briefed the matter of witnesses. We had a long pretrial. After I made my rulings on what I thought the scenario was that should be used based on State versus Green, you lodged objections to that, but you did not offer at that time any information about who you wanted to call other than this lengthy filing in one of your briefs. It comes pretty late in time for, in my view, for you to do that now. The second thing is, I gave the defense a big break when I allowed you to be the cross-examiner and the state to be the presenter of Becky Hill. She's really a witness that each side needs to prove their view of what happened in this matter. The state puts her up to try to show that there was no impact by anything she said, and that some of the things your witnesses say were said, she says were not. So there's a conflict in the evidence there. I'm not going to rearrange the situation and go to any witnesses of yours right now. I'm going to see what Ms. Hill has to say. And then afterwards we can talk about whether there's any need for any other witnesses.
Your Honor, just factually argue this with you. We did not understand. We assumed you'd adopt Remmer.
What?
Well, I don't know why you assumed that when the South Carolina Supreme Court said very clearly that we do not go by the guidance of the 1950s case of U.S. v. Remmer.
We do not believe that's what Justice Kittredge has said.
They said it straight out, as clear as a bell can be, but I ruled on that.
Yes, ma'am.
And, and the South Carolina Supreme Court's going to have plenty of chances to decide that they want to modify Green.
Well, when we were somewhat taken aback by a ruling as a result, and that ruling came at a point where we didn't know what these witnesses were going to testify to. So we now, and by the way, you've set aside 3 days for this. What's the hurry? This gentleman is facing life with no parole. We should take this in a very deliberate way. He's got a 14th Amendment right to ensure that he had a fair trial.
All these arguments should have been made before this time, Mr. Well, Mr. Harper,
why? Did he just say why? Did he just say why should these arguments be made? Really? What do you think pretrial is for, sir? What do you think pretrial is for? Pretrial is to set what's going to happen at trial, so we don't have to resolve these issues at trial. We don't really want to resolve things on the fly to the extent we don't have to. So pretrial is trying to deal with everything we can that is not going to be at trial, which principally is going to be objections relating to questions that are asked, right? Because we can't deal with that in advance. So I mean, we can a little bit with motions in limine, but we can't control everything. So what do you think exactly the point of pretrial is? The point of pretrial is to figure out what the scope, what's going to happen at the trial or the hearing, as the case may be in this situation. You know, what is the question we're going to ask? What are the standards we're going to ask? What is the law we're going to apply? What witnesses are relevant to this thing? And the judge is like, I already ruled on this. And Dick Harpootlian's like, we didn't understand it to be the law. And the judge is like, I can't understand why you didn't, because I told you all this. This isn't a surprise. I know you disagree with me. I know you think that green isn't the best law, but I think it's the best law. I still think it's the best law. I mean, I understand that you disagree with me, but I've made a ruling, so, you know, there's that. We're caught by surprise. I'm like, how much by surprise can you possibly be? We want to call witnesses. And the judge is saying to themselves, what witnesses? You gave me a whole lengthy motion about why my ruling was some bullshit, but you didn't tell me what witnesses you wanted to call. Right? You know, so I knew what you were talking about. Like, why should we have? And I'm over here as the judge, I'm like, what do you mean, why should you have? What are you talking about? What are you talking about? Because you think I screwed it up. And you would tell me what witnesses you wanted to call and why they're important. And so I understood those things. And now you're springing it on me at the last second. It's like we didn't bring it to your attention before. We're just bringing it to your attention now. In the middle of trial, you want me to like amend what I'm doing in the middle of trial? How about you sit your fucking ass down, you shut up, and, you know, revel in your pain. Oh my God.
I've told you how I'm going to handle this thing. Your objections are noted and they're on the record. But right now what I'm going to do is what I said I would do. We're going to call Ms. Hill and see what she has to say. I have no idea who all you want to call as witnesses or whether they're here in the courtroom at the present time. But we'll get to that after Ms. Hill testifies.
Yep, sounds about right to me. Sit up, sit down. Sit your ass down. I know, I really actually appreciate this judge. I appreciate this judge and I like this judge. Because this judge is like no nonsense and no bullshit, and I appreciate it. I like this judge very much, right? I don't know whether or not she's right on the law, right? I haven't delved into the issue deep enough to know whether or not she's right on green or not. So I don't know whether or not she's right on the law, but she's like, look, I've been briefed on this issue. I've made a ruling. I've decided this issue. I know you disagree with me. I've thought about it. You guys cited me the law. I went and read the law. I've made a decision. Is the decision wrong? I don't know. I've done my best. I've done my best. If the Court of Appeals or the Supreme Court disagrees with me, then, you know, cool. But, you know, I've done my best. I've made a decision. I'm the judge. I've made a decision. We're not going to re-examine this. Sit your ass down. I want to re-examine it. Fuck no. All right, we'd like to call our witnesses. You didn't tell me in advance who they were. I have no idea who you're talking about. Why were we supposed to tell you? Why do you think you were supposed to tell me, asshole? Because that's what pretrial is for. What the fuck do you mean? Why are you telling me? Why didn't you tell me before? What the fuck are you asking me? You know, what the fuck are you even talking about? Well, Your Honor, this isn't fair. What the fuck isn't fair about it? I mean, we decided, I mean, look, this is an issue about whether Becky Hill interfered with the jurors, okay? Who are the obvious witnesses for this? The jurors and Becky Hill. Who have we heard from? The jurors. Who do we have yet to hear from? Becky Hill. Those are the obvious witnesses. What other witnesses do you want to call when the issue is, did Becky Hill interfere with the jury? How are other witnesses relevant to this thing? We just want to call witnesses, you know? No. And I appreciate this judge. We've seen too many judges. We've seen too many judges who vacillate and wander and like, oh no, right? Like the Rittenhouse judge, right? The prosecutor just keeps arguing and like the judge is like, okay, whatever you want, right? Whatever you want. This judge is like, fuck you. And I like the fuck you judge. I like the fuck you judge. And it's not fuck you because, you know, I haven't considered the issue. It's not fuck you because I haven't been briefed on it. You know, I've been thoroughly briefed. I've thoroughly considered the issue. We've thoroughly looked at it. I think green's the right law. You don't. I made a decision. Fuck you. We're calling the 12 lawyers and we're calling the clerk of court. Fuck you. You didn't tell me who you wanted to call. Fuck you. You're the one who wanted to introduce the affidavit from the juror that torpedoed your case. Fuck you. I like this judge. She's just like, I made a decision. This is what we're doing. It's like, I want to reconsider. How about fuck you? No, we're not doing that. How about sit your fucking ass down and shut the fuck up? I like this judge. I like this judge very much. Yeah. I like it. She's great. She's great. Chief Justice. That's right. Chief Justice. Not even judge. Chief Justice. I like this Chief Justice. She's pretty good. I like this Chief Justice. She's pretty good.
Let me go to a little something here that I'm just getting an email on and put this on the record right now. I have a communication from Mr. McCullough
The 19 today.
that's only, that is copied.
I like it so much. It's like, did I stutter, bitch? That's what this judge is like. Did I stutter? I like it's so great.
To Mr. Harpootlian, Mr. Griffin, Mr. Waters, and Attorney General Wilson. And basically says his client, Juror Z, wants to enhance the testimony she gave with some sort of affidavit that he wants me to look at, and I have looked at it. I want to hear from the state and the defense, but I can tell you I'm not inclined to get back into the testimony that's already been taken by these jurors. Her inconsistencies, whatever they are in the record, and she now wants to have another bite at the apple. I'm not at all enthusiastic about that, but I will hear from you, Mr. Waters, first.
Your Honor, the jurors testified. The court conducted the inquiry that needed to be conducted. She answered the questions. I would agree with Your Honor that multiple bites at the apple are not warranted. And so we would believe we should proceed forward as the court has indicated.
Why is a Perkins person still working at 82? She's not. She's retired. They pulled her out of her retirement home to beat everyone's ass around, and I'm here for it. I'm here for it.
Mr. Harpootlian?
Your Honor, I'd note two things. The first thing is we asked to be able to examine this juror. You denied that request. Number two, she's not our witness. She's not Mr. Waters' witness. She was the court's witness, and a juror that, and you commended all of them on their honesty. She's attempting to be honest. This process we're going through is an effort to seek the truth. This is the truth. I don't understand why it can't come in.
I think I understand what your position is, Mr.
So we'd ask you to make it a part of the record. You can say you're going to consider it. You're not going to consider it, but it should be a part of the record.
Well, I'll give some thought to whether this thing should be a part of the record, but I can tell you this. Witnesses don't get on the stand and testify under oath and then seek to add or change or deal in any way with their testimony. Those questions were very open-ended questions that asked for her responses, and she gave them. If they're inconsistent, she can't come up now and try to close the loop of consistency by...
I appreciate this. It's like, you know, the person testified on the stand. They said what they said. I'm not going to let them fix it. I appreciate that. I'm down for this. Shut up. Shut your face. I know it's great.
Some additional testimony. And I am not thinking about allowing that to be done.
With all due respect, Your Honor, we believe, and we said at the time, the way you questioned her put her in the position of saying, yes, that was my verdict then. We think, and we couldn't examine her, and Your Honor, to say now that this affidavit doesn't accurately depict her position is to deny fact, the truth.
You've already said that once. I know your...
Yeah, it's like I already heard this argument. Shut up. I like this judge. I like this judge. It's like, you literally said that already. I've already ruled. Did I stutter the first time? This judge pleases me. This judge is now my spirit animal. I'm happy.
Position on that matter, but I decline to adopt it. All right.
Sit your face down.
Make this an exhibit as a proffer for our case. This affidavit, we proffer it for our case. We have the burden.
I'll give some thought to it. I'm not ready to deal with that right now. I have looked at it just in the moment right before I put it on the record. I'll do some research about that, and we'll close that loop before the end of the day.
Your Honor, again, I indicate we have 2 more days. We don't have to wrap everything up today.
We're going to, though.
Yes, sir.
We're going to close it out today, though.
Thank you, Your Honor. The state calls Rebecca Hill.
I love this judge.
And bring it to the courtroom.
This judge is like, sit down with your fucking bullshit. She just has command, and I appreciate it. I appreciate her command. Yeah. It's like, did I stutter, bitch? I appreciate that. Yeah. Did I stutter? Yeah. Yeah. All right, Becky, tell us some lies. Tell me lies, tell me sweet little lies. Tell me lies, tell me lies.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Did you write a book? Was it plagiarized? Would you like to read from chapter 1 and just read us your beautiful, beautiful language?
Good afternoon, Ms. Hill. How are you?
I'm fine.
I want to get started, if you would, if you could state your full name for the record and spell it for the court reporter, please.
My name is Becky Hill. Last name Hill, H-I-L-L.
All right. And if you would, just give us, you're currently the clerk of court for Colleton County, is that correct?
That's correct.
And just very quickly, if you would, what year were you elected as clerk of court?
At the end of 2020.
At the end of 2020?
Yes.
And prior to that, did you have any involvement or experience with the state judicial system?
I did.
And could you tell the court what that was, please?
I was a South Carolina official court reporter for about 14 years.
All right. And were you, in being an official court reporter, you would serve in the courtroom, which is Ms. Harris is here today, is that correct?
That's
what
correct.
Was your, all right. And was that primarily in the 14th Circuit?
It was primarily in the 14th Circuit. However, I did travel throughout the state.
Did you have any other experience in professional experience prior to becoming a court reporter or clerk of court?
I was a court reporter freelance for 2 years before that.
Okay. And then any other professional pursuits you've had over the course of your career?
I was able to be a middle school teacher, and I worked for the Board of Disabilities for a few years as well.
Let me go ahead and just kind of get straight to it. In your capacity as clerk of court and in your previous experience being a court reporter, were you familiar with the rules that apply to court staff as it comes to interactions with jurors in the course of a criminal trial or a civil trial for that matter?
Yes.
All right. And could you tell the court generally what those rules are as far as what contact is permissible and what contact is not permissible, just very quickly?
The judge gives the law and gives the instructions for a jury, and the attorneys will state their opening argument, their opening statements, their closing arguments, and basically the clerk of court and anyone else court reporter. We're there to, my understanding would be to make sure that everyone's taken care of. Do you need some Kleenex? Do you need some water? Different things like that, just to make sure that they're taken care of.
Is it common for clerks of court to have interaction with jurors during the course of a trial to see to those various logistical needs that you just described?
Yes.
And did that happen in the Murdaugh case?
It did.
And can you give us an example of some of the logistical things that you, or other things that you would see to deal with any needs that the jurors may have? I mean, did you provide them food, coffee, make sure they were comfortable, things like that?
Yes, all of that.
All right. Provide blankets for them if they were cold?
Our courtroom was very cold in Colleton County, yes.
Did you provide them with aspirin or Tylenol if they needed, make sure coffee and snacks were available?
Yes.
Did you take lunch orders for them so that they were fed each day?
Yes.
At any time, did you interact with any juror in an attempt to influence their view of the facts in the State v. Murdaugh case?
No.
All right, now I want to ask you some specifics about that and some allegations that have been raised. At any time, did you tell the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys?
I did not.
At any time, did you instruct the jury to watch him closely and look at his actions?
I did not.
At any time, did you instruct the jury or tell the jury to look at his movements?
No.
At any time, as the jury moved to deliberate, did you tell the jury this shouldn't take long?
No.
At any time, did you tell the jury that the defense case, watch out for the defense case, they're going to try to throw you off, or anything along those lines that was meant to influence the jurors against Mr. Murdaugh?
No.
Uh-huh. So 3 different jurors are lying.
Let me ask you if you ever made any comment to the jurors about the fact that the defendant was going to testify. Did you have a conversation in the presence of the jurors prior to the defendant testifying about the fact that he was about to testify?
It wasn't directly related to the jurors. I was talking to Mr. Bill, who was our bailiff foreman, our bailiff over the jury, and I was talking to him about that.
All right, and what did you say?
I told him what I had just come from downstairs telling my security and bailiff office, that Judge Newman had allowed more testimony in regarding the financials, and that also the defendant had decided that he may testify.
All right. And where were the jurors at the point that that conversation occurred?
There were a few jurors standing in line, and there were some in the bathroom, I'm sure, because they said they were waiting on jurors to get out of the bathroom. And there were some in the jury room just milling around from what I could see, looking down the hallway.
And again, what were the words that you said during that conversation? What were the effect of them?
To Mr. Bill.
Yeah. And what did you say?
I told him that that Judge Newman was allowing more of the financial evidence in, which would prolong the testimony in the trial a little bit, and also that the defendant had decided that he was going to testify.
Did you say anything about this being an important day, pay attention, we'll get coffee for you, things like that during that?
I usually give a little pep talk to the jurors. It's sometimes hard sitting a long time, but my usual, and I do remember saying, pay attention, it's a big day today. Whatever you need, let Mr. Bill know, or one of the other bailiffs, and they'll be glad to get it for you.
Did your comments, or were your comments?
Yeah, Shauna, you like the fuck you judge too? Yeah. It's like Goodfellas. Fuck you, pay me. You know, your business is slow. Fuck you, pay me. Your business burned down. Fuck you, pay me. I like it. I like it very much. Yeah.
It's in any way phrased in favor of one side or against another side, or were they at more of a neutral comment about paying attention?
No, it was not for one side or the other.
Were you present when the jury went to the Moselle property to conduct the jury view?
I was.
All right. And was Judge Newman there as well?
He was.
During the time that you were on the property, traveling there, traveling back, did you have any conversation with the jurors where you made any comment about the substance of any testimony or any comment about the merits or the strength of the case?
No, no.
Did you have a quick comment to the forelady about how the property was beautiful and there were tea olive trees there that bloom and smell good, or words to that effect?
I did.
All right. And was there any other conversation related that you had where you made any comment about the case or the merits or anything like that?
Oh, no, no.
During the course of this trial, did you have a bailiff employee whose primary job it was to see to the jury and their security and to keep them separate from everyone else that was involved in this trial?
I did.
And who was that?
Mr. Bill Polk.
All right. And he was ultimately the jury coordinator in this particular case?
That's correct.
During the course of the deliberations, once the jury went back there, did you have any contact with the juries or have any substantive discussion with them?
Not at all.
Did you have any discussion with them about logistics, about staying in a hotel or anything like that?
I did not.
Did you have any interaction with the jurors or anything to do with them having smoke breaks or anything like that?
I did not.
During the course of the trial, did you have any discussion or interaction with the jurors about them giving any interviews to the media or making themselves available to the media? I'm asking during the course of the trial itself.
No, not during the course of the trial.
After the verdict had been reached and the case was in sentencing, did you have any conversation with any jurors at that time, after they had already entered their verdict and been individually polled?
Yes, after the sentencing.
All right, and tell the court what that interaction was at that time.
There were several outlets, news outlets, that wanted to interview the jury as a whole and really wanted to get them up to New York. And so I was trying to get a hold of all the jurors to talk about that. That was something we had not prepared for.
Did you at all pressure the jurors to speak, or did you just tell them that it was their option to speak or not, and here's the contact information?
I did not pressure the jury to speak, no.
Did you advise them that it was their decision and their decision alone whether or not they wished to speak to the media?
It was totally their decision.
And did you advise them of that?
Yes, yes.
Mm-hmm.
I'm going to ask it again, but I just want to be sure. At any time, did you make any comment to any juror or in the presence of any juror in which you at all tried to influence them in favor of one side or against another?
I did not.
Did you understand, being a longtime court employee and clerk of court, that that is outside the boundaries of what is appropriate interactions with the jurors during the course of a trial?
Absolutely.
And at any time did you violate that rule that you understood?
I did not.
Court's indulgence, 1 moment. Nothing further at this time, Your Honor.
Pretty short, pretty direct. All right, defense, what you got?
Mr. Harpootlian, on cross-examination.
Ms. Hill, we spent 6 weeks together, didn't we?
We did.
And during those 6 weeks, you were as helpful to me as you could be, correct?
I was.
Accommodated just about every request I made.
Yes, sir.
Wait a minute.
And there's that sound system again.
Where were we? Oh, yeah, we're old friends.
I want to be sure you can be heard. That was the microphone that was supposed to, you're fine where you are, absolutely fine.
Yes, ma'am. It was a staged microphone that was obscuring my ability to question a witness.
Yeah, well, what I'm wondering is whether you can be heard without a microphone. Do we need to try to get a microphone up on this podium?
I can hold this mic over if necessary.
Yeah, that would be good.
It's like, I don't need a microphone. Yes, you do.
All right.
I don't know who's supposed to hear this other than you, but I assume they can hear us. The court reporter, I'm sorry. She's more important, not as important as you.
Yes, I agree.
Oh, yeah, we're old friends, right? We spent 6 weeks together in a very pressure-filled situation, correct?
It was a long 6 weeks.
It was a long 6 weeks. And during those 6 weeks, you were helpful to me in a number of different ways, accommodating friends that I had that wanted to come watch the trial, for instance, correct?
That's correct.
You even allowed me to use the private restroom down on the first floor so I didn't have to stand in line with the rest of the people trying to get breaks, correct?
Correct.
So we have no animosity towards each other. You didn't do something to me and I didn't do something to you during that trial, right?
Absolutely.
Okay. Now, given that, I'm going to ask you some questions today that may indicate to you that I have some antagonism towards you. Let me disabuse you of that. I'm here doing a job representing my client.
I'm sure she believes this.
For decades, correct?
Yes, sir.
So you understand what we're doing.
Yeah, I have no antagonism towards you. She's like,
Now,
Are you trying to fool this woman?
A couple of things. I think, and I've read your book, some editions of your book. There's several. We got a bunch of emails in which you have drafts that you forwarded to your co-author, correct?
Correct. Objection. I would object to relevance. I believe any draft she sent to her co-author with the book is beyond the scope of this inquiry here today.
Overruled. You may proceed.
Thank you, Your Honor. And in those drafts, you say certain things about the trial, about the process, which you later did not include in the final version. It's called editing, is that correct?
I would agree with that.
Okay. Now, let's talk about this book for just a second. When did you first decide you were going to write a book?
I think a thought was there, a very fleeting thought before the trial.
Did you take any steps before the trial or at the initiation of the trial to begin writing this book or working with somebody on this book?
Oh, no, sir.
When did you and your co-author get together?
It was several weeks after the trial.
Okay. Did you talk to anybody about the fact you were going to write a book before the trial?
There were several anchors and several journalists that I did speak with about the possibility of writing a book.
We read the book. It was glorious. We read the book on stream. It was great. We enjoyed the book. The book was life.
Did you seek assistance in this trial from other clerks of court?
Yes, sir, I did.
And who were they?
Rhonda McElveen, who is the Barnwell County Clerk of Court, and Renee Elvis from the Horry County Clerk of Court.
In fact, if you like, I could pull it up and see if we can read some more.
Were they there with you the entire 6 weeks?
No.
I mean, how long?
I should
were
have
they
gotten a
there?
soft
How
copy.
long
That's what I
were they
really
there?
should have done.
Rhonda McElveen was there as often as she could be, probably several times a week. Renee Elvis helped me during the jury selection.
Oh, the chat knows. The chat knows how glorious the book is.
And did she begin, that is, Ms. McElveen, did she begin working with you prior to jury selection?
Can you repeat that question?
Was we began jury selection, I think, on January 23rd, correct?
Correct.
Was she working with you or consulting with you prior to the 23rd?
No, sir.
Did you have any conversation with her about the trial?
Not until she got to the trial on what, I can't remember the exact day she came.
Okay. Now, is she a friend of yours?
She was a friend, yes.
Was?
She was.
Well, she is a friend.
Okay.
Yes.
But she's done nothing to make you any less a friend?
No, sir.
Now, did you tell her?
Can I give a book
highlight?
highlight?
The trial. That
Sure.
You were going to write a book. That you had thought about and were going to write a book.
I can't remember exactly. I think we did have a conversation about a book possibly in the future.
And did you tell her you're going to write a book because you thought it would make a lot of money?
Oh, no, sir.
You never said that?
No, sir.
And did you tell her that you were going to write a book to make a bunch of money so you could buy a lake lot and build a house on it?
No, sir.
Okay. Now, did you ever tell her that you had given a juror a ride home, that you had accompanied Mr. Bill, what's his last name?
Bill Polk.
You're right. That you and he took a juror home one night? Did you tell her that?
All right. Because you asked so nicely. Because you asked so nicely. I'll read from chapter 9. The plan. 4 steps to achievement. Plan purposefully. Prepare purposefully. Proceed positively. Pursue persistently. William Ward. All the planning we had done for 4 months from September 2022 to late January 2023 culminated with jury selection on January 23rd, 2023, and the beginning of the trial process. The train was loaded on the tracks, and we were ready to put it in motion. All we had to do was get on and hold on. Great. That's a good start.
Did you take a juror home one night?
I didn't take a juror home one night.
Did
No,
Mr.
sir.
Mr. Polk and you take a juror home one night?
No, sir, we didn't.
Okay, you never gave a juror a ride in a car with Mr. Polk or without?
No, sir.
Okay. Now, also, during the trial, your daughter ended up on the Venire, is that right?
She did.
And she was coming up, and did you talk to me? And
I've never heard it pronounced that way. Venire. I've heard it always pronounced veneer. Venire. Is that some alternative pronunciation I've been missing all my life? Okay.
and Mr. Waters about putting her on the jury if at all possible?
I'm not sure that we wanted her to be on the jury if at all possible, but I think the question was, would she make a good juror? And I said she sure would.
Now, I don't think we asked you. I think you told us she would make a great juror, did you not?
I remember you asking.
Okay. I was considering putting your daughter on the jury.
Yes, sir.
And who does she work for?
She works for Compass South.
Did she work for the Sheriff's Department at some point?
No, sir.
Okay. Did she work in law enforcement at all?
It was important to understand the sacrifice that everyone was making to be part of the trial of the century. And the least we could do was show our Southern hospitality. We wanted to ensure that everyone enjoyed their meals while they had a moment to decompress from the trial. These little details all added up to a lot as we increased the frequency of our meetings. More and more people started attending our meetings as we got closer to the start of the trial. We made decisions on vendors and audio-video equipment since monitors need to be put in place for many key people involved in the trial. Wirings and cabling were also installed. It was a major production. That last word in quotes. As part of our 4-month runaway to the Murdaugh trial, I had our fire marshal come out to give his gospel on how many people he'd allow in our main courtroom at one time. He made it as easy as 1, 2, 3 for us. For this one trial, we were allowed 234 people, and about half of them were directly connected to the trial, such as the Attorney General's office, SLED, Murdaugh's defense team, the Clerk of Court's office, Judge Newman and his team, the media, jurors, alternates, bailiffs, and witnesses. The other half were general spectators. One of the most important aspects of controlling the crowd inside and outside the courtroom was working with the bailiffs, court staff, and visitors to create a numbering system, not unlike how an airline might do it for standby customers. We assigned different colored badges each day that were embossed with the Clerk of Court's seal. That meant that someone couldn't come back on a Wednesday with a Monday colored badge, for example.
No, sir.
Okay. Now, let me ask you this. How many jury rooms were there?
We have 2 jury rooms in Colleton.
In this trial, how many jury rooms did you have? How
2.
Many? Okay, so the entire jury wasn't together at any one time? They were separated into 2 rooms?
Yes.
Okay. And when they're separated into 2 jury rooms like that, are they next door to each other? Are they down the hall from each other?
They are next door to each other.
Okay, so but if you close the door to one, can they hear what's going on in the other one?
Some women probably have very good hearing, and men too, but I would say probably not.
Okay, are there restrooms in both of the jury rooms?
There are.
Okay. Are there 2 restrooms or just 1?
There's 1 restroom in each jury room.
Okay. Were either one of those restrooms designated men and women, or did everybody use the same one?
They were unisex.
They were unisex. Okay. Now, prior to your testimony here today, have you met with the Attorney General's office in SLED?
I have.
On how many occasions?
I want to say twice.
Okay. And remember when the first time was?
I think the first time was in September.
Okay. And the second time was last week?
Yes, sir.
And that was in Walterboro?
Yes, right.
And y'all spent about 4.5 hours together?
I want to say maybe 2 hours together.
Okay. And in those 2 hours, you went over your testimony here today?
They asked me questions.
Did they ever correct your answers or suggest you answered differently?
Oh, no.
No.
Oh,
So
no.
you just went through what you went through in 20 minutes here. It took 2 hours to go through when you were with them.
There were times when I would step out of the room and come back in. But I would say we were there for about 2 hours.
Now, you have described in your book your role as Switzerland, is that correct?
Correct.
Okay. And that is that you should not be in any way opinionated about what's going on in the trial, is that correct?
That's true.
Okay. Yet in your book you indicated a number of different points during the trial you had concluded he was guilty, is that correct?
I think...
Your Honor, I object at this point. I don't know if her conclusions in the book are in any way relevant to what occurred during the trial and whether or not there was any communications with the jurors, which is the sole issue that we're here for today, is whether or not Ms. Hill had any extraneous influence on the jurors. And so I think this is going a little far afield. We object to the relevance, Your Honor.
Overruled. You may continue.
Let me give you an example. You indicate riding back from Moselle that you and 3 other people were in a car and you all decided adamantly, I think was the word you used, that he was guilty, that he had killed his wife and son. Is that what you put in the book?
I can't remember if I put that in the book, but if you say I did, then I will agree with you.
Did that happen?
We did have a conversation about what each of us thought.
And all four agreed that he was guilty, correct?
And none of us were jurors.
No, trust me, I know that. But you had an abiding conviction, at least by the time of the Moselle visit, that he was guilty. And the other people in the car with you were bailiffs, were they not?
No.
Who were they?
Some were not bailiffs. One was a court reporter. One was our security officer, head security, and another was a deputy sheriff.
Okay. But the four of y'all rode out there, and based on what, and I mean, I can, you want me to read to you how chilled you were and how you felt that poor Paul and Maggie had been executed by him on that scene, that visiting the scene convinced you that he was a horrible, horrible murderer? You want me to read that to you, or you will concede that's what you wrote?
I will concede that's what I wrote, but if I may, I would say that a lot of that is poetic license in writing a book and in making it sound like that.
Okay, so some of it's poetic license, and some of it you just stole. You purloined it from that BBC writer, right?
Right, again, I object to not only the relevance, but the scope of cross. I would object also under Rule 608. I don't believe that's appropriate cross-examination.
Overruled. You may continue, Mr. Harpootlian.
Did you steal part of the book?
I did plagiarize,
Okay,
Mr. Harpootlian.
that's stealing, isn't it?
And it is, and for
Okay.
that I'm very sorry, and I have apologized.
Okay. And that makes it okay?
What I did, and I apologized for that.
And part of the book is, you say, literary license, exaggeration?
I wouldn't call it exaggeration.
Okay. Now let me ask you this, is Switzerland?
What's the difference? Okay.
And this is, you're saying this is happening while you're supposed to be Switzerland. You decided the defendant's guilty. And if Ms. McElmeen says that it's going to make you more money if he's found guilty, don't you think it's reasonable to assume that you may have crossed the line from time to time?
Your Honor, I object to the form of the question, assuming facts not in evidence.
Overruled.
Can you repeat that question one more time,
I'm
Mr.
not going to
Harpootlian?
repeat it. Let me just move on to something else. Let me ask you, you had interactions with some jurors, and I believe in a conference in the judges' chambers, you indicated that you had seen a post on, is it Walterboro Word of Mouth?
Your Honor, again, I object. I think he's delving now into the Facebook inquiry. We believe, again, that that's irrelevant to the inquiry before Your Honor.
I will allow limited, he's, as I understand it, trying to impeach her testimony and explore her credibility. And I think I've already told Mr. Harpootlian that I don't want a whole trial about the business of Facebook and the egg juror, but I will allow limited examination on this point. You may proceed, Mr. Harpootlian.
Am I oversimplifying that? I mean, it's in your book. You saw something on Walterboro Word of Mouth, which appeared to you to be from the ex-husband of one of your jurors. Is that correct? Am I oversimplifying that?
I remember reading one night something on Walterboro Word of Mouth, and when I was in the courtroom on a Monday morning listening to the judge and the attorneys talking about a matter, it sounded like it was relevant to each other.
Okay. And you became aware somehow that this juror had a restraining order out for her ex-husband?
She told me that herself.
Okay. And tell me how it came for her to tell you about that. Where did she tell you?
She was very talkative, and when I was instructed by Judge Newman to go and get her from out of the jury room with a deputy following me, she was talking to me all the way back to the judge's chambers, and she mentioned that there were restraining orders out when they had divorced.
So how did the judge, who brought it to the judge's attention about this Walterboro Word of Mouth thing?
I let the judge know, thinking that it could be related.
Okay, and you let the judge know what?
That I had read something on Walterboro word of mouth.
Okay, and that you knew it was tied to that juror?
I didn't know that it was. I wasn't sure at all.
Who do you think it was tied to?
From what y'all were talking about at the bench, I felt like I needed to let him know, just in case it was related. There was something about an ex-husband and an ex-wife and somebody being on the jury.
You didn't tell the judge that you had found what we call the apology post? You didn't tell the judge that?
I didn't call it that, no.
You don't remember producing it, saying that, producing it to the judge, saying this is a post in which the guy that posted it on Friday night says the devil got in him and he's drinking and he apologized for what he posted? You didn't produce that?
My staff did, one of my staff.
But you gave that to the judge and gave it to us, did you not?
Yes, we did.
As if it were from that juror's ex-husband, correct?
Correct.
And you know it wasn't?
I don't know that, Mr. Hartbulian, no.
So, and this, you did not take that juror out and talk to her before you took her to the judge? Is that true?
I never talked to that juror about stuff like that.
Okay. Did you ever talk to the forelady of the jury, separate from the jury?
I did.
Okay. And tell us, where did that occur?
When I would go into the jury room and I would speak with the forelady, we would be in like the hallway, in the two jury rooms were side by side, and the opening to the jury room went out into the hallway, and we would be surrounded by the jurors at all times. Mr. Bill would be very, very nearby, or another bailiff as well, when we would speak.
And what did you speak to her about?
There were several instances. One was there was a juror who needed some feminine products. There was another time when Band-Aids were needed. There were times when Tylenol would be needed.
Other than items that were needed by the jury's health object, did you ever discuss, did she ever discuss with you, some issues jurors had emotionally, or some issues with dissension in the jury room?
She only told me that there were some loud jurors, and it made some of the other jurors a little upset, but other than that, that's...
What did you tell her to do?
I told her if it got out of hand to write a note to the judge, and that she could sign the note and get Mr. Bill to give it to the judge, and the judge would handle that for her.
Okay. Now, you did publish a book after this trial, is that correct?
We did.
And you went to New York.
All right, guys, further breaking news update. Breaking news update. Okay. My continuing conversations with Ty, the pro se, continue. Would you like to know the latest on the Ty, the pro se? Okay. So picking up where we left off, Ty, the pro se, wrote to me the following. I don't like to say I told you, but the dirty judge is gone. He recused himself. So now new judge, refile motion to dismiss based on violations of due process. And if they rule by law, it's over. The pro se wins. I write, if there is a new judge, all the more reason to get a lawyer and present the best case you can. What an amazing opportunity! Exclamation mark. I'm sure the new judge would give any lawyer you hire time to get up to speed. And even if not, you can use one of the lawyers that are up to speed, because he says he has these two lawyers already that are helping him off the books, as it were. To which he responds the following. Don't think we'll need it. The motion is pretty easy. We've done 2 already. As long as they rule according to law, no more trial. Sorry, man, I'm feeling really sick all of a sudden, and I think I need to lay down. Ty, the pro se, is fucked.
York and took some of the jurors to the Today Show.
The Today Show did invite us, yes.
Now, one of those jurors that went up there with you, the day of the verdict, wore, for the first time I can remember, wore a suit to court. Do you remember that?
Your Honor, again, I would object to discussion of the jurors wearing a suit or a post-trial trip to the Today Show. I don't believe there's any connection.
I tried, man. I tried.
That's focus for Your Honor, and
I tried.
There's any extraneous influence during the course of the trial.
I'm going to connect it, Your Honor, I believe.
All right, overruled. You may continue, Mr. Albuquerque.
Did you text, email, or communicate on the morning before final arguments were completed that to people that this was on a Thursday, that they probably, if they're going to see the trial, should come on that Thursday because it would be over by the next day? The jury would not be out very long. Did you ever communicate that? Email, text, or verbally?
I do remember saying that, yes.
And why did you think the jury would not be out very long? Had you communicated with jurors?
I had not communicated with jurors about anything related to this trial at all. I've been a court reporter for at least 14 years. I was clerk of court for 3. And you just get to where you kind of see things happen as they progress, and it's a guess, it's a gut feeling, and that's all that I meant by that.
Well, why are you telling this young man who wanted passes for the next day in an email, it won't be happening tomorrow? That was or did you say, you didn't say, I don't think, you just said, you better come today if you're coming. Remember doing that?
I don't remember that. But, if he wanted to come, I knew that the trial would be ending shortly as far as testimony. So if he wanted to come, he needed to come.
Why wouldn't the jury have been out a week on a 6-week trial?
They could have.
But you apparently were telling the press and others that there'd be a quick verdict. Were you not?
That was just a gut feeling that I had.
Okay.
And that was my opinion.
Okay. Your opinion, you were right. The jury was out 3 hours on a 6-week trial, correct?
That's true.
How much money did you make off that book?
There was not a whole lot of money made off of the book after paying different things and paying for some expenses that went along with that. But I want to say roughly around $100,000.
Okay. That's not a lot of money.
No, especially when you publish your own book.
But that was $100,000 you made?
With my co-author.
Okay. In what period of time? 6 months?
I would say 6 months, yes.
When was the book published?
August 1st.
Okay. The trial was over. That's 6 months after the trial's over, you've published a book, correct?
Correct.
And then I believe you've recently stopped selling the book because of the plagiarism you've admitted to, correct?
Correct.
And so there's no more money?
Correct.
Now, you also indicate in the book that the Murdaughs had a reputation of criminality, I think, is kindly what you put. Did you not?
Well, Mr. Hartpooley and my grandfather and Old Man Buster were very close.
Well, were they criminals?
I wouldn't know.
You wouldn't know. But you believed and you published that the Murdaugh family had run that part of the state and they'd participated in criminal conduct, correct?
Your Honor, again, I would object to general testimony about the alleged criminality of this family. I'm not sure how that has any bearing on the focused inquiry before the court.
He's asking about what she said in the book. I'm going to allow it.
Yes, sir. Did you say that in the book, that they were criminals?
In the book, that was more of the literary ease that we take, I think, to make a story a little more interesting for the reader.
By calling people criminals. I guess what I'm saying is this. Were they criminals?
Your Honor, again, I object to that particular question.
Overruled.
Were they criminals?
I wouldn't know that.
Okay, so you either made it up or you're lying about it? About the reputation of people that can't defend themselves? They're dead? You're going to call them criminals? You did that in the book so you could sell a book?
No, I didn't do that to sell a book.
What'd you do it for? Made it more readable, you said? Which sells books.
Literary ease. Yeah.
What?
Literary.
Literary what?
the literary ease that you can take with when writing a book.
Literary ease you can take with writing a book? You can make stuff up? You can lie? You can lie about people?
Not with that. I think the public perception was one that it was very interesting during this time.
So you're feeding the monster out there that wants to believe bad things about the Murdaughs, and you'll make stuff up to do it. Let me give you another example. I read your book, and I found this somewhat humorous. My co-counsel did not. In describing myself and Mr. Griffin, in the book you say that I neutered him. We've both been very interested in what you meant by that. What do you mean by neutering Jim Griffin?
Mr. Hartpulian, it was a book.
Did you make it up? I know it was a book. The Bible's a book. Right. I mean, just because it's a book doesn't mean you can lie in it.
It's just a word that was used.
The nature of that exchange.
Don't argue with the witness, but the witness, Ms. Hill, you're instructed to answer his questions. You may proceed, Mr. Hartpulian.
So let me get this straight. The book, and I'll see if I can cut to the chase on this. I could read you chapter after chapter, verse after verse, which is not true. Okay? Not true based on my experience of being in a courtroom, and not true based on knowing some of the people you described. You say that is...
Mr. Hartpulian.
I object. The counsel is just testifying right now as to his observations about the book.
Question, Mr. Hartpulian, please.
You have conceded there are things in the book that you don't...
Well, I'm not sure the judge really cares because the judge wants to watch the witness squirm. So yeah, Mr. Waters is like, I objected. The judge is like, yeah, let her dangle. I don't fucking care. I like this so much. Yeah, fuck it. It's fine. You rule your roost, judge. What's the relevance? The relevance is I want to watch the witness squirm. Yeah, that works for me. Yeah.
Know to be true, correct?
Correct.
Okay. You would concede then that you have lied in the book.
It's only because I wasn't there at the time. I can't interview my dead grandfather. I can't interview Mr. Buster. There's just things that we can't interview them on. We can go by what was written in a newspaper and get facts from that.
And take the inference that one of the Murdaughs was a pedophile. You could have printed that, and they're not here to contradict it. You could have printed anything you wanted and made it up to sell books. That's what this whole scheme was about, selling books. As you told Rhonda McElveen, if him being found guilty would sell more books.
Your Honor,
isn't that true?
I'd object to the argumentative nature of the question, the compound question, and assuming facts not evidence.
The compound question. If what you're asking is what she told Ms. McElveen, go on and ask that, but don't precede it with
yes, Your Honor.
Testimony.
Beg the court's indulgence for just a moment.
Judge is so pissed. Judge is so pissed at the witness. I love it. The judge is thinking to himself, I will destroy you. I hate you so much. Yeah. I'm here for it.
Whose ex-husband had posted something we now know probably wasn't her ex-husband. Did she have any other ex-husbands that you found out about?
I have no idea.
Well, you wrote, we learned later the ex-spouses hadn't seen each other in 14 years and she had 3 restraining orders against him. Did she have 3 restraining orders against him?
I don't know. That's what she said.
Okay. Did you tell jurors at the end of the trial after President's Day break? President's Day break would have been a Monday, correct?
Correct.
But before Mr. Murdaugh testified, did you tell the jury not to be fooled by the evidence presented by Mr. Murdaugh's lawyers?
Mr. Harpootlian and I never talked to the jurors about any of the evidence
If the
in
answer
this
would be
case.
yes or no, then you can explain. Did you say that?
No.
Okay. Did you ever instruct the jury to watch him closely immediately before he testified, looking at his actions, looking at his movements? Did you ever tell a jury to do that?
No.
Did you ever tell the jury to pay attention to Mr. Murdaugh's testimony?
To pay attention, not specifically to his testimony. I did tell the jury to pay attention.
To what?
Just generally in the hallway when I was speaking.
Not to him?
No.
Just to any witness?
Right.
Okay. Did you ever warn the jurors the defense is about to do their side? This is right before right at the beginning of the defense case. They are going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Did you ever tell the jury that?
No, sir.
Okay. Did you ever tell the jury, if you get emotional, we want to see your face, because that is what they want to see? You ever tell them that?
No, sir.
Did you ever tell the jury that Mr. Murdaugh was about to testify?
I didn't tell the jurors that.
Now, did you tell the jury that if they didn't reach a verdict by 10 o'clock, they were going to have to spend the night?
No, sir, I did not.
Did you ever tell them they were going to have to spend the night at
No,
some
sir.
point? Did you ever tell them that they couldn't smoke?
No, sir.
Okay. You got any other books in the works?
No, sir.
I mean, doesn't this make a good book?
Nice. Well, eat it. Eat it. Lol. Eat it hard.
Yes, sir.
Yeah. It's like I tell you guys all this. I tell you this all the time. Two things you need to remember. First of all, your judges are minor demigods, and second of all, the number one rule of litigation is don't piss off the judge. This would be a good example why, right? It's like, don't piss off the judge. The judge is pissed. The judge is pissed because of you, and is going to make you pay. And like the Waters is over here like, I object, and the judge is like, I literally don't care. I don't care. I just want to watch her squirm. Just ask anything you want, Mr. Harpootlian, and I'm good. Just beat her to death. I'm here for it. I love it. I love it so much. It's great.
Your Honor, there were a few matters that came up on cross, obviously, that I'd objected to.
You won't waive your you may reserve your rights to object to the entire line of testimony, but you may offer cross-examination subject to the assertion of your objection about the testimony.
Thank you, Your Honor. One of the things you were asked about is finding this Facebook post, and you brought that to the court's attention after a different issue had already arisen related to a juror. Is that correct?
Correct.
All right. And are you technically capable of manufacturing a Facebook post? Is that anything that you have any capability to do?
I'm not.
All right. And did you ask your staff member to go see if she could find this post?
I did.
Did you tell her just generally what you recalled reviewing?
Yes.
And did you give her any further instruction other than that?
No.
Were you sitting behind her as she was doing this particular search or anything like that, or did she eventually report back to you?
She is very, very techie, and then she reported back to me.
All right, so you weren't there when she was searching anything like that?
No.
And she was like, I couldn't find that post, but I did find this, and handed you the Facebook post. Is that correct?
Correct.
And then you provided that to Judge Newman, and ultimately it was provided to the parties. Is that correct?
Right, correct.
You were asked about conversations that you had with the forelady. Did those involve logistical issues and things like that for the jury?
The conversations with the forelady was everything. There was nothing regarding the defendant and this trial.
All right, so they were logistical issues, not anything to do with the substance of the trial. Is that correct?
Absolutely, yes.
You were asked about whether or not you had texted some people, this won't be long. Was that at all in any way based on any conversation you had with a juror as to their internal thinking or anything like that? Or was that just your assessment being an experienced person in the court?
Absolutely not.
It was based on just your assessments?
Just my assessments, yes.
Did you ever communicate with the jurors on how long they would be, or did any juror ever tell you how long they thought they would be?
I never talked to any jurors about anything like that.
You were asked about your book, and I don't want to get into too much detail about that, but you were asked about some of the assertions that you made in the book. And you were asked if these were lies. Were they lies, or were they ultimately things that were based on inferences from newspapers and community stories?
You are leading by, this is your witness, Mr. Waters, so please ask a direct question.
Thank you. Some of the statements that you were asked about in your book, were they lies, or were they based on your inferences from just general community knowledge and things that you had researched and knew?
Still leading, but I'm not going to object.
All right.
Thank you.
He's right about that, Mr. Waters. Just ask a direct question.
Did you lie in your book?
No, I did not.
Thank you. You were asked about when you told the jury to pay attention. When you asked that question, did you also mention anything about, we got coffee for you, or things like that?
I knew that Mr. Bill would take care of that. And the jurors knew too. Coffee, we had done some Dunkin' Donut runs. We had provided coffee, different other things to help stay awake in the cold courtroom that we found ourselves in. And so I knew anything that they needed, Mr. Bill would see that they got, because that's what he did.
At any time, did you have any conversation with any...
Who's actually responsible for all this? Mr. Bill. Who was really the one who tampered with the jury? Mr. Bill. Well...
Any juror in which you tried to influence their decision?
I did not have a conversation with any juror about anything related to this case.
Nothing further, Your Honor.
All right.
Oh no!
Ms. Hill? I want you to turn your attention to a...
Oh, the judge is going to ask some questions now? Oh, this is just too great. So we allowed direct, cross, and redirect. The judge is like, you know what? I'd like a turn. I'd like a turn too. Love it. Awesome. Let's go.
A hearing that Judge Newman had about the alternate who was dismissed. Sometimes called the egg juror. Do you recall that hearing?
Yes, ma'am.
In the hearing, Judge Newman expressed his unhappiness with you for questioning that juror before he questioned her. Do you recall that?
I do remember seeing that.
Well, then let's go back and talk about that juror. On examination in this courtroom, you said that she talked about a lot of things to you, but you didn't ask her any questions. But that's not completely accurate, is it?
Yes, ma'am, that is true.
Well, you asked her direct questions, and that came out in the hearing that Judge Newman had. You asked her questions before she was even examined by the judge, did you not?
Your Honor, I did not ask her any questions.
Really? Really? So Judge Newman was wrong. Okay. All right. Okay. Sure. Okay. That's good. I wonder why the judge found her not credible. It's so hard to tell.
The juror was examined by the judge in a hearing. Do you recall that hearing? It's the second hearing on this matter.
I do recall that hearing, yes.
And the court asked you about, the court asked this juror about postings on Facebook, did he not?
Correct.
And the juror said she gave Miss Becky my full access to my Facebook. And I put positive posts on it. I've done that for the past 3 years. Do you recall her testifying in that regard?
I do remember reading that.
And the judge said, has anyone posted anything on Facebook about you? And the juror answered, I was not aware of it until Miss Becky told me today. Do you recall that?
I do remember her saying that.
And do you recall the judge saying, what did she tell me? And the juror said, she asked me if I had an ex-husband, and I said, yeah. Did you ask her that?
I remember her saying this, Your Honor, but I did not ask her any of these questions.
And she's...
Really? I wonder why the court doesn't find Becky Hill credible. It's amazing. So 4 different jurors say you said things to them, and you're like, no, I didn't say anything to any of them, including a hearing in which Judge Newman had a hearing. The juror was lying to the judge. And these 3 jurors today lied to me about it. It's like, no, I didn't say any of these things. I wonder why the judge doesn't find her credible. It's so hard to tell.
It further says, she asked me if I had talked to him about the case or being on jury duty, and I said no. I had questioned her about why she was asking me that. I haven't seen my husband since 2014. Do you recall her testifying to that?
I do remember that, yes.
And with that having jarred your memory, do you recall asking her about her husband and his post?
Your Honor, I don't remember saying anything about that.
Well, what was the post that you read in the Walterboro Word of mouth? What was the nature? You read that, did you not?
I did.
What did it say?
My memory is a little fuzzy with that, but it was about an ex-husband who found out that his ex-wife was on a jury, and he didn't think that she would be a good juror, and it just sounded very similar to what I had heard the judge and the attorneys speaking about.
So you then went to that juror and questioned her about that, did you not?
I did not, Your Honor.
Well, she says in this testimony that she didn't know about the Facebook until Miss Becky told me. Was that incorrect?
I'm not saying...
Some kind of conversation went between the two of her for her to know about that post, correct?
That's true. And I'm thinking that it could have been someone It wasn't me. I just know that it's not me that she talked to about that.
Well, when the judge, the judge was questioning the juror about this, she also said that she had 3 restraining orders against him. And she also said, I was very upset after she told me that. Like I said, I have 3 restraining orders against him, and I wouldn't have anything to do with him if I didn't have a child with him. But I haven't seen him since 2014. Y'all didn't discuss that, the restraining orders?
On the way from the jury room to the back chambers where the judge was, she was very scared. She was talking about the 3 restraining orders that she had out on her husband at the time that they were divorcing, and she was scared that he would be trying to get back in contact with her again.
Well, how do you know that? Did she tell you that?
She was talking about that on the way to the jury room, to the chambers with the judge.
And in the court, in this hearing now that I'm looking at,
she is a liar.
The court is conducting. She said they're asking about this Facebook post, and she said Miss Becky said she went to look for the post again, and that it had been deleted. I don't know who she talked to or anything else, but she said apparently. Do you recall her saying that?
I do remember her saying that.
And the court then said, what did she tell you about that? And the juror said, it was after you let us go on the last break. I was very upset. This is what you're talking about. And she came down and talked to me and said that apparently, I don't know who talked to him, but he said he was drunk and he removed the post. Do you recall that?
Well, she didn't tell me that, and I didn't talk with her about that.
Well, you saw that post, the so-called apology post, did you not?
Right, I did.
And you assumed that was a post from her husband, did you not?
Right.
And then you talked to the juror about that, did you not?
I did not talk with the juror about that.
Well, who did you talk to about it? Did you bring it to the judge's attention?
No, we didn't get a chance to talk to the judge about that.
Uh-huh. The judge is like, this is some bullshit. This is some bullshit.
The court asked this juror, has the clerk discussed anything about the case with anyone on the jury? The juror said, not that I'm aware of. The judge said, okay, she was just discussing with juror. She pulled me aside when we went downstairs after the last break. I want to say it was after lunch, and we came back, and that's when she first told me about it, about this, what we now know was not a post from her husband.
Right.
But you assumed it was a post at the time, and y'all had a conversation about it, correct? Don't just nod. Answer the question.
Yes, sir. Yes, ma'am. I believe that it was one of my staff that she talked to, but it was not me that she talked to.
Uh-huh.
But the juror says, and I want to say it was after lunch we came back, and that's when she first told me about it. She's talking about you.
Correct.
Then we went back into the court, and I never even got to sit on the jury. The judge says, the judge then stops the questioning and she exits the room. Mr. Griffin, Your Honor, I think that satisfies it. She hadn't talked to anybody, hadn't expressed an opinion, hadn't made up an opinion. She's got an ex-husband and she has 3 restraining orders against him. The court said, Mr. Waters, just obviously we all invested in this. My main concern, I certainly would love to, but not love to, but would want to hear, what one of these individuals said. But, she answered the questions as she did, talking about the juror. They then have a colloquy about
this juror.
Thank you, Chuck, in
whether
Tennessee,
this
for
was really
becoming a
her
member. We do
husband that
appreciate it.
Put this post in that.
We appreciate everyone who hits that join button for 99 cents.
Talk to the court about it at some point, am I right?
That's right.
Yeah, how can I doubt her? Every possible way.
And then at the end, the judge
Thank you, Chuck, in
said
Tennessee, for the 10 gift
that he
memberships.
was,
It's very much appreciated. Thank you.
not too happy with your having talked to the juror before you talked to him. Do you recall the judge saying that?
Yes, ma'am, I do.
Yeah, you can insult
And did you
Becky Hill. What the hell?
Hop right up there and say what you're saying now that you never.
She is
talked
such
to
a
her?
liar. You can insult Becky Hill.
We
It's
never
fine.
talked about
She
it
sucks.
after that. I wasn't in the room when he said that.
Don't make me regret it, though.
The judge brought up another thing right after sentencing that I want to explore with you briefly. One of the big responsibilities of the clerk of court is to take control of the exhibits that are presented in court. Isn't that correct?
Yes, ma'am.
And there were sealed exhibits presented in this case that were photographs of the two decedents at Moselle when the law enforcement authorities first investigated the murders. You recall that?
Yes, ma'am.
And those photographs were sealed by the judge, were they not?
Correct.
And when the testimony about them was completed, they were under your control as the clerk of court, were they
Time
not?
out, Santiago, please.
How was it?
I fucking swear, all you guys commenting about the judge, I swear to God, I'm getting so pissed about this. Fuck all y'all.
That those photographs came into public view.
Are you talking about after the...
I'm talking about the fact, he alluded to it on sentencing and said that he was frustrated about it and was going to try to look into it. Those photographs that were sealed court exhibits under your control found their way into the public media, did they not?
I believe they did. And I think what happened, it was someone from the gallery took a picture from a screen that had some of the pictures on it, if I'm remembering correctly.
Did you ever allow anyone from the press to view these sealed exhibits?
No, ma'am.
Did you allow Netflix to ever examine the exhibits for trial?
No, ma'am.
How did you handle exhibits? Because you did have the press have great access to the exhibits, and you say several times in your book that you had to stay after to be sure that you interacted with the press about these exhibits. That's true, is it not?
That is true. We had Mr. Jay Bender, and then we had the pool photographers and someone from maybe the state, I believe, or the Posting Courier, along with the court reporters, someone from court administration, and then someone from the clerk's office every night that would go over the exhibits to make sure everything was correct and within our domain.
Were any press people ever allowed to view the exhibits, even the sealed exhibits that you had on file?
No, ma'am. No, ma'am.
What was the methodology for allowing them to examine the exhibits? How did you handle that?
I wasn't there a whole lot when we did this every night, but it's my understanding that the people that were involved with the exhibits, and especially the court reporters, and there was a certain time frame that they were allowed to take their pictures, and everything was, all of the pictures were looked at by the court reporters that were there and the lady from court administration, along with someone from my office and Mr. J. Bender, to make sure that everything was done correctly.
What I'm asking is how you handled having them, the press, view these exhibits.
If I remember correctly, the press, we had certain designated photographers and then someone, I think, from the state of or the Post and Courier, and they were responsible for putting it out on a stream for the rest of the media to access.
Would they do that by photographing the exhibits as they were in your possession after court was over that day?
That is correct.
All right. And how did you handle the sealed exhibits in terms of their availability when these press people are there photographing exhibits?
They stayed sealed.
And so you think that you're aware of the fact that some of these on-the-scene photographs of the two decedents found their way into the public press. You're aware of that, are you not?
Yes, ma'am, I am, yes.
And you contend that they photographed them in the courtroom?
That is what I heard.
Mm-hmm.
All right.
Judge is like, that's a bullshit.
Finally, you have indicated about your book that some things that you put in there were, you called it literary license, not literally true, correct?
Correct.
Did you ever, by any kind of email communication or in any way, shape, or form, indicate or state that you wanted a guilty verdict because it would increase the sales of the book? Did you ever say that in an email or verbally or in any other way?
No, ma'am, I did not. It didn't matter to me if it was guilty, not guilty, or a mistrial.
Mm-hmm.
Well, in your book, you suggest that the guilty verdict was what you wanted, and you were fearful that that a guilty verdict would not be rendered. You say that a lot about your feeling about wanting a guilty verdict, do you not?
I do agree that that is said in the book, and part of that is because I think it was a guilty verdict.
Well, this is you were describing a time way before the verdict was rendered. When you wrote about those things in the book. Isn't that correct?
It is, yes.
And you even have something where you said your eyes met with jurors and others at Moselle, and y'all had an understanding, unspoken, that he was guilty. You said that in the book, did you not?
I did say that in the book, and I would consider that part of the literary, the word that we just said. But there was nothing spoken with a juror at all at Moselle or anywhere else at the courthouse or anywhere. I think that's part of that poetic license that we write to make something more apparent.
The judge is a fucking woman. God damn. I hate you all.
But at no time did I read or try to read someone else's eyes, and
at this point I wonder if it's just active disrespect. She is a chief justice of the state, and I think some of you guys are being disrespectful, and it's beginning to piss me off.
That was just one of those gut feelings that I wrote in the book.
And I think she's a great judge, even if she's wrong on the law. I haven't delved into the issue. She may be wrong on the law. I've disagreed with the Supreme Court 9-0 decisions. I've disagreed with unanimous Supreme Court decisions. She might be wrong on the law. Everyone does it. I'm wrong on the law sometimes too. I make mistakes, damn it. You know, but it's like, you know, she's done her due diligence. She's thought about it. She's applied all her tools. She's been a lawyer for 50 fucking years. She's the Chief Justice of the state. She probably knows what's going on. Fuck.
You wrote in the book, speaking of a time before the jury verdict was rendered, I was conflicted about knowing the Murdaugh family and about having so many people watching and listening to me as I read the verdict. I was mostly concerned about Alex being found innocent when I knew in my heart he was guilty. I had this fear that the goodwill the Murdaughs had built up in the community would influence the jury. You wrote that, did you not?
Yes, ma'am.
So you had those feelings well before the verdict was announced in this case. You had some definite opinions and feelings about what the verdict should be, did you not?
I did have a certain way that I felt. But
I
would never...
that's not any poetic license, what was said there. That's how you felt, correct?
Correct.
All right. Those are my questions. Anything further from the state, Mr. Waters?
Becky Hill is such a liar. Mr. Waters knows she's a liar. Are you going to salvage this one?
Yes, sir. You were asked a number of questions about the interactions during the in-camera proceedings with the juror who was excluded. Were you in the room during the entirety of those interactions, or just were brought
Moselle,
there as...
this has tainted your name. I'm sorry, Moselle. We love you. It's not your fault. It wasn't Moselle's fault either. We love you.
As those occurred?
No, I was only brought in for my asking of my questions from Judge Newman.
And you were asked a little bit about sealed exhibits and about Judge Newman's comments at sentencing at the end of trial. And just to clarify, those were not pictures of any sealed exhibits. It was a picture that someone had taken in the gallery that had actually been disclosed, and that's what Judge Newman was talking about, to your understanding?
That was my understanding, yes.
And then after the trial, there was even a post-trial hearing or some discussion about the fact that some body cam videos had not been sealed, and Judge Newman fixed that problem after the trial. Is that correct?
Correct.
Nothing further, Your Honor.
Just a couple questions.
Mr. Harpootlian?
Let me understand this correctly. You would agree that you did release all of the exhibits in this case, sealed and unsealed, to the Texas film crew. Is that correct?
No, sir. No, sir. I did not release the sealed exhibits.
What about to Netflix? Didn't you indicate to the judge they'd been mistakenly released and you're getting them back?
As an error, when we realized everything, yes, those two did go, and Netflix had not even, they said they had not even looked at them.
Did you get them back?
We did get them back, yes.
And what about a Japanese film crew? Did they get exhibits, the sealed exhibits?
They didn't.
Yeah, I mean, shortcake, it's like, look, if you're good, you're good. If you're not, you're not. I've seen incompetent men. I've seen competent women. Like, I just call it like I see it. I think she's a competent woman. I like her style. I like her command of the control room. She seems exceptionally well informed. She's done her due diligence. She's made a decision. She's ruling. She's like, we're moving on. I've ruled. Choo-choo, motherfuckers. Let's go. And I'm like, yeah, that's right. Choo-choo, motherfuckers. We're going. The train is moving. Let's go. I like that. I don't like a lot of these pansy-ass judges. We've seen both men and women pansy-ass judges, incidentally. We're seeing arguably some pansy-ass judge right now, by the way, in the ongoing Crumbley trial. She's a woman, and like many of them, she doesn't have big judge balls. You know who does have big judge balls? This judge. She has big judge balls. She has big judge lady balls, and she's great. She's like, I made a decision. This is what we're doing. We're moving along now. Please stop talking. This is my courtroom. Fuck you. You know, I'm like, yeah, this is it. This is great. So yeah, it's like, this is one of the things I hate, incidentally. Sometimes I get accused of misogyny, and I really, really hate it. I'm like, I'm not a misogynist. I say things because I believe them. If I'm like, this female judge is a piece of shit, it's not because she's female. It's because she's a piece of shit. You know, I'm like, this is bullshit. If it's, you know, it doesn't have anything to do with anything. It's like, yeah, this female judge kicks ass. She's great. She's in control. She's badass. I'm here for it. I love it. I wish more judges were like this. It's great. It's fantastic. She is my spirit animal. She's everything I want to be. Judge Ascarardi. She's a woman. She did great. You know, I disagreed with her at times, you know, but, you know, find me a judge I never disagree with. I mean, Judge Ascarardi was judging Johnny Depp for, what was it, 6 weeks? I mean, yeah, there were some rulings I disagreed with, but, you know, if I agree with a judge for 6 weeks straight, you know, something's wrong with somebody. I don't even agree with myself for 6 weeks straight. You know, I don't agree with myself 6 weeks straight. It's like, sometimes I don't even agree with myself as I'm rendering a decision as I'm speaking it, because I'm divided, right? It's like, you know, shit. So it's like, yeah, I mean, she's just a great judge. And the same thing with Becky. Do I hate her because she's a woman? No. I hate her because she's a narcissistic liar. She's a bitch. That has nothing to do with her being a woman. It has to do with being an asshole. This is like, you fuck this shit. Yeah, shit.
Not get any sealed exhibits.
What about NBC Universal?
No sealed exhibits.
Thank you, Moselle, for upgrading into $5.99. We do appreciate your upgrade membership. Welcome to the higher tier on civilians.
See that Netflix did get sealed exhibits.
They did it as an error. It wasn't
Whose
listed.
error?
Well, I would say the court reporter didn't mark it on the listing.
Well, why were you so accommodating to these national documentaries?
That Southern accent is high class? Sure.
Folks?
I know.
It's good for the book.
I grew up in the South. I get it.
The more documentaries out there about the Murdaugh thing, the better your book sales are. I mean, there was money in this for you, right? Again, it's about the money, right?
What's your question now?
Isn't it financially beneficial to you at the time to get more of these photographs out, more publicity, more Netflix, more
Thank you, Southern Mom, for the $4.99 super chat. We do appreciate it.
Books for you? Didn't you see a financial advantage?
Not at all.
Okay. Thank you. No further questions.
How do I feel about Judge Carroll? Yeah, exactly. We've criticized Judge Carroll all over the place. He's a weak ass pansy man with no balls. Like the two judges who preceded him. Judge Carroll, man, fucking loser. The two judges who precede him, asshole fucking losers. Yeah, they fucking suck. Yeah, they're all a bunch of bitches. And they don't have big judge balls. Yeah, we're even-handed over here, man.
Ms. Hill, you may step down.
Fuck Judge Carroll. Fuck the two judges who preceded him, too.
Let's hang on for a moment. Mr. Lewis.
She excused her subpoena. I just wanted to make sure she's now excused.
Well, I want her to step down. Yes, she's still under subpoena. I haven't heard what's going to be said. Mr. Harpootlian still has some things he wants to raise about other witnesses and so forth. So what I would prefer is that she remain with you, Mr. Lewis, until we see what else is going to happen. You may step down.
Yeah. Never holding back, yeah. Never hold back.
All right, Mr. Harpootlian?
Your Honor, we've got literally millions of pages of documents in this case. Ms. Miller just uncovered an email relevant to what you asked. We don't have it printed out. But what it is an email from Rebecca Hill to Miho Takachuchi, something. Miho, first names, the Buford McDowell body cam should not have gone to you. Please get rid of it. Do not use it. The judge, Judge Newman, specifically ordered that body cam not be used if it got out. Apparently, it's still on the videos we were saved. I appreciate your attention. What about what about the other body cam video we could see on many news documentaries? Can you provide it? It seems the camera was on the other police personnel. I mean, here she's having emails between this Japanese production company about body cams telling them to get rid of it. I think that's important, and I can have a copy of this printed out for you when we can get it to a printer for you for the record.
That would be fine, but do you want to offer it as an exhibit?
I do.
All right, Mr. Waters?
I have no objection. If I could just ask the date of that.
The date is July 17th, 2023. July.
Thank you, Mystery, for the 10 gift memberships.
Right,
we do appreciate it.
That's one thing. What else? I will admit it. I will allow it. That is a impeachment of her testimony to me that she did not send any emails or release anything.
Yes, Your Honor.
In fact, she changed that testimony on redirect when she said she did, so-called by accident, release some things.
It's so-called.
That doesn't appear to be by accident. So we'd like that to make
the judge
Secondly,
knows.
I have sitting outside the courtroom the clerk of court for Barnwell County, Rhonda McElveen. She specifically denied saying certain things to the clerk of court of Barnwell County and denied doing certain things. I think you're going to find her testimony extraordinarily instructive and educational, and it shouldn't take, I would be shocked if it took 20 minutes.
In light of the answers she gave to my questions and some of yours in that regard, I'm going to allow it. Now, I want to know what else we're looking at here.
See, the judge is pretty reasonable, right? It's like, I'm not going to hear what other witnesses you want till we're done with this one, right? So it's like, okay, so you want to bring them in as a rebuttal witness. Okay, yeah, that's pretty reasonable. Judge being reasonable. Judge is good judge. Judge is a good judge. Okay, I appreciate that.
Do we have only one copy of this?
You have the original.
Judge is like, okay, what else? Jen, thank you for the gift membership. Do appreciate it. Thank you. Just a reminder, everyone, memberships are only 99 cents a month.
Affidavit from a witness we would propose to provide in addition to clerk of court. This is a alternate juror, not the egg lady. This is the alternate juror who was dismissed when she was not needed for deliberations. And she is here also ready to testify. And I would expect her testimony would take about the same time as one of those jurors this morning.
Sir?
I would expect her testimony would take about as much time as one of those jurors this morning.
This is your offer in refutation of the testimony Ms. Hill has given today.
She denied saying any
She
of it.
denies saying anything. That's correct.
Yes, Your Honor.
Now, is this juror, alternate juror, going to testify?
She's here. Yes, Your Honor. She's sitting.
Well, you just say she's here. She's available.
Yes, ma'am.
All right, Mr. Waters.
Your Honor, a couple things on this particular alternate juror. We've just been handed this particular affidavit. Your Honor, I believe that Your Honor had correctly ruled that the focus again was on those jurors, and the inquiry has been made to those particular jurors. I don't know why we would go into detail with an alternate juror that ultimately did not sit in any deliberations and cannot testify as to any effect on the verdict, which is the ultimate inquiry before Your Honor. And so we would object to this particular testimony as far as it relates to the alternate juror.
Here's the one thing that gives me some heartburn, and you can help me with this, please. I stand by the rulings I have made that only jurors can be questioned about the effect on their verdict. And that is why I did not allow the testimony of the egg juror in that regard. He is now offering this testimony, and it's testimony of certain things that were said to the jurors as a whole, rather than just to this particular juror. And I would, as I say, I would ordinarily not allow this, but Ms. Hill testified several times during the course of her.
So the judge is going to allow this too because Ms. Hill's a liar? I like it. I'm so pissed at Ms. Hill that I'm going to do it because I can, because I'm the fucking judge. I can do whatever the fuck I want. I love it so great. I love this judge so much. I'm going to do it because I hate this woman so much. And remember yourself, it's a hearing. It's for the benefit of the judge. So the judge says, yeah, I want to hear from that witness. That sounds good to me. I'm here for it. It's great.
That she never told any jurors anything along the lines of what has been asked here, particularly the comments about they're going to say things that will try to confuse you or throw you off, things of that nature. She was asked about that, and she denied she ever said anything like that. So this is an attempt to impeach as I see it, and that's what's giving me a little heartburn about just turning him down flat.
Well, a couple things as to that, Your Honor. First of all, I think that we have some very specific statements and a specific individual that's mentioned here. And so if we're looking at Rule 613B, which is essentially where they're operating, I don't know that there was an appropriate foundation laid as to the specific time and to whom these specific statements were made. I think that it needed to be cleaner with regards to that as to, you know, mentioning this particular person and as much as you can, the time and place and the very specific.
If the judge says, I'm going to call this person as the court's witness, I will be so happy. That will be, it's like, I'm going to call this person as the court's witness. Just say the words. Do it. Do it. Do it.
Statements that were made. I think Mr. Harpootlian, again, we had these general allegations and kind of went through those, but I don't know that now that we've just been handed this affidavit, that they were set forth as an appropriate clarity that's required by 613B. So I think there's a failure there.
Mr. Waters, look for a minute at paragraph 3, 4, 5, 6, 7. Those paragraphs all address things that have been asked her, and they are pretty specific as to time and place. And the content of this testimony is an attempt to impeach her, Ms. Hill's testimony. That's why as I guess colloquially I said, I'm having a little heartburn about excluding this, is because she was asked directly about these matters, and this testimony would be in conflict with that, which would be permitted to impeach someone.
Right, and Your Honor, I certainly understand the point. I guess I would have just 2 points to that. Number one is that, as we've already talked about, this evidentiary hearing is within your discretion in the manner, particularly when you're talking about jurors and the manner to be conducting that. Now we're talking about putting a juror on the stand. And
Phil says, please take your own advice. When you made a point, stop talking. You keep saying stop talking. You've won. Game over and over and over again. Stop talking. Oh, Phil doesn't like me. Phil doesn't like me hammering the point home because of how incredibly stupid it is. All right, chat. You guys get to participate. All right, how many of you in chat are mad at me because I said the same thing over and over again when I was beating Mr. Harpootlian to death. How many of you were irritated? I kept saying over and over again, and how many of you were here for it? You guys can decide. Was the repetition too much, or was it working for you? What do you guys think? I'll take your comments in chat now.
Having attorney examination. And I think under the case law, that's within your discretion as to how that inquiry should go, as opposed to were we purely in a trial setting and applying the evidentiary rules. But if we were applying the evidentiary rules, again, strictly applied, I think I don't know that they have laid the foundation with enough clarity to offer extrinsic evidence under 613B, and that would be our argument there, that we just had generally discussion of some of these concepts, but not the place, time, and person to whom it was made with the specificity that 613B requires. So that would be our evidence.
Yeah, the chat seems to disagree with you.
Your Honor is
Phil.
addressing those. So that would be our position. I do also, before we get started, I do want to go back and address the sealed exhibits issue whenever it's appropriate.
Sure.
If it's now, I'm happy to go.
All right. Mr. Harpootlian, slow for a minute. I'm turning to Mr. Waters to try to get some clarity about why he objects to this testimony. One is the 613 issue that he's explored, and I understand that. He now wants to say something about the sealed exhibits. So I want to hear from him on that, and then you can reply to both of them.
I'm sorry, Your Honor.
That's all right.
Distracted by Mr. Barber.
Sure, I understand.
And finally, going back to the juror issue, we would also raise 403 as well, just because of the nature of the inquiry that we're here to assess. Going back to the sealed exhibits, I just want to clarify for Your Honor, Mr. Griffin and Mr. Harpootlian were at this hearing. After the trial, there was a release of, and these were publicly filed exhibits, of a number of exhibits. What also got released at the time were 2 body cam exhibits, which had images of the victims at the scene.
Thank you,
those had inadvertently not been marked as sealed
82. Appreciate your 99-cent Uncivil for 7 months.
For Judge Newman, and essentially those were clawed back. And so I just want to be clear that when we're having testimony about that particular thing, as it relates to what Ms. Hill was saying, those were the sealed exhibits that were released. And again, at the time, they had not been marked sealed, and that was sort of retroactively fixed. And then the other issue, of course, is, Your Honor, is again that the issue that Judge Newman was talking about after sentencing was a gallery photo. It was not a what apparently would be maybe a press photo of the exact exhibits. And what we did at trial, and Mr. Harpootlian can speak to this, and Mr. Bender could as well, is at the end of each day, first of all, the sealed exhibits would have a cover sheet or a folder that they would be in, and then they would verify with the parties that these are the okay exhibits, these are the sealed exhibits, and then at that point, after court was concluded, the media would then be allowed to review and or photograph or get copies of the unsealed exhibits. So that's just how the procedure was working at the trial.
That's very helpful to clarify this, because I now see this in perspective, that there were that the materials that were photographs at the scene or depictions at the scene of the 2 victims. What you're telling me is that those were inadvertently released after the trial by, I guess, it would have to be by the clerk of court. She's the one that had them, and then they weren't properly marked, and they were then clawed back.
Yeah, they were the 2 body cam videos, and so in those videos, it weren't physical images, but they were the body cam videos, and then in those videos you could see the victims at the scene. Right. And those 2 exhibits, to my recollection, were the only 2 that should have been sealed, but they, in fairness, were not marked sealed, and that's how they got released. The second we realized it was a problem, we took care of it and clawed those back.
Well, that clarifies that issue for me, so I frankly, that puts my mind at ease about what happened there. Now, Mr. Harpootlian, I'll come to you momentarily. Anything else?
No, ma'am, Your
Honor. Okay, now, Mr. Harpootlian.
A couple of things I point out. The first is this: in terms of the statement by this alternate juror, she was interviewed by SLED on video, said exactly the same thing as she's saying in this affidavit weeks, if not months ago. So they know exactly what she said. I can assume they reviewed it. By the way, I asked basically read from this affidavit as I cross-examined the clerk, and she denied each one of these statements. The second piece of that is this.
I know, it's on that basis that I'm even pursuing the idea of your offering something by way of impeachment, so I understand that.
And secondly, as to the sealed exhibits, I think we're going to hear testimony from Ms. McElveen that may elaborate on your concerns based on our interview with her this morning.
All right. Well, here's what we're going to do. It's about 3 minutes of 3, which is when I generally take my afternoon break. I'm going to adjourn the court, or recess the court, and we come back at 3:15, and I will allow you to offer Ms. McElveen and the alternate. I want to make it clear that they will be offered on what we've talked about, matters about which Ms. Hill testified that you think are impeached by Ms. McElveen's testimony and that you think are impeached by the alternate juror's testimony. So and the alternate juror's testimony, as I look at it, is the part about which impeachment would lie would begin at paragraph 3.
Yes, ma'am.
So do you understand what I'm saying?
Yes, ma'am. Can I make you one other offer?
Yes, sir.
Today and today only. Egg Lady is across the street.
Well,
no. If you want to put her on the stand.
No. I've made my position quite clear about that. I think we've got in the record what is needed in terms of
Egg Lady's across the street.
What she says, Ms. Hill says, and what Ms. Hill says she says.
I agree. We did not intend on calling her. I just didn't want you to miss the opportunity if you wanted the opportunity to examine her.
Thank you, Mr. Clark. All right, court will be in recess until 3:15.
Judge is like, I'm good. All right, let's see what else we got.
Say your name again for the record, please.
Ronda Milsap,
And Ms. McElveen, what do you do for a living?
Clerk of Court and ROD for Barnwell County.
Clerk of Court in what?
Register of Deeds. I have 2 titles.
2 titles. And is that an appointed or an elected position?
Elected.
So you're elected by the people of Barnwell County?
Yes, sir.
And how long have you been the Clerk of Court of Barnwell County?
This is my 16th year.
16 years. And
I'm running again, sir.
You're up this year? 24 is?
Yes, sir.
All right. Don't think I'm allowed to plug that, but you have been the clerk for 16 years. You're up again this year. Now, do you know the clerk of, well, back up for just a second. Do you hold any position with, is there a state organization of clerks of court?
Yes, sir. I'm actually the president of the South Carolina Clerks of Court and Register of Deeds.
Okay. And that means that of the 46, there are 46 of y'all, is that
Yes,
right?
sir. Yes, sir.
And you were elected to be the chairman of that group?
President of that group.
President of that group.
Yes, sir.
Now, are there certain rules and constraints that clerks should operate under in terms of dealing with juries?
Yes, sir.
And is there training for that, or is there a book for that, or how do you learn that?
You have the Clerk of Court manual for one that's on the judicial website. You also have the law books that have it in there. There's actually 2 separate forms, SCCA 237 and 238 maybe, that has regulations on it. And then we also have in the handbook or not handbook, but in the program within the CMS system, they actually have rules and stuff there you can go by as well.
Now, as a clerk of court, are part of your duties to deal with juries?
Yes, sir.
We understand there's a jury venire that's brought in at the beginning of a term, and then individual juries are picked for both civil and criminal cases. Is that correct?
That is correct, unless it's a non-jury trial.
And then there's just a judge, like we're doing here, right?
Yes, sir.
And in the process of picking
Strictly
juries,
speaking, this isn't a trial court. It's a hearing, but we'll let it slide.
Who actually picks the jurors out of a hat, or however, whatever the process is?
Well, actually, the first process is you draw a jury by computers through the CMS system, and then summons are sent out, and then once we come to court, we usually do a roll call. We see what everybody's doing, what their jobs and everything, to help the attorneys to decide which jurors they would like to hit. They have so many strikes, etc. And then you call the names, and they have the strikes, and then that's your jury pool.
And then the judge will seat a jury in a jury box, like, although I've never quite seen a jury box that looks like that, but a jury box in a courtroom, right?
That is correct.
Your jury box in Barnwell County is like 2 rows of 7 or 8 people.
Well, I actually have a jury box on both sides of the courtroom, because I have the grand jury on one side when they convene, and then I have the petit juries on the other side when they convene.
Okay. And the jury, they're sworn by the judge, and then they're put in the jury box, and they begin to hear arguments and testimony and jury charges by the judge. Is that correct?
Well, actually, sir, where we do it, the clerk of court usually swears them in with the judge presiding over the whole deal.
Okay. Once that jury is sworn in, what is your role in terms of dealing with those jurors individually or as a group? Are you allowed to talk to them individually, to pull them out, to converse with them about your opinion about the case?
To pull them out of the trial while we're going on?
Yes, ma'am.
No, sir, we're not. If they're on a break, etc., or if they request to see someone, then we manage to, I'll go in with the door open, I'll say, which one of you needs to see someone? It might be the judge. And I said, hold on, and then I go get my judge. And so we've got a juror that needs to speak with you.
Do you converse with jurors about the merits of the case, by the merits, whether someone's guilty or innocent, or whether a plaintiff or a defendant should win in a civil case? Do you ever do that?
No, sir. About the most only thing I ever do is go in and count them and tell them I can count up to 14 without even using my toes. And then I might get their lunch order. That's it. And the doors are usually open when I'm doing that.
And you have bailiffs that sit with the jury or sit outside the jury room?
They sit outside the jury room, and usually there's one beside them in the courtroom in case somebody needs something. But usually they'll catch my eye, or they'll catch the judge's eye, and we'll get something handled.
Okay, so did you have any contact with the clerk of court of Colleton County prior to her being elected the clerk of court of Colleton County? Did you know her before she was clerk of court?
No, I did not.
Did you come to know her once she was elected clerk of court?
Yes, I did.
And was it a pleasant relationship?
It was.
And how did you come to be, and to cut to the chase, you ended up being in the courtroom during the Murdaugh trial for part of those 6 weeks, is that correct?
Yes, sir.
How did you come to be there?
When Becky and I met each other at a conference, clerk of court's conference, where she was discussing that she had that trial coming up, and I knew that she was relatively new, and I said, I'll offer to come help you if you would like. And I think she ended up talking to Judge Newman about it, and they both said, yes, it would be good that I was there.
Okay, because you tried a murder case or two in the past, correct?
Yes, sir.
Okay. And did you go and help Becky Hill try that murder case?
I did. I couldn't go for the first 3 days because I had court in Barnwell, and I told both of them if I had court going on in Barnwell, I could not be in Colleton County.
Okay. To your knowledge, had Ms. Hill ever been the clerk of court that managed a murder trial prior to this?
Not that I'm aware of, sir.
So this was her first murder trial, as far as you know?
As far as I know of this magnitude, I don't know if they had one before then or not.
Okay. Now, when did y'all...
He said that about the other juror. He didn't say that about this one.
How you did it.
He said 20 minutes for this one, so we'll see.
Yes, sir.
During that, before the trial, before we ever picked a jury, did she ever discuss with you that she was going to write a book?
Yes, sir. She wanted to write a book. Yes,
wanted to write a book. Did she indicate what the book was going to be about?
About the trial?
About the Murdaugh trial?
Yes, sir.
And did she discuss with you, what, if anything, did she discuss with you about how...
What, if anything? It's going to be a long time till that phrase doesn't trigger me. Oof. Oof.
She felt the verdict should turn out to be in the Murdaugh trial, vis-a-vis, in reference to the book. What would help the book?
A guilty verdict.
And tell the judge and me what exactly she said to you that you remember. This is prior to the trial.
Okay. Well, first of all, she said we might want to write a book because she needed a lake house and I needed to retire. And then further conversations, a guilty verdict would sell more books. And we left it at that. This was before, even in December.
And when did she ever say that again to you during the weeks you spent there?
Several times. It could be said it was, amongst friends in her office, or we might be having dinner, that kind of stuff, but that's about it.
That she needed a guilty verdict to sell more books.
That would be the best way to sell books, yes, sir.
The best way to sell books. Now, during this process, did she ever express to you an opinion on whether or not, in fact, was Mr. Murdaugh guilty of the murders of his son and his wife?
Yes, sir.
Tell me what she said, and if you remember when.
I don't exactly remember when. I know it's over half of the trial had already happened, but the evidence was coming forth that it looked like he might be guilty, and she made a comment that guilty verdict would be better for the sale of books.
Okay. Now, as a result of a conversation you had sometime during the trial, I don't want you to relay to me what was told you, did you have a discussion with the clerk, Becky Hill, about her being with jurors on her own?
Yes, sir, I did. One morning I showed up to Colony County, and I was told that she had taken a juror home the night before. And I was in the courtroom when I saw her, and it was between the pews and where the back row pews are. And I mentioned to Miss Becky, I said, please tell me you didn't take a juror home last night. And she told me, she says, I did, but I didn't talk about the case. I had a bailiff with me. Mr. Bill was with me.
Ooh. 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 Okay.
I said, Becky, you don't do things like that. I thought we had stopped everything. It wasn't far enough along to really cause a major problem, or I would have told Judge Newman. But I thought we had an understanding that you did not spend time alone with the jurors.
Okay. Now, I'm going to read you some statements. Well, first of all, did you ever hear her say anything in front of you to a juror about whether or not, on the merits of the case, that is, whether or not he was guilty or innocent, or what you should pay attention to? Did you ever hear her, what, if anything, did you ever hear her say to a juror or in the presence of a juror? Anything?
No, sir.
Okay. But let me ask you if you've ever heard her say these statements, and if so, to who?
Don't you have city buses in South Carolina? Fuck no. No. This is in the middle of fucking nowhere. Are there city buses? Fuck no. Shit, no. This isn't New York City. City buses? What the fuck are you talking about? Shit.
Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understand. Do not be fooled by the evidence presented by Mr. Murdaugh's attorneys. You ever heard her say that?
Your Honor, this time I would object. This witness was specifically called as a Rule 16.3b extrinsic evidence. I think we've covered the two grounds that would be permissible for her to testify to, and I believe that should be the extent of her testimony, so we would object to any further extrinsic evidence as improper impeachment and also irrelevant. I think that the issues that were raised with the prior witness have been covered, and that was the express reason that this witness was called, and Your Honor allowed the testimony.
Overruled. You may continue.
Did you ever hear her say that?
Can you repeat the verbiage?
Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys.
Yes, I did.
And who was it said to?
It was said to me.
Okay.
And sometimes there might be a staff member in our office or someone from the media there. But other than that, I didn't hear her say it out there in front of any jurors.
Did she ever say to you or to other people around you, I'm not talking about jurors, watch him closely, talking about Mr. Murdaugh, this is just before he testified, look at his actions, look at his movements. Did you ever hear her say that?
Yes, sir.
Okay. Did you ever have any conversations with the bailiff, Mr. Bill?
Yes, sir.
Did he ever discuss with you the court's contact with jurors?
No, sir.
Okay. Did you ever hear her say that the defense is going to try to confuse the jurors? Did you ever hear her say that?
No, sir, I don't think so.
Okay. Now, let me deal with one last area. Let me see if I can simplify this. There was a setup in the courtroom. Pardon me, I've got a little frog in my throat. And I'm fine, thank you.
I think I'll share my bottle over here if he wants part of it.
Once a cork, always a cork, Your Honor. And I was there, you were there, this judge was not there. And prosecution tables over here, defense tables over here, judges up here, and then there's a rail behind which the clerk was. And because of all the massive electronic equipment we had there with big screens, there was an area over on my right facing the judge. And then I think you were located in that area right between the judge and that area, is that correct?
Talking about in the well area?
Yes, ma'am.
Okay, yes, sir. For
Now,
the most part, now sometimes I was out there with the screen
right.
in the gallery.
Right. But there was a screen on which you could see not only what the gallery back there could see, but the images that only the jury was supposed to see that were under seal. Is that correct?
That is correct.
Now, there's a woman named Rhonda, the writer, correct?
Rich.
Rich. And tell me who she is.
At the time, we did not know who she was. The first time they were there, we didn't know. Then she came in Miss Becky's office the night before, and she asked if she could have another seat in the courtroom for the next day. And Miss Becky said yes. And she says, and what's your name again? And the only reason why I remember Rhonda, because of course my name being Rhonda. And the next day, Miss Rich was sitting, I don't know how to tell you, but she was sitting. Do you know where Doug was sitting?
Yes, ma'am.
All right. I know, Judge, you don't know where Doug was sitting, but anyhow.
But Doug was the audiovisual guy, and he had access to the unscreened, the unsealed images, correct?
Yes, sir.
And she was sitting right next to him, right?
Yes, sir.
Okay.
In that little part. And
so she could see the body cam, she could see the unredacted corpse pictures, the autopsy pictures, all the photos that the judge had sealed, correct?
Well, no, the only thing she could see was what was being put up at the time.
Right. But
Okay.
as they were put up, she could see them.
Right, but they tried their best to seal it where you couldn't, but you could still see it there. I didn't see any of the photos, okay?
But she could see them.
Right, and Doug was really having a problem with that. And I can also tell you that our court reporters didn't know who she was either, okay?
Okay, and she turns out to be a writer, correct?
Yes, sir, after I found out, yes, sir.
And her name is Rhonda Rich.
Correct.
She was given access to areas that only court personnel should have had access to.
Right, but then we broke, and then she moved her in the well with me. She was about on my left, and either Elizabeth or Mike was on my right. And I noticed she was taking notes. And I asked her what was she doing, taking notes. She says, I'm a Sunday school teacher. Well, I immediately covered up everything I had.
You don't trust Sunday school teachers?
So,
you don't trust Sunday school teachers?
let me just, there's too many preachers in my family on both sides, okay?
So You determined she was not a Sunday school teacher, and later learned that she was a writer writing about the Murdaugh case, correct?
Now, I don't know if she's ever a Sunday school teacher or not. There's just, I don't even know where she goes to church or anything, so I can't tell you that answer. But I did find out that she was a writer because shortly after she was put there, and evidently after I covered everything up, shortly after that, Judge Newman asked for a recess so we could find where people were going to be working. And that's when she put Miss Rich out in the gallery in control of that screen.
And she ended up writing the foreword to Becky's book, is that correct?
Yes, sir.
Okay. And Becky gave her access to area only court personnel should have had, is that correct?
That is true, but now I'll be honest with you, sir, there's been a couple times when we had other people that were sitting on that side. We weren't planning on seeing sealed documents that day.
Right.
But there were some other people that sat there, but nobody that actually sat in the well that wasn't court people.
Okay. Thank you, court's indulgence.
Mr. Waters, on cross-examination.
Thank you, Your Honor. Just if I could have 1 second.
Oh, okay.
Judge, do you have an extra bottle of water up there by any chance you're willing to share? Oh, Miss Elizabeth Scott's one, thank you.
Great.
Ms. Buckley, how you doing today?
I'm good, sir. Please call me Rhonda.
I always called you Miss Rhonda. I've known you for a long time as well. In fact,
Yes, sir.
I tried one of those murder cases in front of you years ago. Right.
Yes, sir.
Wanted to ask a couple things. I won't be that long. One of the things that you said earlier is you said when you initially were talking to Miss Hill, she said something like, we ought to write a book or something like that.
That is correct.
Okay. And so did y'all have any further discussion about you writing the book or participating with the book?
Oh, no,
like
sir.
that?
I'm crazy enough not to write one.
Okay. During the course of, though, after the trial, she did send you like chapters and things like that to take a look at.
I did get to see a couple of drafts of the manual.
Okay, so she did send you those to take a look at and review and that sort of thing. Is
Correct.
that correct? Okay. All right. And you were asked, and again, Your Honor, just to be clear, I'd made some objections.
You do not waive any objections by cross-examination. They are all preserved.
Thank you, Your Honor.
You may proceed.
Thank you, Your Honor. You mentioned, some statements that you attributed to Ms. Hill, during the course of conversations during the course of the trial. Is that correct? Just things like watching closely, watches mannerisms, things like that. And where were those conversations? Were those conversations taking place back in the clerk's offices with the clerk staff and people like that?
Yes, sir, in the clerk's office. It might have been downstairs in the bathroom.
Okay.
Some of us had privilege to go to.
All right. So you and Miss Becky and other court staff maybe just discussing the case and that sort of thing. Is that correct?
That is correct.
And people were expressing their opinions about what was going on and that sort of thing. Is that correct?
Now, when we were having those discussions, there weren't more than 1 or 2, maybe 3 people there.
Okay, but just a few people there just talking back behind the scenes. That's what I'm
Correct.
driving at.
Yes, sir, behind
it
the
was
scenes.
behind the scenes, and it's not uncommon for clerk staff behind the scenes, not to the parties, not to the litigants, not to the jurors, but among themselves back in in the hallways back there to talk about the day's activities and things like that. Is that fair?
That's correct.
Okay, and that's a big difference between the natural conversations that people that work together, court staff and the like, have with each other, and actually having those conversations in front of the jurors, right? There's a big difference between those two, correct?
Yes, sir.
Okay, and it's not uncommon for you. You're a clerk of court. You got people that work for you. Y'all are going to have private conversations about what's going on that are not to be shared, particularly with jurors, but with the public as well. Is that fair to say?
That is true.
Okay. All right, and so there were conversations like that going on that you were privy to and part of. Is that correct?
That is correct.
Okay. All right, and you mentioned a little bit about, well, let me ask you this. So there are all these conversations going on, and that's natural. That happens, private conversations with court staff behind closed doors. But you never once saw or observed or had anyone tell you that any of those conversations were being shared by Miss Becky with any juror. Is that right?
That is correct.
All right, and if that had happened, if you had observed anything untoward or improper going on at this particular trial, you would have immediately gone to Judge Newman as part of your obligation. Is that correct?
That is correct.
And you never did that because you never observed anything like that. Is that correct?
That is correct.
Okay. All right. Now, you were asked a little bit about Rhonda Rich, who was a member of the media, and how she was placed kind of back where the defense IT guy was. Is that correct?
I didn't say she was part of the media, sir.
Okay, well, she was a writer.
Yes, sir.
Okay. All right, and then you said that that eventually, though, Judge Newman stepped in, and then she was moved out into the gallery in charge of the screen out there. Is that
Right, but I don't know. I thought Miss Becky moved. I'm not saying Judge Newman did.
Okay. All right, and over there in that area of the, if we look in the courtroom, there was sort of the grand jury box over here, and that was where court TV was and media was stationed and that sort of thing. Is that correct?
That is correct.
All right, and inevitably there were media members that could view some of the images that were being shown. They were just not able to report those just because of the nature of where the courtroom was. Is that accurate?
Well, I was told they couldn't see it, so I don't know what they actually saw because I didn't discuss it with the media.
All right. You never had a conversation with court TV or anything like that?
Other than the fact that be careful what they put on my front page of the New York Times on me.
All right. All right. And you're not aware of any image or confidential information or sealed image or anything like that that was ever made privy to Miss Rich that was put in any sort of publication or anything like that. Is that correct?
Not I'm aware of, sir.
Okay. Because if you had found out about that too, you would have immediately gone and reported that to Judge Newman because you would have said, that's improper. That I need to go report to the judge, correct?
Correct.
And you never once saw anything during the entire course of this trial that caused you to say, you know what, I got to go talk to Judge Newman. Something ain't right about what's going on here. Is that correct?
That is correct.
And you would have done that without a doubt if you had seen that, correct?
Yes, sir.
All right. Now, in looking at, back at this trial, you mentioned that there was a few days at the beginning of trial that you weren't there because you had your own court to take care of back in Barnwell County, correct?
Correct.
All right. And then pretty much after that, I guess you were pretty much present the majority of the remainder of the time. Is that fair to say?
I was. Okay. I had one medical procedure done. I missed 2 days, but basically other than that, I was there every day.
All right. And there was a period of time, though, during the middle of the trial where Miss Becky had a medical issue and had to be absent from the courtroom for about a week or something like that.
That is correct.
Okay. And during that period of time, you were present and functioning as the lead clerk of court during that period of time.
That is correct.
All right. So the reality is that you were present for probably as much, if not more than anyone in the clerk's function during the course of this trial. Is that fair?
Yes, sir.
Okay. And again, just to reiterate, there was not one time that you observed or came in possession of any information that you were like, I got to go talk to Judge Newman about this.
No, sir.
All right. Court's indulgence, 1 moment.
Very good. Mr. Harcourt, then?
Half a question.
All right.
Mr. Waters indicated to you that you were not aware of whether or not, and you agreed that you never witnessed her talking to a juror about the evidence. Is that correct? We agree on that.
Correct.
Do you know, but she did admit to you that she had been with a juror alone in a car for some period of time when you confronted her with that. Is that correct?
Yes, sir.
And did she indicate to you what she talked to that juror about while they were alone in the car?
No, sir. She told me, the only thing she told me was that she did not discuss the case, that she had Mr. Bill, the bailiff, with her, and he could tell her that. Tell that.
And when she said she didn't discuss the case, did you bring that up or did she bring that up?
She brought that up.
You didn't say shouldn't be with him because it's frowned upon?
I did tell her that I would caution her on doing that because the perception of dealing with the jurors one-on-one is not tolerated.
Is not tolerated. Thank you.
Thank you, Ms. McElveen. You may be excused.
Thank you.
All right, Mr. Harpootlian, call your next witness.
Your Honor, we would call Juror 741.
I know you're not going to. Well, that's right. She's an alternate. That's all right.
We're not going to sign her a letter. We're going to go with 741.
I got you.
And Your Honor, while she's coming, my understanding is I'm limited to 4 questions.
Yes, sir. I have a copy, and I have given the court reporter a copy of this affidavit with the name obscured and the number, I think, as well. So, but the affidavit that supports this testimony that you're about to offer is Court's Exhibit 5.
Other than a little
The background about her getting picked for the jury and how long she was on the jury and
That's
then she
fine.
got excused. That's all we intend on asking these 4 questions.
All right, sir.
Unless Mr. Waters asks.
Sure. I mean, they'll have cross-examination.
I'll be crossing, so.
He will definitely open the door.
That, all right.
He's limited to the 4 questions initially, is that?
Yeah.
No, sir. He's just telling me that's what he intends to do. Sometimes you can hold lawyers to that, and sometimes you can't, Mr. Miller.
Yes, ma'am. Thank you.
I intend on only asking her those 4 questions.
That's fine.
It doesn't have to be.
In the building.
Yeah.
The numbers?
Yeah.
Let's skip ahead.
About to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please have a seat on the witness stand.
Your Honor, I assume the same rules apply to her that apply to the other jurors in terms of her image appearing.
That's correct. There'll be no photograph made of this particular witness who was an alternate juror in the matter.
Well, too late for that. She appeared on video. Too late for that.
I'm going to refer to you as Juror 741. It's what we got to do here so we don't use your name so people don't know who you are.
Well, we showed her on video, so that's over.
And you and I have met before.
Correct.
I came to your home one Sunday afternoon. I believe you're cooking Sunday dinner, and we talked. Is that correct?
Correct.
And then you were interviewed by SWED.
Correct.
And you gave them a recorded statement. And then this morning you came here and you gave me an affidavit that you signed, and you're here with your lawyer. Is that correct?
Correct.
Now, just for purposes of the record, you were a juror. You were selected to be a juror on the State versus Alec Murdaugh murder charge, correct?
Correct.
And you sat in the courtroom for 6 weeks and listened to all the testimony.
Correct.
And you were the alternate.
Correct.
And so when the jury went out to deliberate, you were excused. Is that correct? Now, I'm going to go through a series of questions based on your affidavit, okay?
Okay.
Which you signed this morning, which was based on our initial interview with you and your interview with SWED. This is basically the same thing you told SWED. Is that correct?
Correct.
In your affidavit, you say, before the defense put up their case...
Leading.
Sir?
Leading.
Overruled. Go ahead.
Thank you. In your affidavit, you said, before the defense put up their case, Ms. Hill told the jurors, quote, the defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off, unquote. Is this true? Did Ms. Hill say that?
That's exactly what she told us.
I'm sorry?
That's exactly what she told us.
Okay. The next thing you say is Ms. Hill made the above statement warning the defense would try to confuse us in the presence of all the jurors as we assembled in the same jury room. Is that correct?
Correct.
Now, y'all were initially in two jury...
We was in 2 separate rooms, and when she came in, we all went in one room.
Okay. Paragraph number 5, Ms. Hill said, if you get emotional, we want to see your face because that is what they want to see. What does that mean?
She said, don't get nervous. Don't be afraid to show your emotions because that's what they want to see.
Who wants to see?
I don't know who she's speaking of. I'm assuming the court.
Okay. And then number 6, Ms. Hill also informed us Alex Murdaugh was going to testify, but I don't recall exactly what she said. All the jurors were assembled in one room when she made that comment.
Exactly.
She told you that Alex Murdaugh was going to testify.
Exactly.
Did you know before that he was going to testify?
I think we knew that he was going to come up. I think he was supposed to do it the day before, but he didn't. And I knew he was going to be the last person that afternoon.
Okay. During the visit to Moselle, juror number 826 and I walked to the scene together. Then juror 826 began walking with the clerk of court, Becky Hill. I could tell they were talking. I could not hear what was said between them. Is that correct?
Correct.
The only thing that makes it possible, the only thing that makes the stream possible is the badass microphone with the orange tip and the boom arm. all hail microphone. All hail boom arm. I might be getting slightly punch drunk, as they say. Shit.
Yes, sir.
And this is what you told us back in
I don't remember.
August, I believe. I think I interrupted you cooking Sunday dinner.
Right.
Thank you, Billy Mamazilla,
Right,
$6.99.
Any questions defense may have for you?
Mr. Waters, or Mr. Meadows.
Thank you, Your Honor. Please, Your Honor. Good afternoon, Ms. 741. It's nice to see you again.
Yeah.
I'm live. The court's
It's the first
not.
time you talked to Mr. Harpootlian or Mr. Griffin or any other attorney?
I can't tell you exactly. It's been months. It's probably been September, August. It's been months.
Okay. And were they the first attorney to talk to you, or was there somebody else that talked to you prior to them? Any other attorney?
No, I think he was the first person I talked to.
You sure?
I think. It was so many people trying to call me, and I was trying not to be involved, so I can't quite remember. But he was the first person I'd seen.
First person in person?
Yes.
Okay. So when he came to your house?
Yes.
Mr. Harpootlian came to your house?
Yes.
Okay. And at that point, was Miss Holly with him? Holly, do you mind raising your hand? You see Miss Holly?
Yes.
Okay. And was anybody else with him?
Yes. He was.
Mr. Griffin?
Mr. Griffin.
Thank you. And you gave them a statement then, right?
Right.
Okay. And did they record you? I mean, were they audio or video recording you? Did they say we'd like to record this?
No.
They didn't?
But neither did the people that came out. They didn't. I didn't know I was being recorded by them neither.
I'm not trying to fuss.
Oh, okay.
But is there an audio recording of your conversation with them that you know of?
No.
Did they say?
Not that I know of. No.
Okay. So you don't remember them saying?
No audio recording. We're required to tell her for recording her under rules. We didn't record her.
He's on cross-examination. Mr. Maddox?
Thank you, Your Honor. And at that point, and that was again, do you remember, you said you think, was that around the end of August, 1st of September when they first came and talked to you? Roughly?
Roughly. Okay. I don't want to.
And you told them basically everything that you've told us now, right?
Yes.
Exact same thing?
Exact same thing that I told them.
Nothing less, nothing more?
Yes.
So Mr. Harpootlian, just, and you didn't sign an affidavit back in September, or when you talked to him the first time?
No.
And why not?
Because he was just coming out to talk to me. He just was asking questions. It wasn't nothing officially. He had, so.
When you say nothing officially, I don't know what you mean.
He didn't. He was just coming out to ask. He was just asking questions about what went on during the trial. It wasn't.
Well, did they ask you to sign an affidavit that
No.
night? Okay. Did they ask you to sign an affidavit any time right after that?
No.
So they never asked you to sign an affidavit until this week?
No. I was supposed to meet with them a couple of occasions, but I was having my own personal issues and I couldn't come.
Okay. Well, I'm sorry about that.
No problem.
So you told them at this first meeting, back at the end of August, 1st of September, that y'all going to hear some things that will throw you off. Don't let it distract you or mislead you. Is that what you said?
That's what, I didn't say that. That's what the clerk of court told me.
Yeah, I'm saying that's what you said to them. I'm sorry. Okay, and where did that take place?
She would always stand like on the outside of the jury room, like in between, like on the outside. She would never really come inside the jury room.
So you were there were 2 rooms, right?
Yeah.
Okay, one room, and then the other room separated, correct?
Right.
And you couldn't hear people talk in the other room, could you?
No, that's why when she came, everybody came in one room.
Okay, so this comment you said she made, did she bring everybody out in the hallway?
Some people was in the hall. That's why I said she was standing right at the head of the door.
Standing at the head of the door.
Right.
Was Mr. Bill there? Your bailiff?
Yeah, he would be standing in the hallway.
He's all out there, right?
Right.
And then she said in front of everybody, the defense is about to do their side. They're going to say things that will confuse you. Don't let them confuse you or convince you or throw you off. She said that to everybody.
She said that to everybody.
So everybody could have heard.
Everybody could hear it.
And you said you were all in the same jury room.
Yeah, we would all be in the same. When she came, she was standing in front of the door with the jury room that I was in, and everybody would come over. They would let us know before she came, they'll let us know like after lunch she gonna come talk to y'all, and we all would gather together.
So would you go from the 2 rooms into one room?
Some would be standing out. She would stand in front of the door. Some would be standing around her outside the door, and some would be in the room. But it was clear enough for us to hear and see her.
And Mr. Harpootlian led you, and Ms. Hill made the above statement warning that the defense would try to confuse us in the presence of all of the jurors as we had assembled in the same jury room.
We was all in the same jury room. She would be on outside the door, and we would be in the room, and someone would be standing beside her. We was always all together when she came.
And do you think that was unusual?
No, because I guess she didn't want to walk back and forth to room to room.
No, the fact of what she said. Do you think that was unusual?
Yeah, I did.
And if you get emotional and see his face, they want people to see your face?
Because some of the jurors was getting emotional, and I guess she noticed it, so she commented on it.
And you said you didn't. The statement he read, she informed you that the defendant was going to testify, but don't recall exactly what was said.
After, I can't.
When was that?
That was, I think he came in that afternoon, like at 2:33. So that was before he testified, I think.
And where was it?
Oh, in the jury room. Where we were all, like I said, we would all meet.
And I guess what I'm saying is you're in 2 different rooms for a while, right? When y'all get up there, you split, don't you?
Yeah.
The people that talk loud in one room and the others in the other one? Pretty much.
No, it's not like that. It was just, they just split it off. They just asked us what room we wanted to go to.
So when you were fixing to come back to the jury room, to the box, you tell us you'd all go into one jury room together?
Only when she came to speak to us.
And Mr. Harpootlian asked you about, I believe, number 7 on the affidavit. And when did you sign this affidavit?
This morning.
Okay. And when's the last time you had talked to Mr. Harpootlian?
No, I haven't talked to him since he came to my house.
Are any of them before today?
No, I haven't talked to him since he came to my house.
Talked to anybody else involved in this case before today, since then?
No, he was talking to my lawyer.
Okay, and who was that?
Sean Wilson.
Okay, and when had Sean Wilson talked to you?
He's been my lawyer.
Since when?
Since 2021.
Okay. When Mr. Wilson talked to you about this case and what you told Mr. Harpootlian prior to...
All right. They apparently don't object to this, but I am very uncomfortable with your asking what her lawyer told her.
And I wasn't going to content. I was just looking for timing.
Well, she's told you a couple of times that he was her lawyer since 2021.
Well, see, you're a lawyer for this.
For what you mean for this?
Well, like being a juror.
For being a juror?
Yes, ma'am.
I didn't have he was always my lawyer.
Okay. You didn't hire him for this?
No, I didn't hire him for this.
Okay. But he had talked to Mr. Harpootlian about your affidavit and your testimony today, hadn't he? Is that a yes?
Yes, he was looking over the paperwork. He was looking out for me because he's my attorney.
And when was he looking over the paperwork?
Oh, I guess ever since September, October. I wasn't really keeping up with it to be honest, because I'm.
So do you know if he's talked to Mr. Arpulin this week?
Yeah, he talked to him today.
Talked to him today?
We was together.
Who was together?
Me and my lawyer.
And Mr. Arpulin?
Yes, when I went to go sign the affidavit.
Okay. Where'd you sign it?
What the fuck are you talking about right now? What the fuck are these questions?
His office.
In whose office?
Mr. Hopper office. I was supposed to.
I would object, Mr.
Okay.
This meandering, I mean, there's no jury here. It's you. And I don't know what this is.
How about helping a little bit? I think we got all the information. Yeah, all right. I think he's going to move on.
Thank you.
Yeah.
Negative 42C and F are not equal.
And
Bad
that's the last
information from
question Mr.
McRib
Arpulin asked you
enthusiast.
about that.
Bad information.
What was the last question?
Dun dun dun.
During the visit to Moselle jury.
Fake. That's some fake news.
It doesn't matter.
Fake news from McRib enthusiast. Fake news.
Now I walked the scene together, then the juror began talking with the clerk of court. I could tell they were talking, but I couldn't hear what they were said between them. That's
Correct.
the last question he asked you, right?
Correct.
So, and you have no idea what that conversation was about?
No, I don't.
Now the next, number 8, he didn't ask you about, was I also overheard discussions in the jury room that Mr. Hill drove a juror home. I believe it was a juror whose nickname was Boston. Now he didn't ask you that a minute ago, did he?
No, but
Just
okay.
yes.
No.
And you didn't include that in the first conversation you had with them back in August and September in this affidavit. Miss Holly did you? You didn't tell them about that?
I can't remember.
Have you seen the affidavit Miss Holly did for you back in September 1st,
Objection, Your Honor.
2022?
Ms. Holly did not do an affidavit. Ms. Holly
She
did
just
her affidavit, her notes of what this young lady said to her, and what she included and didn't include was based on what Ms. Holly thought was relevant at the time, but she can't be
That
cross-examined.
affidavit's not in evidence, Mr. Meadows, so I think you need
We'd
to
offer
move.
it, Your Honor.
Sir?
I'd offer it.
No.
Just to,
Well, how is this thing going to be authenticated?
You know, even more importantly, he can't question her. I'm sorry.
Several people can't talk at one time. I don't even have the affidavit. Let me see what you're talking. You talking about the one that was just offered today?
this is one Holly did when he first talked to her back in August, and she's referring back to
Miss Miller. Okay. Miss Miller.
This is Ms. Miller's affidavit about what she thinks this juror said.
Yes.
I'm not going to allow this, Mr. Meadow. I don't see a whole lot of difference between this and what's been said in the affidavit that has been offered by Mr. Waters, but I'm not going to allow that.
Okay, thank you.
Good call, Judge. Good call.
You did not tell them about hearing that Miss Hill had driven a juror home back when you met with them in September, did you?
I can't remember.
Good call, Judge. You made the right legal decision. Good job. The judge may know what they're talking about, just, some context clues. I'm not sure I've seen her make a manifestly bad ruling yet. I'm not sure I can really point to any ruling she's made that I disagree with. I could dig into the green thing, I guess, but that would require probably a lot of analysis. Yeah, all right. Well, I'm not doing it tonight. I'm telling you that right now.
Who is Boston?
She was a juror on the On the trial, I don't know her, but that was the nickname they gave her. I don't know her first name.
And what, if anything, did you know or convey about Boston?
She was a juror on the case, just like everybody else.
Anything else?
Nothing.
Ma'am?
No.
Okay. So again, Mr. Harpootlian didn't ask you, but when you, in the affidavit of today, I also overheard discussions in the jury room that Miss Hill drove a juror home. I believe it was a juror whose nickname was Boston. Is that something was added after your lawyer was with Mr. Harpootlian today?
I don't know if I added it. We talked about it today, but I don't know if I mentioned it in September or not. But I know
we've ever talked about it, wasn't it?
Your Honor.
No, it's not.
No reason to raise objection.
The first thing is, Mr. Meadows, I'm going to caution you one more time about this. You cannot talk over a witness. The second thing is, you don't need to be marching all back around here. You talking only to me, not the jury or anything else. So let's slow down, and this is repetitive of questions that have been asked before. If you want to take this tone with her, I don't know exactly what you're trying to accomplish.
I'm not trying to take tone. I apologize. She knows that, and I'm sorry.
Well, you're just talking to me. This is not some drama thing for the jury.
I know. I'm sorry.
All right. Well, let's finish this thing up.
The only reason I did it, he hadn't asked about it, and it to me is the key issue here. They're trying to say was different.
Mr. Meadows, I mean, you lecturing to the witness or to me or what? Please don't do that. Strike that from the record, please.
Don't strike. Don't strike. I'm so sorry.
Let's line this up.
All
right.
Judge just slapped you down, man. Judge just slapped you down. That's worth a price of admission again. I want to watch that moment. That was good. Judge just bitch slapped you. Who are you saying that to? The witness? To me? Strike that. Fuck you. Woof. Yeah. I want to see that again. That was good.
The issue here they're trying to say was different.
Mr. Meadows, I mean, you lecturing to the witness or to me or what? Please don't do that. Strike that from the record, please.
Don't strike. Don't strike. I'm so sorry.
Let's line this up. All right.
What does he say? Don't strike?
Do that. Strike that from the record, please.
Don't strike. Don't strike. I'm so sorry.
Let's line this up.
Fuck you. I love it. Who are you saying? Yeah, this is the key issue. Who are you saying that to? The witness or to me? Fuck you. Shit. I love this judge. I love this judge so much. You reign, queen. You reign. I'm here for it. I'm here for it. Bitch slapping people around. I love it. It's great. Did he say don't strike that, please? Just like, fuck you. Shit.
In number 9 in the affidavit, that before the jury began deliberating, I heard a member of the court staff say the deliberation shouldn't take long. I don't remember specifically who made it, but it was made in the presence of the entire jury right after closing arguments in the jury room.
I also loved it, like, what tone you're taking. I'm not taking a tone, and she knows that. Yeah, I love that line from the lawyer. That was great. I don't know what kind of tone you're taking. He's like, I'm not taking a tone, and she knows that. I'm like, does she know? Does she know that? Because I'm not sure that's true at all. It's like, woof.
Correct.
Then I think you said something, Judge Newman came to see you afterwards, but after the jury went to their room, you were in a separate...
No. When we first left out the courtroom, we all went in the same jury room. And then they separated me.
And Ms. Simply, when I didn't mean to raise my voice.
Oh, that's okay.
I apologize.
That's fine.
But when they started deliberating, were you in a separate room?
Yeah.
I'm just here for it. If the judge at some point be like, yeah, you're done with your examination now, that'll be good. Like, if he loses it again and the judge is like, yeah, you're just done. Stop talking. Sit down. Your examination's over now. That'd be good. That's the only way this can get any better.
When they started deliberating.
So you had no involvement in the deliberations or verdict of Richard Alexander Murdaugh?
No, sir. No, sir.
You didn't get to come back with the verdict, did you?
No, sir.
Have you read Miss Hill's book?
No.
Okay. And I noticed your interview. I did watch it. And I think Mr. Radford back there, you can raise your hand, kind of, Radford, I think came to your place and interviewed you.
Right.
At some point during the trial, I think there was some discussion that somebody might have wanted to do an interview with you.
Yeah, that's what she said.
Okay, and then after the trial, I think there was some discussion, somebody, since you weren't on the jury, they may not have wanted to interview you. You remember that, roughly telling the officer that?
Yeah, that's not what she said. She came to me roughly in the middle of the trial, and she said, I have a few people who would like to interview. She said she didn't say a few. She said, I have a lot of people that's inquiring to interview with you. She said, but I'll have to get with you after the trial. But after the trial, she came back in the jury room, and she started handing out cards. And she handed everybody cards but me. And she was like, I don't have any cards for you for an interview because no one wants to speak with you. That's what was said.
And did, I mean, you weren't happy with that, were you?
Yes, I was.
You were happy with that?
I don't need to be interviewed.
Dave Corsico.
Yeah, I like that. You weren't happy with that. Yes, I was. I like that so much. It's such a great thing. You weren't happy about that. Yes, I was. You were happy about it? I didn't need to be interviewed.
Briefly, Your Honor. Mr. Meadows just asked you a series of questions that I'm not sure I'd heard before. Who approached you during the trial and indicated the media would want to interview you?
Miss Hill.
Miss Hill?
Miss Hill herself.
Just you or all the jurors?
They had, I think it's the day they had the bomb threat, and I think that was the day. And she approached me.
You?
Me, by myself.
By yourself. And where were you?
That's the day in the lunchroom when they had the bomb threat. We went to the middle school. I believe that was the day.
The middle school. And she came over to you and said what?
That she had some reporters that was reaching out to her that wanted to speak with me.
To you?
Yeah.
Not the whole jury, to you. Was there anybody with you at that time?
No, it was
Did
just
she indicate why they wanted to speak with you? Just you?
No.
Did she indicate what reporters?
No.
Did she ever talk to you about doing interviews with the media after that?
No.
But you indicated she brought some cards at some point?
She brought cards in to hand to the jurors.
Before?
After.
After?
The verdict was read.
Cards of media people?
Yes, sir.
Did she tell you she was writing a book?
No.
Did she indicate to you why it might be good for her if you did media interviews?
No.
But she had a conversation with you in the lunchroom of the middle school?
I believe it was the lunchroom. I think the day of the bomb threat.
The day of the bomb threat?
I'm 100% sure she came to me and she told me that in the middle of the trial.
Was there a bailiff with her or just her?
No, it was just her.
Pulled you over and said, hey, I can make you famous, I can put you on TV.
She said she had media that wanted to talk to me. That's what she said.
Okay. I hyperbolize. I apologize, Your Honor.
Yes, sir.
That's all I have.
All right, no further questions, Mr. Harpootlian?
No, Your Honor.
Very good. Thank you very much, ma'am. You are excused. All right, Mr. Harpootlian, that it?
I need to put one matter on the record, Your Honor, and that is it.
All right.
As soon as I'm told what to put on the record.
All right.
You want to put on the record that you're a dipshit? That might help.
Your Honor, earlier today you received a very short affidavit from Juror Z. We'd like to proffer that and make it part of the record.
Right, I did not admit it, but I'll accept a written proffer, and if you would give the thing to me, I saw it on the screen on my law clerk's computer, but I don't have a printed out copy.
We don't either, but would you allow us to do that?
Well, I will allow before I close the record with Ms. Harris, if you can get it to us When can you get it to us?
We could email it this afternoon.
Very well. How about do this? How about email it to Mr. Waters, to me, to Ms. Diaz, and to Ms. Harris, the court reporter. And I will say now that it's offered as a proffer, and I admitted it into evidence.
Yes, ma'am.
All right.
Fair enough. It's like I like that, you know, fair enough. That's perfectly fine. So a proffer is also called an offer of proof, same kind of idea. Basically, it's here's what the witness would testify to if they were allowed to be called. So it's what you do to preserve your record for the Court of Appeals, because the Court of Appeals doesn't know, obviously, what the witnesses would testify to if there's no record. So it's the way you make the record, right? So your witness isn't allowed to be called. So what you do is you do a proffer. And there's a couple ways to go about doing that. You can do it in court with just the judge, depending on what the judge wants to do. Obviously, details depend. But you can do it in court with just the judge. Both lawyers are there, but not the jury, because it's not being offered to the jury. It's being offered for the Court of Appeals benefit. You could do it by an affidavit, which is being done here, right? So that's right? It's like, okay, I will allow it as a proffer. So it's on the record, so the Court of Appeals has it if they care. So, you know, that's right. Good job. Fair.
Your Honor, we referred to earlier on a email to the Japanese television folks. I do have copies of that. I'd like to make that.
And by the way, depending on the situation, it can just be on the attorney's word. That's another way. Again, it's going to be dependent on the court. It's going to be dependent on the situation. But it could just, and also another reason you might do it is because you have to, for some reason, call a witness out of sequence. And you need the information on the record for this witness. And you can't call the other witness first. There's no way to do it. So you could say, like, okay, so I don't know why you wouldn't be able to do it in the right order, but let's say for some reason you have, well, maybe because it's the state's case, or I don't know, but you have a person on the stand and you need to voice authenticate them based on a tape, and it's like you can't get the person who does the voice authentication, so you like play the tape and it's like, you know, objection, authentication. It's like, we proffer that we have a witness who will testify as the authenticity of this based on a voice sample. The judge will be like, okay, you know, because you're representing to the court what will happen, and you know you're putting your balls on the line. I was like, okay, fine. So you want to represent that's what this witness will say? Great. Okay, move on. All right, and so then you can be like, okay, so since this witness will testify to this, what do you have to say about that? Right? So you can do it. It happens. It's fine. So it depends on the judge, depends on what you're trying to do, it depends on a whole bunch of things. But sometimes the attorney can just say, yeah, we'd like to proffer that our witness would say X, Y, Z. And the judge can be like, cool. Sometimes you do it by, you know, calling the witness, deposition, affidavit, entrails, whatever works.
Part of the record.
All right, but hand it up to me and let me see it. And also, of course, to Ms. Waters.
I got law analysis, second win, third win, fourth win, baby. I'm a beast. Don't fuck with me, I'm a beast.
I got two of these, Mr. Harpootlian. I'll give you one back.
You don't want to bang with me. I'm a motherfucking PIMP. Bum 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 bum.
All right.
Well, if the proffer isn't proved, then the judge is going to own your ass. And the judge is going to own your ass.
The hearing before Judge Newman to seal the body cam videos was on May 26, 2023. This email is in July, just to give you the context of
All
what's
right,
going on.
and this is being offered
Yeah.
as a
If the proffer doesn't come through, then you might be looking at a mistrial, plus the judge beating you to death, plus the bar beating you to death. So, don't do that. Don't do that.
after the fact email to Rebecca Hill, and her replies garnered from the emails that were released by Cotton County at a certain point. And it addresses the issue I raised with Ms. Hill relative to the security of sealed records.
Exactly, Your
All
Honor.
right, I'll admit it. Mr. Waters?
As to this specific exhibit, Your Honor?
Yeah.
Remember when we had that little exchange during the Ken Paxton impeachment? Some of you guys weren't there, but there was this whole thing about whether or not certain records, I think there were medical records, were already out in the open or not. And there was basically one of, I'm pretty sure it was was it the prosecution's team? Yeah, it was one of the prosecution's team. And because the defense moved to, the Paxton moved to exclude this evidence on the basis it was medical information, protected medical information. And the prosecution's like, no, it's out in the open. And it's like, okay, I'll defer. And then they renewed the objection. It's like, yeah, we moved to object on the basis it's protected information. And the prosecution said, no, it's all out in the open. And the judge basically said, are you sure? Are you sure it's out in the open? And because that's where you okay, are you sure it's out in the open? And the prosecution attorney is like, yes, I'm sure it's in the open. And the judge is like, okay, based on your representation, I guess I'll admit it. And there's no protective order on it. So, this information is being exposed. So, okay. You put your ass right on the line, big balls. Yeah. Big balls. Yeah. And I commented about this during the Paxton impeachment trial. As if the judge asked me if I'm sure with that kind of tone, I'm not sure what my own name is, man. You better be really fucking sure. You better be unbelievably sure.
Your Honor, we don't have any objection other than the ones we've raised just generally to the testimony. But I have no further objection.
What does it mean to be out in the open? That was already exposed. It's not secret. It's not privileged. The health information or whatever it was already published by the press. So there's no point in keeping it secret because it's already known. There's no point in the secrecy. It's already been exposed. It's in the open. That's what it means. It's already public knowledge. Yeah.
Very good. All right.
And Your Honor, that's all we would have.
All right, hang on. All right, have you got a copy of it there? I got it. This is his next exhibit. Proffer is his one.
Thank you for the $1 super chat. Appreciate that.
Proffer is your exhibit 1, Mr. Harpootlian, and this, which I have admitted, is your exhibit 2.
Thank you, Your Honor.
All right. All right. Now we proceed to closing. You prepared?
Yes, ma'am.
Very good. Mr. Waters.
Thank you, Your Honor. Just to go back and reiterate as to the standard. And ultimately, we've of course argued that the defendant has the burden. We've also discussed that the standard for Your Honor, of course, is first of all, was there any misconduct that occurred? And then regardless of that, whether or not there was any effect on the verdict. And the standard has been expressed in multiple cases is whether the verdict is solely the product of honest deliberation or the product of outside influence. And that inquiry fundamentally, as the court recognized from the very beginning, focuses on the jurors themselves, because it doesn't necessarily matter what was said as much or what was intended or what was inadvertent, even assuming that those existed. What matters is what the jurors heard, what they perceived, and whether or not it had any sort of effect.
Uncivil Law hasn't used the restroom in a while.
Your Honor went through that inquiry with these jurors. 11 of those jurors were clear and unequivocal that there was no effect on their verdict, and also clear and unequivocal that nothing was said that could in any way be inferred as any sort of attempt to influence them. And I think that's very important, Your Honor, because there can be sometimes behind the doors, as we've talked about, I think some of the cases recognize this, that some conversations can go on and things like that can happen, but ultimately, and while I think there were some cases cited in some of the various South Carolina decisions, that it's unrealistic and not surprising to think that sometimes things like that can happen, an untoward comment or something was said. But that was in Aldrich, Your Honor, in the 1999 Supreme Court case. But
you want me to meet your daughter at my alma mater to get a tour? At my alma mater to get a tour? Yeah. Clemson's changed a lot since I was there, but I'll show you as much as I know. Yeah, Clemson's a cool school.
The mere fact that something like that may be stated.
You ate dinner at 7 and then hang out with my son. Yeah, we're on. I think we're on hour 13 now. It's been a long day. It's been a long day of streaming, but you know what makes it all possible? My two turntables and my microphone.
That could be stated in a neutral reason is not enough to undermine the verdict, because the inquiry ultimately boils down to what was it that those jurors heard, and in the end, though, did they listen to the instructions from the trial judge? Did they come to a fair and honest verdict? And, Your Honor, the evidence here is overwhelming, I would say, from the people that matter, and that's those jurors. And that is, there was no effect on the jurors. And you saw every single one of them very clearly and strongly looked you in the eye, all 11 at least, and I'll get to the 12th one in a second, but looked you in the eye and said, no, that didn't happen. No, I didn't hear anything like that. No, there was no effect on our verdict. No, this was our verdict, and it was based solely, which was Your Honor's question, solely on the evidence and the law and the testimony at trial. And I think that carries the day. We have the one juror, and I want to make sure, because I'm about to say the number and I don't want to do that. Let me go back to Juror Z. And let's look at Juror Z and what she said, because Juror Z also said that, yes, I said this was my verdict. I was polled and said this was my verdict. Juror C also said that my verdict was solely based on the evidence and the law of the testimony at trial. Answered question number 2, yes. Absolutely yes. But then goes on after that to say she heard some communications from the clerk, and then says, well, it had an effect on my verdict. Even after she had already answered question number 2, when she said her verdict was based solely on the evidence and the law and the testimony at trial. And beyond that then, Your Honor, I think that it's very telling that the affidavit that was submitted from this particular juror, and we've been pointing this out from the beginning because it's very crucial and very telling, because despite the things that she alleges that happened, even though the other jurors say it didn't, despite the things that she alleges that happened, she says that she voted guilty because she felt pressure from other jurors. Not that her verdict was in any way affected from some supposed external influence. In that affidavit that was filed with the defense motion from day one, that is what she says, that she felt pressure from other jurors. And Your Honor, we've cited the cases over and over again that the internal mechanics of the jury room, the fact that one juror feels pressured by others, as long as there's not violence or things that go beyond the pale, that is not a basis for undermining a verdict. That is part of the deliberative process, and it's expected, and it occurs. But I think it's very telling that we have those conflicting answers. And Your Honor, without waiving any objection to the latest affidavit that we were just discussing from this juror, I think that's very telling. because now we have answer number 3 as it relates to this particular juror. And of course, it is clearly manufactured and rehabilitated, recognized after the fact. She, of course, is, this juror is represented by Joe McCullough. And ultimately, we've got now a 3rd version of events from this very juror. So we have this juror who's given answers all over the place that are inconsistent with 11 other jurors who were very strong and unequivocal that, yes, this was our verdict. It was based solely on the evidence, the law, and the testimony, that there were no communications from Becky Hill that influenced that verdict. And I think ultimately when you look at the case law, in the end, it's up to Your Honor to make that ultimate determination and looking at all that law together. We cited a number of decisions, including as
no, Juror Z wasn't the 4-person. Yeah, apologize. Juror Z was the Juror X was the 4-person.
Perhaps.
Juror X, Mr. X, or Mrs. X, actually. Yeah, Mrs. X was the 4-person.
The law is very clear that it does not recognize that, because what that would do would be to consistently and constantly put every verdict that occurs in any courtroom in this state or in the nation at risk. Jurors don't have to vote in perpetuity. They vote on one day and one day only. And here, Your Honor, the evidence is overwhelming that those jurors' verdict was the product of honest deliberation, and the only bit of contrary evidence to that effect is from a juror who, frankly, not only said that it was purely the result of honest deliberation, but then has answers all over the place. And, Your Honor, I would say that the other 11 jurors are credible, they were strong, they were clear with Your Honor, and I think that ultimately that carries the day. Now, we've had testimony from other people since the jurors were here. We've had testimony, obviously, from Ms. Hill, we've had testimony from Ms. Rhonda, and we've had testimony from this alternate juror. But again, none of that testimony at all goes to what is the ultimate test for Your Honor, and that is whether or not this verdict was the product of honest deliberation. And on that, again, the evidence is overwhelming and strong and clear that it was the product of honest deliberation. It's very interesting as we look at some of the testimony from the other witnesses. And obviously we have Miss Becky, and as Your Honor has pointed out, we're not here to go through some of the issues that have been alleged or are percolating out there. That's not the point of this proceeding here today. But Miss Becky is a court reporter and then became a clerk, and was clear to you that she never made any comment in an attempt to sway the jury one way or the other. We have Ms. Rhonda. And Ms. Rhonda came in and testified, but I would submit to Your Honor that this is kind of a red herring, because what Ms. Rhonda described were conversations that she herself admitted are just the kind of conversations that go on, and that's the reality of it. The conversations that go on among a trial team when we're not in an open court, where we're discussing things, the kind of conversations that go on among court staff behind the doors, those types of conversations go on, but that does not mean, nor does that necessarily indicate that somebody's not going to come out here and do their job fairly and understand the distinction between influencing a jury and not doing that. And one thing that I think is very important is Ms. Rhonda was at that trial more than Ms. Becky was. And she was...
What? Did he mean that the other way around, or did I miss something? Or what are we talking about? What is he? Miss Rhonda was at there more than Miss Becky? What did I miss something? I'm confused. What are we talking about?
Very clear job fairly. And those types of conversations go on, but that does not mean, nor does that necessarily indicate that somebody's not going to come out here and do their job fairly. And understand the distinction between influencing a jury and not doing that. And one thing that I think is very important is Miss Rhonda was at that trial more than Miss Becky was. And
what? Are they about the same? Becky took a week off? Oh, okay. All right. All right. So they're the same. All right. Rhonda missed only 3 days. Becky missed a week. Okay. Fair enough. I stand corrected. Yeah. The Barnesville court was at the trial more days than Becky. Okay. I was confused. I forgot that Becky was, I'm not even sure I knew in the first place, to be honest, that Becky was out a week. Okay. Fair enough. I was just really confused. Okay. Fair enough. Carry on.
she was very clear. And I probably was as repetitive as anyone here today in asking that question over and over again because I didn't want that point to be lost. That Miss Rhonda said, I was there more than anyone else, and I never saw anything or observed anything or had anything happen that would cause me independently to go to Judge Newman, because that's what I would have done, to go to Judge Newman and say, something's not right about this. This needs to be fixed. Something's going on that's improper. And I think that that is an extremely crucial fact because Miss Rhonda admitted and said, of course, as she would, that if something had happened that the judge needed to know about, she would have been the first one to do it. And it never happened. And she was here more than Miss Becky was. It never happened. When we look at the balance of those facts, when we have the clerk of court come in and testify that, you know, maybe I did this or maybe I did that, maybe I plagiarized the book, a portion of it, maybe I did this, maybe I wrote in things in there that are based on community knowledge or newspapers or poetic license or whatever you want to call it. I don't care about the book. And I would submit that Your Honor doesn't need to care about the book either, because the book and what happened with the book afterwards is not what is relevant to the inquiry. But she was...
If the book is not already on the record, I'd just make it a record as the court. I'd just make it a copy of the book, a copy of the record, just for the hell of it. This thing needs to be memorialized. I'm making it a court's exhibit. That's good shit.
Clear that she did not have any attempt to influence that jury. She was clear about that. And Miss Rhonda was clear that she was not aware of anything like that either. And what does that do but corroborate the most important witnesses here? The defense, I think in one of their letters, tried to say that Miss Becky was the...
She didn't plagiarize. She didn't plagiarize. It just had... what's the language of the day? It had significant portions without proper citation. I think it's the proper phraseology these days.
State star witness, and that's not what this inquiry is about. It's not what this inquiry is about at all, because as I've said from day one, if there were not facts to be litigated, if we had not done an investigation and had those 11 jurors say, that didn't happen, there was no effect on our verdict. This was the product of honest deliberation. We would be the first ones here standing here to say that. But what we do know, Your Honor, is that what Miss Becky said and ultimately what Miss Rhonda said corroborates who are the true, if you want to say it, and I'm only using this term because the defense accused us of Miss Becky being our star witness. There are no star witnesses here. This isn't about stars. But what Miss Becky and Miss Rhonda do is corroborate who are the most important witnesses. And that are those jurors. And you have 11 of them strong as a rock saying this verdict was not influenced, nobody tried to influence, and regardless, it was the product of our honest deliberation. And you have one juror who said that too, but then has answers that are all over the place. And if you go back to her original statement, what she says is not external influence anyway. It's not sufficient under the law. So I think that the proof here is overwhelming. I think the proof here corroborates what those jurors say. I think the only juror that we have to contend with, her testimony is compromised. And I'm not saying that that person is in here maliciously lying. I just think that this process is a lot. But it's clear that if there was any attempt to influence this jury, those jurors who sat in that box, every single one of them, you saw them, and we saw them for 6 weeks. They are conscientious. They take their obligations seriously. They were not here to reward friends or punish enemies. They were here to do their job appropriately and fairly. You saw that in their eyes. You saw that in their mannerisms. You saw that in their demeanor. And they were strong and clear that this verdict was fair. Your Honor, we would submit that the motion for new trial be denied.
Mr. Harpootlian.
Mr. Griffin will be arguing.
All right.
It's okay if I stand here, Your Honor? That way I won't be interrupted by Mr. Harpootlian as I'm trying to make my points. Your Honor,
What?
I want to first start with State v. Green because I understand that that's the guidance, that's what we're following here, and reading, excerpts from State v. Green. First, it is absolutely clear in State v. Green that we find ourselves, and the issue is whether there's a defendant's right to a fair and impartial jury under the Sixth Amendment has been violated. Reading from the opinion, it says, in the Sixth Amendment's context, the Supreme Court of the United States has held that, quote, any private communication, contact, or tampering with a jury during a trial about the matter pending before the jury is deemed presumptively prejudicial. Now, Green goes on to say that we are not going to categorically apply the presumption whenever there is a contact with the juror. But the question is it prejudicial? Not whether the verdict would have been different. It is it prejudicial? And I'll keep reading. The court says, we're not persuaded that the Rimmer presumption of prejudice, we're talking about prejudice, not is the verdict different, it was their prejudice, was this tainted process, was it prejudice to the defendant? Was the process prejudicial to the defendant because of extraneous communications? Not whether the verdict would have been different, but whether there's prejudice involved in the process of the trial. The court goes on to say, our unwillingness to categorically apply the Rimmer presumption of prejudice stems from our view that not every inappropriate comment by bailiff to a juror rises to the level of constitutional error. Goes on to say the attempted bribery of the jury in Rimmer conduct which goes to the heart of the merits of the case is a far cry from the circumstances presented in this case. The bailiff's actions here, though improper, did not touch the merits, but only dealt with the procedural question of how the judge might handle a jury impasse that apparently never materialized. The court says, while we decline to adopt the Rimmer presumption of prejudice in every instance of inappropriate bailiff communication to a juror, the occasion of this case presents an opportunity for our clerks of court and circuit judges to ensure that all bailiffs are properly trained. Now, the only thing the Green did was reject the presumption of prejudice in every case. And Your Honor, I just want to preserve for the record that our position is that the comments that you heard in this case go to the merits, go to the heart of the defense. And if you find that those comments were made, and I'm going to establish for the record, we clearly have proven that then we do get the Rimmer presumption. That we do get the Rimmer presumption if we have proven these comments were made. But I'm going to argue that we proved prejudice also in this case. So to start with, let's go to the evidence that was presented since Friday. And Your Honor, we have 12 deliberating jurors. In this case, what you've heard, 3 of the 12 have testified under oath
that they heard Ms. Hill make comments about the case, whether it's, how they categorize it as merits or not. But Juror X on Friday acknowledged that Ms. Hill made a comment about Alex was going to testify, that it was going to be epic or some words like that, and that defendants don't normally testify. That's what Juror X said on Friday. Today, so that's one who says Ms. Hill made a comment about Alex's testimony, how it's going to be a big deal, and defendants don't normally testify. Juror Z today says that first she says Ms. Hill said to watch his actions, to watch him closely, and then she said there are other things that he said I don't remember. And then we were allowed to show her, and with Your Honor, I asked her questions about her affidavit, and she says, confirm what was in her affidavit, that Rebecca Hill told the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also acknowledged, this is a truthful statement, that she instructed the jury to, quote, watch him closely, close quote, immediately before he testified, including look at his actions and look at his movements, which I understand to mean he was guilty. And she also said and confirmed that Ms. Hill said when they began deliberations that this, quote, this shouldn't take us long, close quote, and that if we deliberated past 11 p.m., that we'd be taken to a hotel. Those statements go to the merits. Those statements go to the heart of the defense. Those statements go to what Mr. Murdaugh, his credibility. So that's two deliberating jurors down. The third deliberating juror who testified today is Juror P. And he says, you were asked, Juror P, did Ms. Hill make any comments about the case? And he says, yes. She said the day that Alex was taking the stand, excuse me, Juror P is a he, but he is saying that she, Ms. Hill, said the day Alex was taking the stand, that she, Ms. Hill, made the comment about watch his body language. That's all I recall. So 3 of the 12 deliberating jurors heard Ms. Hill speak about Alex Murdaugh's testimony. 3 of the 12. And then we get the alternate juror came in and basically corroborated what those 3 of the 12 heard. And she had additional things that she had heard, but she corroborated what those 3 of the 12 heard. And then you've got Ms. Hill who gets on the stand and denies it all. And Your Honor, I couldn't agree with you more that you're able to judge the credibility of witnesses. And on this record, there's no way to find Ms. Hill credible. There's no way to credit her statements that she did not make these statements about his testimony. I mean, she crossed herself up as Your Honor is questioning her about the transcript involving the egg lady and how the egg lady learned that there's some Facebook post that was allegedly attributed to her husband. There's no way the egg lady would have known that unless Ms. Hill told her, and that pretty much came out there. I mean, so, and I know this is not a jury argument, but if someone misrepresents a fact to you once, I mean, I don't think you should go back and credit anything beyond that. What we hear from Ms. McElveen is that she heard these almost identical statements from Ms. Hill that Ms. Hill told that 3 of the 12 deliberating jurors heard and the 4th alternate heard. That Ms. McElveen heard her make very similar statements about the defense's case, about Mr. Murdaugh's testimony. So you've got to put Ms. McElveen's testimony in our category. And Ms. Hill gets up there and says, never drove a juror home. Ms. McElveen's got no dog in this fight. And she says, she goes to court one day, she hears that Ms. Hill took a juror home the night before and went and talked to her and said, you can't do that. And Ms. Hill says, I didn't talk to her about the case. Well, she gets on the stand under oath here and tells you, I never took a juror home. I mean, it's totally inconsistent. And for her to say, I never made these statements, she tried, I mean, she kind of gave herself a little wiggle room at the end. Well, when they were lining up, I may have said he's going to testify today or something, but these jurors heard this information. And the question under Green and Rimmer, was it prejudicial? Now, what we got from Juror Z today, the question was, did these comments influence your verdict? And Juror Z says, yes. Then you ask, how? And Juror Z says, to me, it felt like she made it seem like he was already guilty. Then you said, did it affect your finding of guilt in this case? And the answer was yes. And so that's prejudice, Your Honor. That is prejudice from one of the 12 deliberating jurors. Was your verdict influenced by what Ms. Hill said? And good grief, how could it not be? How could it not be? And to ask all these other jurors who heard the same thing, was it influenced? It is really an impossible task, because you don't know what's influencing a jury, and frankly, that's why the Rimmer presumption is there. But let's try to sort this out. And Your Honor, I think it was a State v. Kelly case where the deputies went out and they were investigating the jurors' beliefs on the death penalty, and there was really no testimony about did that affect your verdict, but it was just so wrong. The conduct was so wrongful that the Supreme Court says that's prejudicial, and we're granting a new trial. I mean, this is prejudice, and this has been proven. I mean, Ms. Hill is not credible. Ms. Hill is not credible. And she's talking about her book, talking about taking literary license to lie. Literary license to lie is that's what she thinks a literary license is. So her testimony should not be credited. We have proven, we have met our burden of proving that there was extraneous contact with these jurors. 3 of the 12 deliberating jurors have testified to that. 1 of the 12 says it influenced my verdict. How is that not prejudice? And that's all we have to prove. We believe, for the record, there is a presumption of prejudice that they have to overcome, but we have proven prejudice. And Your Honor, we respectfully request that a new trial should be granted based on the record developed today. Thank you.
All right. The arguments are closed. I will take until 5 of the hour to examine my notes, and then I will come and make a ruling from the bench on this matter. Court will be at ease.
And then she comes back, let's see. She comes back in 20 minutes or so. It's pretty fast. All right, guys, we've reached the end, so we're done here for the day. I don't think the judge made the wrong ruling based on the law as she understands it. Whether she's wrong on the law, I don't know, and there's no chance on this world. I'm looking it up now because I'm beat and I'm tired. And there's no way I'm anywhere near close enough to being in form enough to go critiquing a Supreme Court judge of the state based on state law. I'm much more familiar with federal law, so I can do federal law much faster on a pinch. But state law, terms of state law specific, and that's not happening. So assuming she's right on the law, I think she's right in her conclusion. And and in large part because Dick Poot completely fucked it up and fucked it up hard. He fucked it up so incredibly hard. It's unbelievable how much he fucked it up. I hope he understands how much he fucked it up. It's pretty bad. This is pretty bad. This is incredibly bad. This is all the bad. Dick Poot fucked this up so hard. Complete unforced error. Destroys his appeal. What a fool. So I suppose we're back to appeal on normal grounds. So we're back to appeal on our normal issues, and I suppose this comes along for the ride too. Good luck. And the only thing we have really to fight with is 403 on the state level, basically for the financial stuff being unduly prejudicial, is all we have to work with. I'll assume the South Carolina Chief Justice knows South Carolina law, so I imagine the South Carolina Supreme Court doesn't overrule it, and then the only hope left is the Fourth Circuit Court of Appeals on the issue of the federal law. So we'll try that, I guess, or I suppose the U.S. Supreme Court. Yeah. She made the wrong ruling on the law. No, on the facts, nah. Vacillating, too unclear. I think the judge's finding is not clear. Is not clear error, or abuse of discretion. It's like, yeah, the juror said that, and then she said some other things, and here's a third thing she said. So I think finding the juror to be, finding Juror Z to be, what'd she say? Indeterminate or inconclusive or whatever. Yeah, I think that's a reasonable conclusion. So yeah, I know it only takes one juror. I know the law. Don't hate me. I know the law. I know it only takes one. But the one is insufficiently reliable because their testimony is muddled. And the judge, as the finder of fact, is well within her rights to find the testimony muddled, because she's the finder of fact. So she's like, well, this juror's testimony is muddled. That's a finding of fact. So, good luck, Legal advice is thought differently. Well, there's a shocker. There's a shocker. Different lawyers disagreeing. Wow, what are the odds? What are the odds? A different lawyer looking at this disagrees with me. Tell me a different story. Tell me a different story. So, okay, legal advice disagrees with me. Wow, amazing. Unbelievable. Who would have thought it, right? Who would have thought it? All right, I'm going to bed. Uncivil Laws beat. Tell Jeff I said he was wrong. Tell Jeff I said he was wrong. And he doesn't understand the law right. And he's wrong, and he's a bad lawyer who misunderstands things, and he should apologize to his entire chat for putting them on the primrose path. Tell Jeff that'd be good. Also make it clear with the sarcasm that I don't really mean it, please, so we don't start a war between me and another creator. Let's try not to start a war. I've been on civil law until friends, I hope all's well. Cheers, my friends, and goodbye.